camera. Chiefs kindly. A criminal appeal. The dismissed for non-causes, senior tomorrow.
But appeal matter, my lord. From 2022, it is not got listed only, my lord.
Madam, will you on the
Next.
List number 2. Any adjournments? Page number.
My lord, serial number 11, my lords. I appear for the
Page,
petitioner, my lord.
page.
List number.
Serial number 11, my lord.
List number 2.
List number 2. My lord, the count
You are
on- for the petitioner, my lord.
B group matter.
Suffering from viral fever in 2 days, after 2 days. my lord.
Counsel for the petitioner prays for time.
Lord, list number 10, list number 2, serial number 10, my lord, appear for the respondent in this case, respondent number 2 in this case, my lord. So due to some slight inconvenience for my senior, my lord, he won't be available to kindly have this matter after 2 days.
Matter, all these
My lord, we have informed the opposite advocate also, my lord.
may inform, but what about the court work?
These, my on
Hmm.
2 days, 2 days.
Counsel for the respondent number 1, respondent number 2 prays for time. He undertakes to address his argument on the next date of hearing without fail. Madlindo.
Interim order ಇದೆ ಇದರಲ್ಲಿ. We have no objection for extension of interim order.
Serial number 9, my lord.
Huh?
Serial number 9. The Andhra card advocate is under operation, my lord.
All the B group matter you are seeking.
ಇಲ್ಲ, ಅವ್ರ
time, one
operation
after the
ಆಗಿದೆ.
other.
ಆಪರೇಷನ್ ಆಗಿದೆ, ನಾನೇ ಅವ್ರ ಹಾಸ್ಪಿಟ್ಲಿಗೆ ಹೋಗಿದ್ದೆ. ನನಗೆ ಏನಾದ್ರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಳ್ಳೋಣ ಅಂತ ಅವ್ರ ಫ್ಯಾಮಿಲಿ ಅವರು ಮಾತಾಡಕ್ ಆಗೋದಿಲ್ಲ ಅಂತ.
Who is in the hospital?
ಮುಸ್ತಾಕ್ ಅಹಮದ್. Serial number 9.
Order sheet to counsel for the petition, proxy counsel. for
Since
the
from last
petitioner.
1 year he is in the hospital. ma'am.
Then what should happen to the writ petition?
Hello?
What should happen to the writ petition?
ಅಲ್ಲ ಇನ್ನೊಂದು 10-15 days ಅಲ್ಲಿ ರಿಕವರ್ ಆಗ್ತಾ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಸರ್.
Sir,
ನನ್-
1
ನನ್ಗೆ
year
ಮಾ-
ಇಂದ ಅವ್ರು ಇದಾರೆ ಅಂತಂದ್ರೆ.
ಸಾರಿ 1 month ಮೇಲೆ.
If you cannot make alternative arrangement.
1 month ಮೇಲೆ. ಸಾರಿ 1 month, ಸಾರಿ. ಬೈ ಓವರ್ಸೈಟ್ ಇಟ್ಸ್ ಕಮ್ ಇನ್ ಮೌತ್. ಒಂದು ತಿಂಗಳ ಅನ್ನಕ್ಕೆ ಹೋಗಿ 1 ವರ್ಷ ಅಂದ್ಬಿಟ್ಟು ಸಾರಿ ಮೇಲೆ.
Anything we will say, ಏನು ಮಾಡು. Praise for time.
2 weeks time.
He submits that the counsel for the petitioner will undertakes to address his argument on the next date of hearing.
Interim order may kindly be extended.
Commission is based on
2 weeks.
record. List finally as a last chance, subject to
Interim
the
order may
condition that the counsel for the petitioner should go on with the matter. Interim order is extended till next date of hearing. Yes, next.
Your Lordship, list 2, serial number 7.
Oh, first serial number 1.
Your Lordship,
Compliance.
Yes. Yes, who is this?
list 2, serial number 7. I appear for respondent 2, my lord. We have to seek certain documents from the party.
That is for interlocutory, hearing of interlocutory.
It's for IA for vacating stay, my lord.
Yes.
We
You
don't
filed
have,
that application?
we have filed. We don't have the supporting documents, my lord.
Then
I
why
pay
that
for 2
application was
weeks.
filed?
That is filed in the year 23.
No, wait for some time, wait for some. Yes, list number 1, serial number 1.
Like 2 weeks time to do compliance.
Counsel for the petitioner prays for time. Next.
List number 1, serial number 2, Girisha Jetty.
Counsel for the petitioner is absent or representation. Next.
Non-compliance for office objection for 3rd time, serial number 3, Channakeshwa BS.
Appearing for petitioner in this matter, my lords. So lords, the petition may be dismissed as withdrawn, my lords, because charge sheet has been filed.
Counsel for the petitioner submits that the charge sheet is already filed by the investigating officer, hence the petition is rendered infructuous. Commission is placed on record, petition is dismissed as well. Same is rendered infructuous. Yes. 4.
Serial number 4, Mahabaleshwar.
My lords, in this, B report as filed, my lords. B report as filed, my lords.
Learned SCGP submits that the investigating officer has filed the B report and therefore the petition is rendered infructuous. Submission is placed on record, petition is dismissed as the same is rendered infructuous. Next.
Serial number 5, Mallikarjuna Swamy.
absent, no representation.
Serial number 6, M.N. Prabhakar.
That's in this matter, my lords, charges framed, my lords, and it has posted for evidence, my lords.
Then at counsel for the petitioner is absent, no representation. Then at CCP submits that the trial court has already framed charge and the matter is fixed for a trial. The petition is of the year 2020 till the office objections are not complied with. Hence petition is dismissed. Next.
Serial number 7, Venkataswamy Gowda.
ಏನು ಫೈನಲ್ ಅಂತ ಏನಾದ್ರು ಇದೆಯಾ? ಸ್ವಲ್ಪ the petitioner is absent, no representation in this. ಇದೆಲ್ಲ ಫೈನಲ್ ಇಲ್ಲ. ಯಾವುದು? Serial number 5 and 7. Yes.
Serial number 8, Lankesh L.
ಕೊಡಿ. Pass over.
Serial number 9, Krishnamurthy.
Lords, in this matter also charges, charge framed, my lords, and that's
Charge.
framed, my lords, and it has posted for trial, my lords.
Order sheet ಕೊಡಿ. Counsel for the petitioner is absent, no representation. The order sheet dated 13/8/2024 reads as under, in spite of that, there is no progress in the matter. Next. Then at HCCP submits that the trial court has already framed charges. The matter is fixed for trial. I do not find any reason to adjourn the matter. Petition dismissed. Yes.
Serial number 10,
My lordship, representing the petitioner, my lordship, in 1 week time may be granted, my lordship, furnish the process and
Why, sir? 2018 matter till you
Matter
have
also
not furnished
charges
the PF.
no, my lordship, already 2 times I furnished the process, my lordship.
What is the stage before the trial court?
Trial court, my lordship, in the evidence stage only, madam, my lordship.
Then why this petition is to be kept pending? You go
One-
before the trial court and contest.
No, my lordship, 1 week.
No purpose would be served. When
My lordship-
charges are already framed and the matter is set on for trial.
My lordship, here in, we question the charge sheet, my lordship. Here in, we just,
Maybe. The trial court has already framed charges.
yes, my lordship, but before evidence start, not,
It
Please
has,
come and
posted
address
for
the
evidence, and then it has jumped the stage of evidence, my lords. It has posted for hearing for the date of 29/2018, my lords.
Noted. Very, pass over. Next.
serial number 11, Francis Xavier.
ಏನ್ ಕೊಡಿ. For petitioner. Order sheet ಮಾತ್ರ ಕೊಡ್ಬೇಕು. Then counsel for the petitioner is absent, no representation. Order sheet dated 18/4/2024 reads as under. In spite of that, there is no progress in the matter. Petition is of the year 2020. Till date. The PF for issuance of notice to respondent number 2 is not furnished. Given the acknowledgement for having served the copy of the note, in the counsel for the respondent is not furnished. It appears the petitioner is not interested in prosecuting the petition dismissal. Next.
Serial number 12, Subhash Reddy.
Petitioner in this case, week time may be granted, the process and document for the
Kodi, order sheet. Why you are not paying the PF?
payment.
Mechanically, you are seeking time.
Today we pay them.
So the emergent notice you have taken. Till date, you have not paid the PF.
Put them pay.
Pass over. Pay it,
Serial
pay the
number,
PF.
serial number 13, Sudarshan.
Pass over.
Serial number 14, Surendra Kumar.
Pass over.
Serial number 15, Srinivas Murthy.
Pass over.
Serial number 16, Venugopal.
I appear for this now. R2 is the state, my lord, Tahsildar. My learned counsel may be directed to take notice.
R1 is
R1 is the state.
Hmm.
R2 is the Tahsildar who is the complainant.
ನೋಡಿ verify ಮಾಡಿ. Petition ನೋಡ್ರಿ R2 ಯಾರಿದ್ದಾರೆ? R2 HCGP to take notice of respondent number 2. Just for next.
Interim order.
Interim order is extended. Next.
Serial number 17, Ajay.
I'm for the petitioner in this case, my lordship. I request for 2 days time, my lordship. I'll take steps, my lord.
I'll pass over the matter. Please take the steps.
Much obliged, my lord. I'll do it.
Pass over.
List number 2, serial number 1, SPP.
Let's, yeah.
For respondent, my lords.
Need to file an police report, my lords. Kindly pass over, my lords. File an.
What happened to the NBW?
My lords, the accused is taken to the custody. my lords.
He is in custody.
Yes,
NBW is
since 2
executed.
days.
Where is the report?
Kindly pass over, my lords.
Pass over.
This one report.
Serial number 2, Sunil, petitioner.
Put it order sheet. Office objections are not yet complete and complied. Order C at 20. Court note ಯಾವಾಗ ಆಗಿದೆ? Issue ಆಗ್ಲಿಲ್ವಾ court notice? So
Serial number 3, Kempraju.
ಕೊಡಿ. Counsel for the petitioner is absent, no representation. Has filed the memo. Memo ಇಲ್ಲಿ. Seeking permission to retire from the case. Has produced the copy of the wakalat. To contend that NOC wakalat is already given to the party. Memo is accepted. Is permitted to return from the case. Petitioner is absent. Petition is of the year 2020. Office objections are not yet complied. The case petitioner is not interested in prosecuting the petition. Petition dismissed. Next.
Serial number 4, Anand Mutalli.
And so the petitioner in this. My lord, the second petitioner, the complainant, my lord, has passed away. I have placed his death certificate on record.
Counsel for the petitioner filed a memo quoting the death of respondent number 2 along with the death certificate. When he died,
My lord, he passed away on 4th September 2019 itself, my lord.
stated that the respondent number 2 had died on 4th
4th
September
September 2019.
19, as petition against respondent number 2 is dismissed as abated. IA1 ಏನದು? IA1 of 2023 ಏನದು? What is this IA1 of 2023?
My lord, the IA was filed, my lord, for vacating the interim order. I have not filed that IA. That copy is not served on me.
Who filed that?
Hmm?
So nobody represented the respondent. Who filed the application? State has filed.
My lord, it appears that the state has filed the IA for vacating the stay.
Yes. You have no idea.
That's
You are keeping quiet. We are asking who has filed the application. What is this IA?
Is that my lord's writ petition?
You should be quick, madam. You should know. You are the applicant.
Please, my lords. Kindly pass your minutes. I'll get.
You don't have the file?
That's having 5 minutes. Morning.
We have not yet opened.
Morning I
You are
received.
waiting for the auspicious time.
Morning received.
Why don't you come prepared? Every day I am asking you.
Thing is that my lord's writ petition was handling by colleagues, my lords. Today without.
Where are they?
Due to some
I will ask SPP to come here.
due to some inconvenience, my lords.
No, no, no. I am not here
They
to.
are they are on leave, my lords.
Please ask your SPP to come.
Please kindly pass on, my lords. I'll go through.
My lord, in the light of the demise of, my lord, the complainant, section 279, my lord, may be applicable.
Hmm?
The complainant, my lord, has passed away.
Hmm.
This court, my lord, had granted a stay against the investigation. The complaint, my lord, was for criminal intimidation and under the Atrocities Act. There are civil disputes going on between the petitioners and the second respondent.
Yes,
In the light of that, my lord, a stay was granted by this court against the investigation.
yes,
Now, my lord, the complainant himself has passed away.
yes.
Therefore, my lord, the section 279, my lord, of the BNS may be applicable.
What does it say?
My lord, non-appearance or death of complainant. Summons has been issued on complaint and on the day appointed for appearance of the accused, or on any day subsequent thereto to which the hearing may be adjourned. The complainant does not appear. The magistrate shall give 30 days time to the complainant to be present.
Magistrate, you go before the
That's
magistrate.
before the
I will dismiss-
magistrate. I would only request, my lord, that there was a interim order that was granted for protection. Lord, that may be continued, and I may be,
Before the
I
magistrate.
will go before the magistrate, my lord, but until such time, my lord,
Petition is,
my lord, also may I submit this, my lord, if I could take my lord through the annexes which is filed along with this petition.
sir, that is to be made. You have to make submission before the magistrate. It's not before this court.
But until such time, my lord, that the interim protection may be continued, my lord.
You go before that. Yenaithu? Against respondent number 2 is dismissed as awaited. In view of dismissal of the petition against respondent number 2 as awaited, the petition also does not survive for consideration. This petition. The petitioner is at liberty to go before the learned magistrate and seek necessary orders. Yes, next, you are at liberty to move the magistrate.
Grateful.
Serial number 5, Harshit V.
Petitions. Copy is not served on.
IA1 of 2023 filed by learned HCGP for respondent, copy not served. Same thing. Pass over.
Serial number 6, Neeralagi Jeevan Babu.
Your Lordship, I am appearing on behalf of the petitioner, Your Lordship. Your Lordship, the case was dismissed for non-compliance of office objection. But submit that only one complaint regarding the age of the respondent.
Then it is already dismissed.
So we had filed an IA regarding this. It was listed on previous Tuesday, Your Lordship. The counsel was held up in the other court, Your Lordship. He could not appear.
That application is also dismissed.
So we are filing another IA, Your Lordship. Your Lordship, the counsel is
That cannot be the ground. Is it the ground?
No, Your Lordship, Tuesday.
Because the counsel is held up in the other court. Is it a valid ground?
No, I apologize, Your Lordship. But it was a tax day, Your Lordship.
Will not help you in any manner. No.
The counsel is Your Lordship, please, I'll make a submission, Your Lordship. The council is a GST panel advocate, Your Lordship.
But is there any
Your
relaxation?
Lordship, the Tuesdays are tax matters, tax day in the quota 11, Your Lordship.
Maybe that cannot be the ground. No, pass over, next.
Much obliged.
Serial number 7, P. Siddhaya.
Respondent number 2, my lord.
Counsel for the petitioner is absent, no representation. Counsel for respondent number 2 is present. We submit that IA 1 of 2023 is filed seeking vacating of the stay. The petition is of the year 2020. Sorry, 2020. The petitioner is enjoying the grant, the order of interim order of stay, but is not diligent in prosecuting the petition. Hence, interim order is not extended. Accordingly, IA 1 of 2023 is disposed of. List for next stage again. Next.
Serial number 8.
Kindly pass for the
Okay.
matter, my lordship. Senior is held up in order
For what? What purpose?
to hear on.
IA 1 is filed by the respondent, is it?
I filed, Your Lordship.
You filed it. Yes,
Senior, ಪಕ್ಕದ ಕೋಟಲ್ಲಿ ಇದ್ದಾರೆ.
pass over,
Serial
Pass,
number,
Lordship.
pass
Next-
over.
Next week, Your Lordship. Some convenience in the afternoon.
Instead of application, why don't you argue on merits, both of
That's
you?
why, ಅದಕ್ಕೇನೆ.
Senior,
Argue on merits.
argue on merit.
Learned counsel for the petitioner undertakes to address his argument on merits on the next date of hearing. Instead of arguing on IA 1 of 2023, learned counsel for respondent number 9.
9, I am for 9.
You filed the application.
Yeah, exactly, Your Lordship.
Respondent number 9 who filed the application IA 1 of 2023 concedes for the same. Hence, both the learned counsel are directed to address their arguments on merits on the next date of hearing.
I'm appearing for respondent number 3, my lords.
Huh?
Respondent number 3, I'm appearing.
You also get ready
Please,
to
madam.
address the argument on
Please,
merits, not on
please.
application.
Please, my lords.
Next,
serial number 9 to 11, Arjun.
hence IA 1 of 2023. stands
Serial number
disposed of.
12,
Much obliged, my lord.
Serial number 12.
12, Satish K.
My lords, kindly pass over. Senior counsel is engaged.
Better.
Pass over.
Grateful, my lords.
Serial number 13, Pushpalata.
Hardship.
ಬ್ರದರ್ ಎಕ್ಸ್ಪೈರ್ ಆಗ್ತಾವೆ.
ನೀವು ಯಾರು?
ದೇವರಾಜ್
ದೇವರಾಜ್. Counsel for the appellant is absent, no representation. Counsel for respondent is also absent. Office note discloses that the bailable warrant issued against respondent is executed. Respondent is present before the court and submits that there is a bereavement in the family of his counsel and prays for time. He undertakes to make necessary arrangement to address the arguments on the next date of hearing. List finally as a last chance. Next date of hearing, ನಿಮ್ಮ ವಕೀಲರು ಬರಬೇಕು, ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಡ್ರೆಸ್ ಆಗ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗಿಗೆ ನಿಮ್ಮ ವಕೀಲರು ಬಂದು ಆರ್ಗ್ಯೂ ಮಾಡ್ಬೇಕು, ಇಲ್ಲಾಂದ್ರೆ ನಿಮ್ಮ ಅಗೇನೆಸ್ಟ್ ಹೋಗುತ್ತೆ. ಎಸ್, ಅವರಿಗೆ ಡೇಟ್ ಹೇಳ್ಬಿಡಿ. ನೆಕ್ಸ್ಟ್
Serial number 14, B. Ramesh.
ಕೊಡಿ. So for the petitioner is absent, no representation. The petitioner is enjoying the order of interim stay. but not. The petition is of the year 2018. Petitioner is enjoying the interim order of stay, but he is not interested in prosecuting the petition. Hence, interim order granted earlier is not extended. List finally as allotments.
Serial number 15, Harish Kumar.
Same. Petition is of the year. Absent.
Serial 58, we pass.
15. Pass over.
Serial number 16, Basavaraju.
Petitioner, rest for time 1 week, my lord.
No, sir.
Vehicle model.
Please go on with the matter. You are Mr. Basuraju.
Civil portal is there, madam.
Or earlier, late. I will dismiss this.
Next week, till Monday.
No, pass over. Please ask him to go.
Serial number 17, Harish Kumar MS.
Happy for the petitioner's counsel.
Yes.
My lord, the petitioner is my lord, the secretary of a housing society.
Petitioner is?
The secretary of a housing society.
Hmm.
My lord, he is an employee. He is not elected under the Cooperative Society Act. He is an employee, not a, my lord, in the management committee. Only he, my lord, implements the whatever the, my lord, the board of directors.
What is his designation?
He is a secretary.
Secretary.
Now they are called, my lord, executive officer.
He is representing the society.
But my lord, he has no power to take, my lord, any action, whatever the, my lord, board of directors. And
He is accused number 1.
he is accused number 1. He is accused.
Sole accused.
Sole accused. My lord, the second respondent is the, my lord, the complainant, who is the associate member of a society. Madam, there are two types of members. One is the regular members who have paid the entire amount towards the value of the site. And the associate member is a member who has given the formal amount. And he has been registered if after the allotting all the sites, if any of the sites are remaining, then the preference will be given to the associate member. So he has. Now the second respondent is the son-in-law of one Mr. Ramakrishna, whose lands have been, whose lands have been acquired by the society. Now he father-in-law died. Now after the society had taken a decision to the effect, apart from paying the compensation, but all the members who have been all the landowners whose lands have been acquired, they have to be paid 10 lakh rupees ex gratia payment. That is the resolution he himself has produced in the along with
they are not entitled for site.
My lord, the site has been given. Apart from that, my lord, the ex gratia amount is paid 10 lakh rupees per acre.
Respondent number 2 is the owner of the.
No, he's not the owner. His father-in-law was the owner.
He was allotted with the site.
My lord, that is not in question. That is, were not, site has already been allotted to all the owners. depending upon the, my lord, the nature of the land. My lord, now he has produced the, my lord, the resolution which has been passed by the, my lord, the society to the effect each of the landowners will be paid 10 lakh rupees compensation apart from the ex gratia payment, apart from the, my lord, the compensation paid to the, my lord, kindly take, my lord, the page number 192.
No.
My lord, the
Page number?
192 of the statement of objection. So, sorry, my lord. This is the, my lord, I have, along with the memo, I have produced certain documents. On, my lord, the 1st April 2024.
One minute, let me know. What is the allegation?
No, I will come. Allegation is, my lord, there are number of allegation. Now, this background, my lord, lordship got it 192 page, my lord.
No, let me see the FIR, the gist of FIR.
No, I will, there are number of this one. I will read them all the FIR also. I want to this one. There is a resolution to pay, my lord, the 10 lakh rupees apart from the, my lord, the compensation. That is the, my lord, the annexure. I produced the document, my lord, the document number 2. That is, my lord, 24/7/2011.
The allegation is that
I will come to the allegation.
Allotment of sites to a fictitious person in the
My
name
lord,
of fictitious person.
Yes, I will. I'm not concerned with the allotment. My lord, he became secretary. By that time, my lord, almost all sites have been allotted prior to 2016.
That
But
is why,
section 64 inquiry was held on the same allegation.
before going to the merits of the case, we should understand what is the allegation.
No, I will
Then
come
only
to.
will be in a
No,
position.
What is the motive behind the filing complaint is?
Let us come to the motive later.
Yes.
What is the allegation first?
Allegation first, my lord, kindly, my lord,
You please come to page number 13.
page number 14 is the complaint.
Gist of complaint is in FIR, column number 12.
14, my lord, the actual complaint. Gist is, my lord, page number 30.
That is sufficient for the present.
My lord, ಈ ಕೇಸಿನ ಸಾರಾಂಶ ಏನೆಂದರೆ ಗೃಹ ನಿರ್ಮಾಣ ಸಹಕಾರ ಸಂಘದ ಕಾರ್ಯದರ್ಶಿಯಾದ ಪ್ರತಾಪ್ ರಾಥೋಡ್ ದಿನಾಂಕ 8/8/10 ನಡುವೆ ವಾರ್ಷಿಕ ಸಭಾನ NT ಹೌಸ್ ಸಹಕಾರ ಸಂಘ ಸ್ವಾಧೀನಗೊಂಡ ಕೊಡಗೇಹಳ್ಳಿ ಸರ್ವೆ ನಂಬರ್ 64B/6B ಜಮೀನಿಗೆ ಹೆಚ್ಚುವರಿ 10 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡುವ ತೀರ್ಮಾನಿಸಿದ್ದು ಸದರಿ ಆರೋಪಿಯು ಹಿಂದೆ ನಿವೇಶನ ಕೊಡಿಸುವುದಾಗಿ ಹೇಳಿ ಪಡೆದಿದ್ದ 9 ಲಕ್ಷ ಚೆಕ್ ಮೂಲಕ ಮಂಜುಳಾ ಎಂಬರಿಗೆ ವಾಪಸ್ ನೀಡಿದ್ದು ಸಂಘದ ಓಚರ್ನಲ್ಲಿ ಆರೋಪಿ ಸಂಘದ ಪರಿಹಾರ ಹಣವೆಂಬ ನಂಬಿಸಿ ವಂಚಿಸುತ್ತಾರೆ. ಹಾಗೂ ಓಚರ್ನಲ್ಲಿ 5,50,000 ಮೊದಲು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಆರೋಪಿಯು ರಾಜೀವ್ ಗಾಂಧಿಯ 2ನೇ ಹಂತದಲ್ಲಿ 13 ನಿವೇಶನ, 1ನೇ ಹಂತದ 7 ನಿವೇಶನಗಳು ಅಕ್ರಮವಾಗಿ ಕುಟುಂಬದವರಿಗೆ ಮಾಡಿರುತ್ತಾರೆ. ಹಾಗೂ ಸದರಿ ಆರೋಪಿಯು ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲೆಯ ಹರಿನಾ ಡೆವಲಪ್ ಜೊತೆ ಕೈಗೂಡಿಸಿ ಕಾನೂನು ತೊಡಕಿನ ನಿವೇಶನ ಖರೀದಿಸಿ 15 ಕೋಟಿಗಳನ್ನು ಅಸಹಿರುತ್ತಾರೆ. ಹಾಗೂ ಸದರಿ ಆರೋಪಿಯು ಆಡಳಿತ ಮಂಡಪ ಪಡೆಯದೆ ಅಧಿಕಾರಿಗಳು 23 ನಿವೇಶನಗಳನ್ನು ರಾಜೀವ್ ಗಾಂಧಿ 2ನೇ ನಿವೇಶನದಲ್ಲಿ 898 ಬಿನ್ ಅಪ್ಪಣೆ 60 ಹೆಸರನ್ನು ಸೃಷ್ಟಿ ಮಾಡಿಸಿಕೊಂಡು ತಪ್ಪ ವಿಳಾಸವನ್ನು ಸಂಗಿಸಿ ಸಂಘದ ಮೆಂಬರ್ ಅಲ್ಲಿವರೆಗೆ 4/7/13 ನೋಂದಣಿ ಮಾಡಿಕೊಟ್ಟಿರುತ್ತಾರೆ. ಸದರಿ ಆರೋಪಿಯು 20 ವರ್ಷದಿಂದ ಕರೆದು ಸುಮಾರು 300 ಕೋಟಿ ದುರ್ಬಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಮಾನ್ಯ ACP ಯಲಹಂಕ ದೂರು ಕಾಣುತ್ತಾರೆ. This is the allegation FIR. Then we will not the next with them, my lord, the complaint.
Yes.
My lord, kindly, my lord, read the complaint. Next page, my lord, page
Yes.
number 14. My lord, ನಾನು 2011ರಿಂದಲೂ ಸಂಘದಲ್ಲಿ ನಡೆದಿರುವ ಅಕ್ರಮ ಅವ್ಯವಹಾರ ಹಣ ದುರುಪಯೋಗ ಬಗ್ಗೆ ಹೋರಾಟ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿದ್ದೇನೆ. ನನ್ನ ಹೋರಾಟದ ಭಾಗವಾಗಿ ಅನುಬಂಧ 17/1, 17/2, 17/4 ಆದೇಶದಲ್ಲಿ ಸ್ಪಷ್ಟಿಸಿದ ಕಲಂ 64 ವಿಚಾರಣೆ ನಡೆದಿರುತ್ತದೆ. ಮಲ್ನಾಡಿ ಈ ವಿಚಾರಣೆಯಿಂದ ಸದರಿ ಸಂಘದ ಕಾರ್ಯದರ್ಶಿ ಪ್ರತಾಪ್ ರಾಠೋಡ್ ನನ್ನನ್ನು ಹೋರಾಟ ಹತ್ತಿಕ್ಕಲು ಸಂಚಿಸಿ ರೂಪಿಸಿಕೊಂಡು ಅನೇಕ ವಂಚನೆಗಳನ್ನು ಸ್ಪಷ್ಟಿ ಮಾಡುತ್ತಾ ಇದರ ಪ್ರತಿಬಿಂಬವಾಗಿ ಕೆಲವು ಹಗರಣವನ್ನು ಮಾಡುತ್ತಾರೆ. ಮಲ್ನಾಡಿ he says there was a inquiry has been initiated under 64 of the Cooperative Societies Act. Pursuant to the, he gives a number.
Yes.
Yes. My lord, the first allegation is ದಿವಂಗತ ಕೃಷ್ಣಪ್ಪ ಮಾಜಿ ಚೇರ್ಮನ್ ಧರ್ಮಪತ್ನಿ ವೆಂಕಟಲಕ್ಷ್ಮಿ ಅವರು ಕೊಡಗೇಹಳ್ಳಿ 6-4B-65 ಬಂಟು ಜಮೀನು 1 ಎಕರೆ 13 ಗುಂಟೆ ಜಮೀನು ಇಂಟಿಯ ಗ್ರಾಮ ಸಂಘಕ್ಕೆ ಭೂಸ್ವಾಧೀನಗೊಂಡು 8/8/10 29ನೇ ಮಹಾಸಭೆಯಲ್ಲಿ ಕೈಗೊಂಡ 11/11ರಲ್ಲಿ 30ನೇ ವಾರ್ಷಿಕ ಸಭೆಯಲ್ಲಿ ನಡೆಯುವ ದಾಖಲೆ ರೀತಿ 10 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ಹೆಚ್ಚುವರಿ ಪರವಾಗಿ ಕೊಡುವಂತೆ ತೀರ್ಮಾನಿಸಲಾಗಿತ್ತು. ಆಮೇಲೆ ಅಡ್ಮಿಟ್ಸ್ ಅಂದರೆ ಶ್ರೀಮತಿ ಲಕ್ಷ್ಮಮ್ಮ ಅವರು 13,500,000 ಕೊಡಲು ಕೋರಿ ಸಂಘಕ್ಕೆ ಅವರು ಮನವಿಯನ್ನು ಮುದ್ದಾಂ ಸಲ್ಲಿಸಿ ಸಂಘದಿಂದ ಸ್ವೀಕರಿಸುತ್ತಾರೆ. ಸದ್ವಿಯ ಮನವಿ ಅನುಬಂಧ 1-2 ಲಗತ್ತಿಸುತ್ತದೆ. ಆದರೆ ಸಂಘದಿಂದ ಇದುವರೆಗೆ ವೆಂಕಟಲಕ್ಷ್ಮಮ್ಮ ಅವರಿಗೆ ಈ ದಿನದ ಯಾವುದೇ ಮರುಪತ್ರ ಬಂದಿರುವುದಿಲ್ಲ, ಸ್ವೀಕರಿಸಲುವುದಿಲ್ಲ. ಮಾನ್ಯ ಸಹಾಯಕ ಪೊಲೀಸ್ ಆಯುಕ್ತ ಶ್ರೇಯಾಂಕ ನಂಬರ್ ಪ್ರತಾಪ್ ರಾವ್ ಸಂಘದ ಪತ್ರ ಪತ್ರಗಳನ್ನು ಲಘುತಗಳನ್ನು ಸೇರಿಸಿ ಅಂಚೆ ಮೂಲಕ ಕಳಿಸಿದ ಸದರಿ ಪತ್ರ ಲಗತ್ತಿಸಿದೆ. His first allegation is his mother-in-law had given a letter requesting to pay my lord the ex gratia payment.
Yes.
Till today, my lord, the ex gratia payment has not been made. This is the first. Then, my lord, the next. ಸದರಿ ಪತ್ರದೊಂದಿಗೆ ಕಳಿಸಿರುವ ಜಿರಾಕ್ಸ್ ವೋಚರ್ನಲ್ಲಿ ಶ್ರೀಮತಿ ಮಂಜುಳಾ ಅವರಿಗೆ ಚೆಕ್ಗಳ ಮೂಲಕ 9 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಟ್ಟಿರುವುದು ನಮೂದಿಸಿರುತ್ತಾರೆ. My lord, the Manjula is the, my lord, the complainant's wife. She is the daughter of the, my lord, the landowner.
Yes.
Krishnappa.
Yes.
My lord, ನಾವು ನಿವೇಶನಕ್ಕಾಗಿ ಸದರಿ ಪತ್ರದವರಿಗೆ 9 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದು ಸರಿಯಷ್ಟೇ. ಸದರಿ ಸಂಘದಿಂದ ನಿವೇಶ ಕೊಡಿಸಿ ನಗದಾಗಿ ಪಡೆದುಕೊಂಡು 9 ಲಕ್ಷ ರೂಪಾಯಿಗಳನ್ನು ವಾಪಸ್ ಕೊಡಬೇಕು, ಇಲ್ಲವಾದರೆ ನಿವೇಶನ ಕೊಡಿಸಬೇಕೆಂದು ಸುಮಾರು 10 ವರ್ಷಗಳಿಂದ ಒತ್ತಾಯ ಮಾಡುತ್ತಾ ಅನೇಕರು ಕೇಳಿದಾಗ ಅಂತಿಮವಾಗಿ ನಮಗೆ ಸಂಘದ ಮೂಲಕ ಹಣವನ್ನು ನಮ್ಮ ಧರ್ಮಪತ್ನಿ ಶ್ರೀ ಮಂಜುಳಾ ಅವರಿಗೆ ಹೆಸರು 2 ಚೆಕ್ ಕೊಡುತ್ತಾರೆ. ನಾವು ಸದರಿಗಳನ್ನು 4.5 ಲಕ್ಷ 2 ಚೆಕ್ಗಳನ್ನು ಬ್ಯಾಂಕ್ಗೆ ಹಾಕಿರುತ್ತೇವೆ. ಸದರಿ ನಾಲ್ಕು so and so. My lord, the compensation payable was 10 lakh rupees ex gratia payment. Out of rupees, my lord, the 10%.
No, allegation is that the petitioner has collected 9 lakh.
No, I will come, 9 lakh, that is allegation. Now
And the voucher was in the name of Manjula.
Manjula, my lord, the
But till
ex
date,
gratia
neither the
payment.
site is paid nor ex gratia is paid.
No, ex gratia is paid, the amount.
No, allegation is like that.
No, ex gratia amount is paid to Manjula. ನಮ್ಮ ಸಂಘದ ಮೂಲಕ ಹಣವನ್ನು ನಮ್ಮ ಧರ್ಮಪತ್ನಿ ಶ್ರೀ ಮಂಜುಳಾ ಅವರಿಗೆ ಹೆಸರು 2 ಕೊಟ್ಟಿರುತ್ತಾರೆ. He says, my lord, the amount which has been paid by the society of 9 lakh rupees is towards the, my lord, the discharge of the amount which has been paid by, my lord, his wife for the site. That is his allegation.
No, the 9 lakh rupees was obtained by the petitioner in his individual capacity.
The allegation is 9 lakh rupees were paid by his wife for allotment of the site.
Yes.
And
For
that
return
amount
that
has been
amount.
paid.
That to return that amount, he has issued the checks belonging to the society.
So society, that is the allegation.
Yes.
My lord, the candidate ಸದ್ರಿ ಪ್ರತಾಪ ರಾಥೋಡ್ ನಮ್ಮಿಂದ ನಿವೇಶನಗಳನ್ನು ನಗದವಾಗಿ ಪಡೆದುಕೊಂಡು 9 ಲಕ್ಷ ನಮಗೆ ನಗದ ಕೊಡೋದು ನಿವೇಶನ ಕೊಡದೆ ಸಂಘದ ಮೂಲಕ ಕೊಟ್ಟ ಸಂಘಕ್ಕೆ ಮಾಡುತ್ತೆ ಈ ವಂಚನೆ ನಮಗೆ ಸದ್ಯ ಚೆಕ್ಸ್ ಓಚರ್ಗಳು ನೋಡಿದಾಗ ಸ್ಪಷ್ಟವಾಗಿ ಬರುತ್ತದೆ. ಸದರಿ ಚೆಕ್ಗಳು ಕೊಡಗಿಹಳ್ಳಿ ನಂಬರ್ 6 ನಂಬರ್ ಜಮೀನು ಪರಿಹಾರ ಮುಂದುವರಿಸುತ್ತಾರೆ. ಓಚರ್ಗಳಲ್ಲಿ ಶ್ರೀಮತಿ ಮಂಜುಳನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿರುತ್ತಾರೆ. ವಹಿಯನ್ನು ಧರ್ಮಪತ್ನಿ ಮಂಜುಳರಾಗುವುದಿಲ್ಲ. ಸದ್ನಿ ಚೆಕ್ ನಂಬರ್ ಆಗಿ ತಪ್ಪಾಗಿ ನಮೂದಿಸಿರುತ್ತಾರೆ. ಬರೆದ ಸಂಖ್ಯೆಯಲ್ಲಿ 4 ಓಚರ್ಗಳು ತುಂಬಾ ವಂಚನೆಯಕ್ಕಾಗಿ ಸದರಿ ವಚನ ಲಗತ್ತಿಸಿದೆ. ಶ್ರೀಮತಿ ಮಂಜುಳ ಬ್ಯಾಂಕ್ ಆಫ್ ಬಂಡೆಯಾದ ಜಿರಾಕ್ಸ್ ಕಾಪಿಯನ್ನು ಲಗತ್ತಿಸಿದೆ. ವೆಂಕಟಲಕ್ಷ್ಮವನ್ನು ವಂಶ ಪ್ರಕರಣವನ್ನು ಲಗತ್ತಿಸಿದೆ. ಸದರಿ ಮಂಜುಳ ಸರಿ ಪರಿಹಾರವನ್ನು ಕೊಡಲು ಯಾವ ಅವಕಾಶ ಇರುತ್ತದೆ ಜಮೀನು ಒಬ್ಬರಿಗೆ ಸೇರಿದ್ದಾಗಿಯೋ ಇದು ಸಂಘದ ಕಾರ್ಯ ಪ್ರತಾಪರಾಜ್ ಸ್ಪಷ್ಟಿಸಬೇಕು. ಇಲ್ಲವಾದರೆ ವಂಚನೆ ಒಪ್ಪಿಕೊಳ್ಳಬೇಕು. ಇವರು ವಿಚಾರಣೆ ಅವಶ್ಯಕ. ಸದರಿ ಸಮಯನ ಪರ್ಯಾಯ ಹಣಕ್ಕಾಗಿ ವೆಂಕಟಲಕ್ಷ್ಮ 3 ಮನೆಗಳು ಕಸಿದ್ದು ಯಾವೇ ಜವಾಬಪತ್ರ ಮೂಲಕ ಸಹಾಯಕ my lord, the first charge is, my lord, the 10 lakh rupees he had given 10 years back for allotment of a site by his wife. My lord, he has not prepaid the amount, and when he demanded the money, they paid 9 lakh rupees from the society. That is an allegation. My lord, they now kindly take, my lord, the his objection statement. My lord, the vouchers, my lord, he himself has produced it. And what's your sir?
No, sir. Petition.
Sorry, my lord, I have produced along with petition. Kindly take, my lord, the document number 5, page number 26.
You are referring to statement of objection.
No, sorry, my lord, it is along with my petition.
Page number.
Page number, my lord, 26.
No, what is your defense now?
My lord, my defense is, my lord, he has, my lord, the 10 lakh rupees was a compensation was payable for each other member. My lord, the 10 lakh rupees has been paid. My lord, I have not received any amount, my lord, from him for the allotment of the site. Now, my lord, what happens is, my lord, after the death of his father-in-law, there are about 5 legal heirs are there, my lord. Suppressing this fact, my lord, he comes to our office and, my lord, they demands the saying that ex gratia payment have to be made, and his wife is only one of the legal heirs. My lord, on that false submission, my lord, we paid the amount to him. Afterwards, my lord, his mother-in-law and other.
Who you paid
through the check.
Check for rupees?
4.5 lakh rupees, 4.5 lakh rupees.
Only 9 lakh.
9 lakh rupees.
What happened to
out of 10 lakh rupees, 1 lakh is deducted towards a TDS.
Towards?
TDS, my lord, income tax deduction, 10% you have.
Where is the document?
My lord.
Where is the document?
My lord, there will be document will not be there, my lord, meaning TDS. My lord, they will submit.
Sir, for paying 10 lakh as ex gratia.
Yes.
As per the decision
My
of
lord,
the board.
Yes.
There must be a decision.
My lord, kindly, my lord, he himself has, my lord, issued a, my lord, the receipt. Having paid the, my lord, towards the compensation amount.
That is, according to him, is a forged.
My lord, he himself, my lord, he himself has, my lord, taken the, my lord, the voucher, obtained a signature from his wife and paid. And, my lord, the 9 lakh rupees.
Let it be investigated, sir.
My lord, my submission.
Whether a specific allegations are made by the complainant. That my signature of my wife is forged on the voucher.
My lord, kindly say, my lord, that allegation
is sent to forensic lab. Truth will prevail.
Check.
Why you should be afraid of that?
Check which has been this one. She has, my lord, deposited in the bank. She admits it.
Yes.
My lord, both the checks he has deposited in amount. And, my lord, he has, my lord, paid the amount. Now, kindly see, my lord, the reason for filing him the this one, there are about 5 legal heirs are there. They, after paying the amount to him, they started demanding the money, saying that the amount to 10 lakh rupees have to pay to them. Then we realized, my lord, this amount which has been paid, there are other legal heirs. And my lord, they just to cover up this aspect of the matter, my lord, this false complaint has been filed against the secretary of the society.
Where is the demand by the other legal
My
representative?
lord, he himself says, my lord, in the complaint, that his mother, my lord, he has started demanding the money. In the complaint himself, he says. May I read this complaint?
You have not inquired as to who is the legal representative?
My lord, my lord, he came to this one. Then he said, my lord, he is the only legal heir. My lord, initially,
There is no inquiry by the secretary.
no, it is, my lord, the secretary, on the basis of this, my lord, his representation.
See, some Tom, Dick and Harry will come and say, I am entitled for entire amount.
Yes.
Whether the society will blindly issue a check?
My lord, believing him, my lord, since they were all this one, the amount has been paid to him. Then when his mother-in-law started demanding money, then we came to know not only his mother, there are other legal the brothers.
There is a demand by the mother.
Yes.
With this society, where is that?
My lord, in the complaint himself, it says. May I read a complaint?
If there is a demand, the society should have something.
My lord,
You are the secretary, you are representing the society.
society, yes, ma'am.
Then
My lord,
why you are not placing any records?
my lord, in his complaint himself, he says, my lord, his mother has.
He may say so many things.
No,
Sir.
he admitted, my lord.
If you want to go through the complaint, the averments made in the complaint,
Yes.
and it is to be accepted, I will accept that.
No, my lord,
According to you, the complaint is false.
my lord, he admits that his mother has started paying the amount, demanding the amount. My lord,
Because you have not paid any amount, she started demanding.
my lord, yes.
This is the allegation.
That is the allegation. My lord, kindly take, my lord, the
See,
complaint.
page number 15, 30ನೇ ವಾರ್ಷಿಕ ಮಹಾಸಭೆ ನಡವಳಿಕೆಯಲ್ಲಿ ದಾಖಲಿಸುವ ರೀತಿ ಎಕರೆಗೆ 10 ಲಕ್ಷ ರೂಗಳನ್ನು ಹೆಚ್ಚುವರಿ ಪರಿಹಾರವಾಗಿ ಕೊಡುವಂತೆ ತೀರ್ಮಾನಿಸಿತ್ತು. ಅಂದರೆ ಶ್ರೀಮತಿ ವೆಂಕಟಲಕ್ಷ್ಮಮ್ಮ ಅವರ ಜಮೀನಿಗೆ 13,50,000 ರೂಗಳನ್ನು ಕೊಡಲು ಕೋರಿ ಸಂಘಕ್ಕೆ ಶ್ರೀಮತಿ ವೆಂಕಟಲಕ್ಷ್ಮಮ್ಮ ಅವರು ಮನವಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದರು.
Yes,
but nothing was paid.
Now the my lord, after payment of the amount, now she started demanding the
When that payment was made? When that payment was made?
Payment was made to the my lord, the complainant's wife through the check.
When?
My lord, the check dated is my lord the 20th April 2015.
Where I can find that date?
My lord, page number, along with my petition, page number document number 5, I have produced the my lord the check.
Page number?
26. Page number 26, my lord.
Whether this is encashed?
Encashed, my lord, they have produced the passbook also, and he admits also in the complaint that amount has been encashed by his wife.
ಎಲ್ಲಿದೆ?
I will read the my lord complaint.
See, he
My lord,
refers to,
kindly take page number 15.
he refers to 9 lakh rupees paid to you personally for allotment of site.
Yes, my lord.
That amount is not returned to the wife, mother of the complainant.
No.
Mother-in-law of the complainant.
No. His case is, my lord, his wife had paid 9 lakh rupees to the secretary for allotment of a site.
Yes, not to the society.
My lord,
To the petitioner.
I will read it once again, my lord, to be sure. I don't want to come. My lord, he says to the petitioner, not to.
Petitioner, that is what I am saying.
Yes, my lord.
Instead of returning that amount,
yes,
you have issued the checks belonging to the society.
My lord, that is, he says, my lord,
Yes, it is his contention, that is what I am saying.
My lord, then kindly see, my lord, the receipt which has been this one. He admits, he says, my lord, this amount was paid towards the compensation amount, that the receipt. And it is not.
What should happen to the 9 lakh rupees which is already paid?
My lord, my lord, I have not received the, my lord, the 9 lakh rupees from him at any point of time. My lord, even though he says 10 years back, he was not even the, my lord, the secretary of society. He became secretary of society in the year 2014. I have produced the, my lord, the resolution copy. Kindly take, my lord, the resolution copy, appointing the, my lord, this one, the petitioner as the, my lord, the secretary. He was appointed on 7/6/2014 as the, my lord, the in-charge secretary, and he was, my lord, appointed on 27/10/2016 as the regular secretary. He refers to a transaction which is 10 years back. At that time, he was not even, he was the secretary. Kindly take, my lord, the page number 23, document number 3.
And there is no document to show that.
This is the, my lord, a resolution appointing me as the, my lord, in-charge secretary on 7/6/2014. The next document is the, my lord, on 27/10/2016.
ಲಕ್ಷಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಏನು ದಾಖಲೆ ಇಲ್ಲ, ಸುಳ್ಳೆ.
Earlier to that, you are working as an accountant.
And on, my lord, 27/10/2016, next document, I was appointed a regular secretary.
What happened to your, the inquiry under 64?
I will come to, my lord, this is the, then, my lord, here, the next charges are pertaining to the, my lord, the 64 inquiry. I will read the next charges also. My lord, the 64 inquiry was held. My lord, the president, my lord, the inquiry, this one is the misappropriation done by the ex-secretary, Mr. Prakash, not by this gentleman. That is the finding of the, my lord, 64 inquiry.
Where is that report?
I have produced the, my lord, the 64 inquiry report. Kindly take, my lord, the document. My lord, the first document along, my lord, the memo, page number 1.
Memo, you are referring to memo dated 1/4.
On 1st April 24.
Who held this inquiry?
Not the deputist of the society, cooperative society.
Where is the final opinion in the report?
My lord, I will, my lord, the charges are there, number of charges are there. Whatever charges against the petitioners, I will read it only relevant portions. My lord, this is a very big inquiry report. I will not refer it to the, my lord, the other charges.
What is the conclusion arrived at?
My lord, on each charge, but the finding is given, conclusion is given. For example, my lord, kindly take, my lord, the charge number, my lord, the page number 11, page number 25, Aropa. You also got it.
Page number?
Page number 25, along with the documents. There are about 43, my lord, the charges are there. On each charge, my lord, the inquiry is conducted and a report is given. First charge. ಸಂಘವು ಕಾನೂನು ಬಾಹಿರುವ ನಿಮಿಷಗಳನ್ನು ಸದಸ್ಯರಿಗೆ ಹಂಚಿಕೆ ಮಾಡಿ ವಿರುದ್ಧ ಜವಾಬ್ದಾರಿ ಹೊಣೆಗಾರಿಕೆ
ಪೇಜ್ ನಂಬರ್ 25.
Page number 25, my lord, ಆರೋಪ number 1.
ಇಲ್ಲ ಅದು.
Along with the documents have produced.
Page number 11.
Page number 11.
ನೀವು ಪೇಜ್ ಬೇರೆ ನಮ್ಮ ಪೇಜ್
Sorry,
ಬೇರೆ.
No,
ಏನ್ ಮಾಡೋದು?
ನಂದರಲ್ಲಿ 2 ಪೇಜ್ ಇದೆ.
Whitener ಹಾಕಿದ್ದಾರೆ.
Page number 11, my lord. But this is our charges. On each charge, my lord, the finding is given, this is conducted. So far as the petitioners is concerned, I will read them out of the charges which has been leveled against the petitioners, and a report has been given.
This is not the charge we are concerned about.
No, it is not, this is not a charge pertaining to the petitioner.
Then
I will read them out of the charges
you
which has
please
been.
come to the relevant
Yes,
portions.
my lord, your lordship wanted to finding, that's why. My lord, the first charge is, my lord, kindly take, my lord, the Aropa number RO, page number 35.
ಎಲ್ಲಿ ಅದು? Two different pagination is there.
My lord, the ink page number 35, my lord, that is Xerox page, ink page number 35.
In page ಯಾವ್ದಿದೆ? ಆರೋಪ Yes.
ಆರೋಪ 6. ಸಂಘದ ಕಲಂ 30 ನಿರ್ದೇಶನ ಜ್ಯೇಷ್ಠತಾ ಪಟ್ಟಿಯನ್ನು ಇಲಾಖೆಯಿಂದ ಅನುಮೋದಿಸಿಕೊಂಡು ಜ್ಯೇಷ್ಠತೆಯಲ್ಲಿ ಹೊರತುಪಡಿಸಿ 210ರಿಂದ ತಹಲುವರೆಗೆ ಕಿರಿಯ ಸದಸ್ಯರಿಗೆ ಸಂಘವು ಅಕ್ರಮವಾಗಿ ನಿವೇಶವನ್ನು ಹಂಚಿಕೆ ಮಾಡಿ ನೋಂದಣಿ ಮಾಡಿಕೊ ಕುರಿತು ಸಂಬಂಧಪಟ್ಟ ಹಿಂದಿನ ಕಾರ್ಯದರ್ಶಿ.
We are not concerned about allotment of sites.
No, my lord, it is pertaining to the site. My lord, that's why I said, my lord.
The allegation.
No, my lord, then my lord, the relevant allegation is, my lord.
Is there any allegation against the present petitioner?
My lord, the only allegation
made in the first information.
My lord, yes, my lord, all report has been given, my lord, the petitioner had not committed any this one.
ಎಲ್ಲಿದೆ? Where is it?
Yes, my lord. ನಾನು ಅದಕ್ಕೆ ಅವ್ರ ಚಾರ್ಜಸ್ ವೈಸ್ ಏನೇನಿದೆ FIR ಅಲ್ಲಿ ಬೇಡ. my lord, charges
Those are irrelevant, sir. The report runs into how many pages? 190 pages.
190 pages,
We
yes.
are not concerned about that.
My-
I am
yes.
asking you, where is the relevant observation made by the enquiry officer, that is Deputy Registrar of Cooperative Societies?
Yes, my lord, first is, my lord, that's why I'm saying, what are his.
We are not concerned about allotment of sites.
No.
There is no dispute about that.
I'm referring to the, my lord, allegation made in the complaint. He has made about 5-6 allegations. On basis of the complaint, FIR is produced. My humble submission is, I'm reading the, my lord, the allegation made in the complaint, and I will point out from that.
If you are ready with the allegations made against the petitioner.
Yes.
And the finding recorded by
Yes.
the enquiry officer.
Yes.
Directly come to that point.
Yes, my lord, the first point is, my lord,
First, we are not concerned. Allotment of sites is not a question before this court.
yes. My lord, if you read the, my lord, the complaint, my lord, kindly take, my lord, the page number 18. ಹಗರಣ 4.
This enquiry is against whom?
And the inquiry against them, my lord, all the transaction made by the, my lord, the society, not what a particular persons. Against the, my lord, the president, all against the, my lord, it pertains to the, my lord, all the transaction which have been made by the society, not against the petitioner, including the petitioners and the president of the society.
What is the allegation against the petitioner?
My lord, the allegation against the petitioner is, my lord, he has allotted, one allegation is, my lord, he has allotted a site in favor of his wife. My lord, that is the main charges which he has made. So far, other.
We are not concerned about.
No, that is allegations he has.
He might have allotted or
Yes.
not allotted. We
Yes.
are not concerned about that.
Yes.
How this enquiry report is relevant?
My lord, the inquiry report, he refers to the inquiry report in the
Let him
complaint.
refer, sir.
My lord,
Let him refer.
no, his complaint is.
Incidentally, he refers to that inquiry to say that there was allegations against the petitioner. That does not mean to say that we have to go through the entire inquiry report, which runs into hundreds of
My lord,
pages.
kindly take, my lord, the FIR. First allegation is, my lord, allotment of the site in made in favor of the, my lord, his wife.
He has no dispute about that.
No,
He is claiming that amount of rupees 9 lakh, which was said to
my
have
lord, the
been
9
paid.
lakh rupees was, my lord, the, kindly take, my lord, the,
Ratio 10 lakh rupees.
my lord, he says, my lord, the 10 years back he has paid the amount by his wife. Wife is not a complainant. She had not paid 10 years back. My lord, he says his wife had given this one. My client has not received the 9 lakh rupees from her at all.
Yes.
Now the my lord is separate, now the my lord, since society my lord started insisting to refund the amount, a false complaint has been filed against the my lord secretary of society.
That is your defense.
Yes.
Then why you are referring to all these unnecessary
No,
documents?
there are other allegations in the my lord, the,
There may be hundreds of allegations, sir. We are not
no,
concerned
no,
about.
in the FIR, my lord.
I am concerned only about FIR.
My lord, only, I'm reading only FIR. My lord, the FIR, my lord says, my lord, the 9 lakh rupees was paid by his wife and 10 years back, and he did not pay the compensation. Sorry, he did not allot the site. And my lord, the through the society, he has paid the monthly amount.
There is no dispute about allotment of site.
My
Or
lord,
there is a dispute?
no, sorry. No, his allegation is my client has taken 9 lakh rupees from his wife regarding the allotment of the site.
Yes.
My lord, the site was not allotted, and my lord, the 9 lakh rupees was returned through the society. That is his allegation.
You said at the beginning, the allotment of alternate site is not in dispute.
My lord, no, this was site was allotted to the original owner.
To whoever he may be.
Yes, my lord, to him also site is allotted. Now the my lord, after his death, my lord, his wife entered.
Be certain whether site was allotted to, alternative site was allotted or not.
Not the alternative site is allotted to the original one.
Then why are you saying the site was not allotted?
That is his allegation.
My lord, he says, my lord, alternative site was allotted to original owner.
Yes.
My lord, there is no dispute. Now he says, my lord, apart from this one, he had, his wife has given 9 lakh rupees to the my client for allotment of the another site. She is also a member and he is also a member. Now the my lord, according to him, 9 lakh rupees was paid for the allotment of the site. It was not, site was not allotted. And my lord, the 9 lakh rupees was repaid by the my lord, him through the society.
It's not for allotment of site, sir. As I understand, it is towards ex gratia 10 lakh rupees that is to be paid.
No, I'm not referring. According to us, I have not received 9 lakh rupees from him. This amount which has been paid to him is towards the my lord, the ex gratia payment to the made as the legal heir of the original owner. He claims to be the my lord, the only the legal heir.
Wait, yes. What is your?
My lord, then my lord, may I kind of this one?
1 minute, let me hear from the complainant.
Well, that's the sum and substance of the complaint is this, my lord. There are two transactions involved. One is 1 acre 35 guntas was acquired from the mother-in-law of the complainant.
Yes.
For that, the society had agreed to pay an ex gratia of 10 lakhs per acre.
Yes.
Now, in a completely different transaction, the complainant, the petitioner before your lordship had taken 9 lakhs to allot a site to the wife of the complainant.
Yes.
Now, refunding that 9 lakhs which he has collected from the complainant's wife,
Issue the checks belonging to the society.
society is one aspect. The second aspect is he's forged receipts, forged the signature of the complainant's wife, and made it appear as if that payment of 9 lakhs is made towards the ex gratia payment. That's the sum and substance of it.
That is what I am
That
saying.
needs to be investigated. The checks, the signatures have to be.
That is what I am saying.
Yes. My lords, I have produced those forged.
9 lakh rupees should have been returned by the petitioner in his personal capacity.
In his personal capacity.
Not from the fund of the society.
Society.
My
And
lord, I
13
dispute my-
lakhs ought to have been.
I have not, I have disputed the my lord, the receipt of the amount.
Yes.
My lord, this is my lord, just to cover up his lapses. My lord, a false complaint has been filed just to blackmail my client. My lord, this is the my lord, the arm twisting tactics. When my lord, he came to know that there are other legal heirs and my lord, other legal heirs are also entitled for the payment of the compensation. My lord, he has lodged this complaint to my lord to cover up his lapses. My lord, he admits that my lord, the receipt of the amount and also the my lord, he admits that the receipt have been my lord, paid, has been issued by the my lord, this one. He says, my lord, the receipts have been forged by my client. My lord, kindly see my lord, the receipts. My lord, kindly take my lord the statement of objection, page number 25.
Yes,
My lord, this he says, my lord. Lordship got it, madam.
yes.
My lord, received thanks so and so and so. Bearing check number so and so, corporator this one, white check number so and so. Towards the my lord, the compensation. My lord, Kodigehulli land compensation antide. Lordship got it, madam.
Yes, yes.
My lord,
Now, according to the complainant, this.
my lord, this signature, my lord, this receipt.
Picture is forged.
My lord, this signature is signed not only by me, by the vice president and the secretary.
Yes.
And my lord, this one. My lord, according to us, my lord, he took the check from us, and he says, my lord, he will obtain signature from his wife. My lord, he has obtained signature and produced us. We don't know, my lord, who has signed the signature. And it is a routine, my lord. We have taken such the receipts from all the landowners who have, my lord, given the my lord the ex gratia payment. It is not from this individual. This is a printed format which has been issued by the secretary, by the society, and all the landowners who are the beneficiaries, they have given this. My humble submission is this allegation that the check has been forged by me, my lord, is a baseless. It is a, my lord, it is only to cover up his lapses. Since we started demanding the amount to refund the amount so as to pay the other legal heads, my lord, my lord, the complaint has been filed.
Yes.
And kindly see the my lord, his allegation is 10 years back his wife has not paid the amount. But can you believe, my lord, 10 years a person he keeps quiet for 10 years. And person who has, my lord, received the amount, and person whose signature is alleged to have been forged, she had not come before the police. I can understand, suppose Manjula had come before the police and lodged a complaint. She is not before the, my lord, lodged a complaint before this one. This gentleman has lodged a complaint. My humble submission is, he is not an aggrieved person. He cannot, my lord, so far represent his wife.
Any person can set the criminal law into motion.
No, so far, kindly see the conduct of a party. Suppose, my lord, the person who has, I suppose I come to know my signature has been forged. Immediately, what will be the reaction? Person who is aggrieved person, he will lodge a complaint.
No, there is no bar for the husband to lodge the complaint.
No, I'm saying, my lord,
Criminal law, anybody can
No,
set the law, criminal law into motion.
kindly see the conduct of the party, my lord.
Yes.
Then, my lord, the allegations are there in the FIR regarding the allotment of the sites, misappropriation, all those things. They have been, my lord, kindly take, my lord, the FIR. My lord, ಆರೋಪಿಯು ರಾಜೀವ್ ಗಾಂಧಿ ಅಂದ್ರೆ 2ನೇ ಹಂತದಲ್ಲಿ ಬರುವ 13 ನಿವೇಶನ 1 ನಿವೇಶನಗಳಲ್ಲಿ ಅಕ್ರಮವಾಗಿ ಅವರು ಕುಟುಂಬ ವರ್ಗದವರಿಗೆ ಹಂಚಿ ನೋಂದಣಿ ಮಾಡಿಸಿರುತ್ತಾರೆ. This is the next allegation. My lord, so far this is concerned, 64 inquiry says this site was allotted to his wife even before his marriage by the society. That is the, my lord, the finding under 64 inquiry. May I read it, that finding, my lord? My lord, kindly take, my lord, the page number 36. along with the documents which you have produced. Kindly take the page number 130 regarding the allotment of the site made in favor of the wife. Finding is, my lord, ಪ್ರತಾಪ್ ರಾಥೋರ್ ಪತ್ನಿಯಾಗಿದ್ದು ಅವರ ವಿವಾಹಕ್ಕೆ ಮುಂಚೆಯೇ ಸದರಿ ನಿವೇಶವನ್ನು ಖರೀದುವ ವಿಚಾರಣೆ ಸಮಯದಲ್ಲಿ ತಿಳಿಸಿದರು. Finding is, my lord, even before his marriage, the site was allotted to his wife. There cannot be, my lord, the finding is there, and so far second allegation it goes to my lord. Then, my lord, so far the Haryana Development Corporation and all those things concerned, my lord, the 64 inquiry says, my lord, he is not at all responsible, and the president, who is the alone, he is Ravindranath, he is alone held to be responsible for other allegations. Then, my lord, this regarding the, my lord, he says, my lord, a sale deed, a rectification of a sale deed has been made by the petitioner in respect of this one. So far a rectification of the sale deed is concerned, it has been done pursuant to a resolution passed by the, my lord, the society. And, my lord, the mere rectification does not amount to constitute any offense. So far as then he says, my lord, my client has misappropriated 300 crore rupees of the amount.
Now, where is the resolution for executing ratification deed?
My lord, the kindly seek, my lord, the deed of rectification is number 68.
That is there. Where is the resolution by the society authorizing the petitioner to execute?
My lord, first I will take the, my lord, the rectification itself. It is not only signed by me, it is signed by the president himself. Kindly take, my lord, the page number.
There was no resolution.
Resolution is there, my lord.
Where is it?
I will produce it if that resolution is. I will produce it resolution.
You have not produced it.
I have not produced it, my lord. Kindly take, my lord, the page number 87.
Yes.
My lord, the execution of a rectification, is it amounts to a, my lord, an offense?
It depends on the facts of the case.
No, it does not amount to an amount. The rectification of a sale deed by this one, the sale deed. I can understand in this.
Why ratification deed was
But
executed?
there was a change of name, nothing else. That's why I said.
Earlier, in whose name the sale deed was executed?
Huh?
Earlier, in whose name the sale deed?
I will kindly take, my lord, the rectification deed, page number 87. Bearing number so, President Manjunath here, so and so, whereas the property bearing number so and so, so and so. Hereafter, whereas in page number 1, line number, so instead of typing name Nanjay Gowda, son of Nanjay Gowda by our side, it is typed Rame Gowda. Now it will be read as the Nanjay Gowda alias Rama Gowda. And it has been signed by the president and secretary. And, my lord, nothing has been changed. Only the name alias has been included.
No, Rame Gowda is changed as Nanjay Gowda.
My lord, I will read on the, whereas in page number 1, instead of typing Nanjay Gowda, the seal bidide.
Alias Rame Gowda by oversight.
Nanjay Gowda, by typing Nanjay Gowda,
Alias
Rame Gowda by oversight, it is typed as Rame Gowda. It will be read as Nanjay Gowda alias Rame Gowda.
When the sale deed is dated?
Sale deed was executed in the year 2013, 4/7/2013. At that time, he was not even the, my lord, the secretary of the society.
Ratification deed was executed.
Executed in the year 2016.
Yes.
Then, my lord, the vague allegation is made that my client has misappropriated about 300 crore rupees worth of the amount.
Yes.
My lord, there is no allegation in the complaint to that effect. I will read regarding misappropriation of the amount. There is no allegation in the complaint. First time investigation officer in a FIR, he says, my lord, I am misappropriated. My lord, kindly see, my lord, in the complaint. There is no allegation of the, my lord, the misappropriation of 300 crore rupees by my client. This is a imaginary, my lord, even though there is no allegation, but it is happening in corporate.
Yes.
And hence, my lord, this is with a vengeance. My lord, this complaint has been filed. It's a false complaint.
Yes.
And my lord, hence I seek, my lord, the quashing of the proceedings.
Yes. Yes.
Then, my lord, sorry, my lord, under the Cooperative Societies Act, my lord, if the complaint has to be lodged, any offence is committed under the, my lord, the offence under the Cooperative Societies Act, permission is necessary.
Which is the provision?
My lord, the
Cooperative Societies Act.
my lord, the section
ಇರುತ್ತದೆ Cooperative Societies Act ಇರೋದು.
section 111
What does it read?
of the Cooperative Societies Act. My lord,
Read it.
no court inferior to a magistrate of the first class shall try any offence under this act. No prosecution shall be instituted under this act without the prior sanction of the director of the Cooperative Society audit in respect to the matters arising of the audit other than the matters relating to the Cooperative Society, Credit Structure Society. The register inspect of all other, including the matters relating to audit report, Cooperative Society Structure Society, provided no sanction of the register of the director of audit shall be necessary filing the criminal complaint against the delinquent for alleged misappropriation, embezzlement, funds of the Cooperative Society detected during the audit, inquiry, inspection, course of the business, Cooperative Society. The sanction shall not be given. But in this case, my lord, there is no, my lord, in the audit report, there is no, my lord, finding that, my lord, regarding the misappropriation of the amount. Under these circumstances, the permission of the director of cooperative society is necessary. In this case, there is no sanction has been obtained straight away.
What stage the sanction is to be obtained?
My lord, if you want to, my lord, register the case.
No, it is for prosecution.
No, that's all, my lord. No prosecution shall be instituted. Prosecution means, my lord, the registration of the complaint. Then sanction shall be given by the my lord, after hearing the my lord, the complaint, the registrar. The sanction of section shall not be given without giving a person concerned an opportunity to present his case. And director of the response, so and so. But in this case, no sanction is obtained, straight away, my lord, the FIR is filed and case is registered.
Yes, yes, what is?
As per the complaint aware minutes, there is a clear misappropriation of the fund which has belonged to the society, my lords, and it has admitted fact that he has allotted the site to the wife of she is none other than the wife of the petitioner herein, my lords. And my lords, there was a check issued by the wife of the petitioner herein, my lords. It has.
You have heard his argument. Even though there is allotment of a site in favor of his wife, that was much before his marriage.
That is the finding.
Will it amount to an offense?
My lords, but the signature of the
When the site was allotted?
Complainant's wife. Allah, idu petitioner wife. Petitioner's wife. Petitioner wife.
Yes.
Please, my lords. And apart from this, my lords, there are.
Apart from Allah, the question is answer bekalba.
When
the site was allotted, according to him, it was much before his marriage. When
That
the
is
site was
contention, further investigation is required regarding this.
Further, no, investigation agilla tane.
Illa, my lords.
No investigation
No,
was
no,
under.
no, my
There
lords.
was
There
stay
was
from
stay,
this
my
court.
lords. There was
Nothing
a
has
stay.
been investigated.
Nothing has been investigated.
64.
Yes.
Hence, my lords, and as per the complaint awareness, my lords, he has misappropriated the funds belongs to the society, my lords. And regarding this, my lords, their inquiry should be conducted, my lords. And further, my lords, the property and the amount which has belongs to the society, my lords, it's a public fund it has involved, my lords.
How he has misappropriated?
Let's, he has taken the check of 9 lakhs in form of allotting the site, my lords. And he has issued the, and he has stated as a parihara hanavendu nambisi sarkarake vanchisiruttare.
He never taken the check. He has rather issued the check. He has not taken the check. Where is the allegation that he has taken the checks?
Society check ಅನ್ನ ದುರುಪಯೋಗ ಮಾಡಿಕೊಂಡಿದ್ದಾರೆ. Society check.
How? Yes, for respondent number 2.
That's the, according to me, my lords, one substantive issue is the payment of ex gratia payment, which was required to be made by the society in the sum of 13 lakhs 50,000, has been purported to have been shown as having been made to the daughter from whom he has personally taken a sum of rupees 9 lakhs. And to compound that, he has forged a receipt in the name of Manjula. I've produced that receipt along with my statement of objection.
Why you paid 9 lakh rupees to him?
For the, he was a clerk in the society. He said, I will get you one site. I'll get it.
When you paid it?
That was paid sometime in 2007.
Why you kept quiet? He was not a secretary then.
He was not, he was a clerk he was always in the society. He was always running the society. Yes, ma'am.
He was a accountant.
He was an accountant. Before that, he was a clerk. He's the only one who knows anything.
Of the member of the society.
Not Manjula, my lord, but the complainant. Complainant is
a
an
member.
associate member of the society.
Since
Yes.
how long?
My lord, he's been a member since I think about 2007, 2008.
So even though you are a member,
Yes, ma'am.
your wife paid rupees 9 lakh in cash to an accountant,
Took an accountant
not
who,
authorized to
Yes.
sort the sites.
he had assured her he'll get her a site from a member who's been allotted a site. That is how it's come into.
After so many years you have filed this complaint.
My lords, what had happened is, your lordship will recollect, in 2005, the Supreme Court had delivered the judgment in the HMT case, wherein it held that all lands which were acquired from the landowner should be returned back to the landowners. Now it's in view of that judgment, to pacify the landowners, that this 10 lakhs ex gratia payment was
No sites, alternative sites were allotted.
no alternative site. They pacified the landowners from going to the High Court and getting the land back by paying them this 10 lakhs ex gratia
It's
per.
altogether different.
It's altogether different, but my lords, all along, the society never formed the sites because of the pending litigation.
Admittedly, there was a resolution in the society to pay rupees 10 lakh per acre as gratia
Yes, ma'am.
for the land loser.
The landowner, yes.
Towards the payment, the petitioner issued 2 checks, 4.5 lakhs.
That is what he claims.
Even you admit in your complaint.
Well, that was paid towards the refund of the money paid by his wife.
No, that was paid by the society.
It was, he issued checks from the society.
Ex gratia payment.
He claimed, in the receipt, he claimed it is ex gratia. But according to what he gave us, he said this is towards the repayment of the amount which was.
Is there any material to substantiate that?
There's no material we have produced, my lords. But my submission, my lords, is all this requires, this is a substantive.
Do you
case.
have any document to show that you have paid rupees 9 lakh to him?
I don't think there's any document.
Then-
But unless I paid it, my lords, your lordship will see this 13 lakhs 50,000 and this 9 lakhs paid, they don't correlate. If he has to repay 13 lakhs, why will he pay 9 lakhs?
No, you can claim it from the society. That is a different issue. That will
That's-
not
therefore my
constitute an
subs-
offense.
My lords, from the amounts which are
If
involved.
the entire amount what is decided by the society is not paid to you, you can always claim it.
So, my lords, what I'm trying to say is,
See, you made some allegations.
yes,
I am asking you, is there any prima facie material to substantiate that? You
Well,
said you have paid 9 lakh, there is no document.
there's no document. My lords,
Moreover, the petitioner was not the secretary. He was not authorized to allot.
he was
the
an
sites.
accountant, my lords, yes.
And about 10 years you kept quiet.
My lords, that is because promise is always made, we'll get it, I'll get you a site,
But the
That's-
conduct of the
Parties.
complainant.
Well, yes, that's my substance is the fact that the amount which was agreed to be paid by the society is ex gratia.
Is there any prima facie material, sir, for having you paid the amount of rupees 9 lakh?
I think nothing has been placed on.
Then even if the investigation is undertaken, what will be the result?
Well, it's the fact that the receipts were forged shows that he's trying to cover up something. Otherwise, what's the necessity to forge? Well, that is one thing. Secondly, he had to pay the amount to the mother-in-law. He has not paid anything to the mother-in-law. In the very fact that the mother-in-law has been collaterally demanding that amount and no amount is paid to her clearly shows that these two are two different transactions and the payment is towards different. He's completely aware that Venkat Lakshmama has to be paid 13 lakhs. There's absolutely no reason for him to pay the 9 lakhs to Manjula. This prima facie shows that these are two completely different transactions. He wouldn't pay 13 lakhs to a stranger under the assumption that she's the daughter and therefore my payment of 13 lakhs gets discharged by paying the amount to the daughter.
Venkata Lakshmama was the owner of the property.
Owner of the land. And this story that 1 lakh is retained as TDS, 13 lakhs is to be paid. Why will 1 lakh be withheld? It only fortifies my case that what was borrowed, what was taken for the procuring a site is 9 lakhs and 9 lakhs is what has been.
Yes.
Well, this is the substantive part of the complaint, my lords. I think the rest all.
What do you say regarding section 111 prosecution?
Well, this is
Sanction.
the complaint has been given against the person, not the society.
In his capacity as a secretary of the society.
Well, he may have acted as a thing, but the forgery has been done by him in his personal capacity.
Personal capacity ಅಂತ ಹೇಳಿದಿರ ನೀವು ಇಲ್ಲ.
So far as section 69 is concerned, my lords, that pertains to prosecution.
69 ಅಲ್ಲ, he referred to section
111. It pertains to prosecution where prosecution is ordered by the society. Because if I'm not mistaken, because I haven't, that's not a ground which is raised by them. I did not. Cognizance of offences, no court inferior to that of a magistrate of the first class shall try any offense under this act. Offense under the act. Malaj, I am not claiming.
Not,
yes,
is not the question.
no prosecution shall be instituted under the act without the previous sanction.
Yes.
Malaj, this is not a prosecution which is under the act at all. This is a.
You see, read the name of the petitioner as secretary, as accountant, in charge secretary and secretary of the society.
Yes, Malaj.
Adhikara
But this is not a prosecution under the act.
Then what else?
Malaj, prosecution under the act, your lordship will see, is specifically set out. For non-compliance of statutory provisions, for Malaj, offenses and penalties 109. Malaj.
10?
109 of the society's registration. These are the prosecutions under the act, not a complaint given against an office bearer. Well, let's say subsection 13 of 109. Manoj. Any cooperative society or any office bearer or employee or paid servant thereof who fails to give effect to any decision or award under section 71, including an order, if any, passed by an appropriate appellate authority and such decision or award not being a, shall, if such failure is, the board punishable with fine. Malaj, these are the offenses which are offenses under the act. Therefore, my submission is, matter requires investigation. Forgery and the payment of amount has to be investigated. It's and nothing has happened after filing the FIR. Malaj, they've obtained a stay. There is absolutely no proceedings which has been commenced pursuant to the FIR.
Yes.
The matter needs to be
Yes.
gone into.
Anything?
My lord, after the receipt of the complaint, my lord, the he lodges a complaint before the decision. He had given a reply. In the reply, he specifically stated, my lord, this amount has been paid by him towards the, my lord, the ex gratia payment. My lord, the kindly take, my lord, the
Ex gratia payment, 10 lakh rupees per acre.
no, 10 lakh rupees per acre. That's what given. My lord, this
What is the extent of land that was acquired?
1 acre, my lord, the 13 guntas also.
So it should be more than 10 lakh.
My lord,
rupees.
that was the, my lord, the amount which I paid. My lord, that was, the society has paid 10 lakh rupees. Now the balance has to be paid. Now, my lord, it is not the case. Case, my lord, they say, my lord, 10 lakh was paid, 1 lakh and odd. If it exceeds, my lord, the 2 acres, then they will pay, my lord, the 20 lakhs. Again, the size agi 1 lakh 13 gunta. ಆ ರೀತಿ ಮಾಡಿದ per acre 1 ಗುಂಟೆ 10 ಲಕ್ಷ 2 ಗುಂಟೆ ಆದ್ರೆ 20 ಲಕ್ಷ ಮಾಡಿ ಇನ್ ಬಿಟ್ವೀನ್ 1 lakh ಪ್ರಿಸೈಸ್ ಆಗಿ ಮೇಲೆ ಗುಂಟೆ ಲೆಕ್ಕ ಹಾಕೋದಿಲ್ಲ 1 lakh 1 acre 13 ಗುಂಟಾಸ್.
That's all. Anything more?
My lord, immediately after this one, he has a a reply was given to the Assistant Commissioner of Police. My lord, he lodges a complaint. In Assistant Commissioner of Police, he specifically stated this amount has been paid by the society, and my lord, towards the the execution.
That is your defense.
My lord,
That is your
that
defense.
is my defense, and it is the letter which has been written by him. It also shows that, my lord, this amount has been paid by him, by the society for execution payment.
Yes.
Since there are about 5 other legal heirs are there, not only for the wife, there are other 4 children. My lord, he has produced the genealogy.
No, who is the owner of the property?
Krishnappa was the owner.
No,
He
according
died.
to him, Venkatalakshmamma was the owner.
No. Krishnappa owner. He died. My lord, he has produced the genealogy. Kindly see the genealogy. My lord, the genealogy shows, my lord, the Krishnappa was the owner of the property. After his death, his wife and 4 children, they becomes the owner of the property. That is the genealogy which has been produced by him.
Where is it?
Madam, kindly take his statement of objection, page number 30. And relevant page is 31. Krishnappa, Pauti. Then Venkatalakshmamma, his wife. Manjula.
Maybe, but who is the owner?
The Krishnappa is the owner.
Where it is stated?
My lord, this is admitted fact, my lord, he was the owner. There is no dispute. That, my lord, his father-in-law.
Who is the owner?
My lords, he was the owner. After his, my lords, Krishnappa was the owner. After his death,
Yes.
everybody is, it's Venkatalakshmamma who's on, has the revenue records.
Petitioner being the sole accused. In the crime number 165 of 2018 of Kodgihalli Police Station. Registered for the offences punishable under section 408, 420, 468, 471 of IPC. Is seeking to quash the criminal proceedings initiated against him. The facts of the case are that parties are referred to. The facts of the case are that respondent number 2 as the first informant logged the as well. The respondent number 2 has logged the first information against the accused, alleging commission of the offences as stated above. In the nutshell, it is the contention of respondent number 2 that the accused was working as an accountant, later as in-charge secretary, and later as a secretary of NIT House Building Cooperative Society. Society. It had acquired the lands, including survey number 6/4/B and 6/B. A decision was taken in the society to pay rupees 10 lakh per acre as ex gratia to the erstwhile owners. Next paragraph. It is alleged that the petitioner, promising to allot a site, had taken rupees 9 lakh from the wife of the complainant and had issued 2 checks for rupees 4,50,000 each. On behalf of the society, and forged the vouchers said to have been signed by the wife of the complainant towards compensation for the land that was acquired. It is alleged that both these vouchers dated 20th April 2015 are forged and concocted by the petitioner. It stated that there was no question of the petitioner paying rupees 9 lakh to the society, to the wife of the petitioner, wife of the complainant, when he had to return the cash of rupees 9 lakh received by him in his personal capacity. And by issuing the checks for rupees 4,50,000 each, the petitioner has misappropriated the amount of the society. So it is also contended that the ex gratia amount that was required to be paid to the mother-in-law of the complainant was never paid by the society. But the petitioner, by forging and concocting the vouchers, tried to contend that it is the ex gratia amount that is payable to the wife of the owner of the land. It is also alleged that the petitioner, without obtaining necessary sanction from the board of directors of the society, allotted about 23 sites and also site number 898 situated in a second stage of Rajiv Gandhi layout in the name of a fictitious person, Ramegowda, who was never a member of the society, by executing the sale deed dated 4/7/2013. Thus, the petitioner is said to have misappropriated, committed cheating, misappropriated more than rupees 300 crores, committed cheating, forgery, impersonation, etc. Therefore, the complainant requested the police to register the case and to initiate legal action. The police have registered the case and took up investigation. The petitioner is with this court seeking to quash the criminal proceedings initiated against him. Third, so and so, so and so. When counsel for the petitioner contended that there is absolutely no basis for the first information lodged by respondent number 2. baseless allegations were made against the petitioner that he had received 9 lakh from the wife of the complainant about several years back. The petitioner was appointed as a secretary only during 2014. Earlier to that, he was not authorized to execute the sale deed. Even after assuming the office as secretary, the petitioner was obliged to carry out the directions of the board as per its resolution. Admittedly, the wife of the complainant has received 2 checks for rupees 4,50,000 each. In that regard, she has issued the voucher. Since there was inter-se dispute between the wife of the complainant and her mother for claiming compensation, the petitioner is made a scapegoat. Parallel counsel contended that an inquiry under section 64 of Cooperative Societies Act was held by the Deputy Registrar of Cooperative Societies, and the petitioner is exonerated of all the charges leveled against him. Under such circumstances, there is no reason to entertain the police complaint without any basis. Next, counsel further submitted that no sanction is obtained by the complainant to prosecute the petitioner as required under section 111 of Karnataka Cooperative Societies Act. Under such circumstances, the criminal proceedings initiated against the petitioner is liable to be quashed. Accordingly, praise for allowing the petition. Per contra, counsel for respondent number 2 submitted that immediately after filing the complaint in the year 2018, the petitioner had approached his court and obtained a stay order, and therefore no investigation was undertaken. Specific allegations were made against the petitioner, who was admittedly working as accountant in the society, later took charge as in-charge secretary, and subsequently as a secretary of the society. For more than 20 years, he worked in the society and had misappropriated huge sum of rupees 300 crores. Next, counsel submitted that specific allegations are made that the petitioner had received rupees 9 lakh from the wife of the complainant for allotment of a site. When wife of the complainant insisted for repayment of the said amount, which he had received personally, the petitioner had issued 2 checks belonging to the society for rupees 9 lakh in all. Thereby, he misappropriated the amount belonging to the society. Then counsel submitted that the petitioner has concocted the vouchers in the name of the wife of the petitioner to show that the said amount was paid as ex gratia to the land that was acquired, which was belonging to the father-in-law of the complainant, and his mother-in-law had claimed ex gratia payment. There was no reason for the petitioner to pay rupees 9 lakh to the wife of the petitioner when the claim for ex gratia at the rate of rupees 10 lakh per acre was by the mother-in-law of the complainant. The voucher produced before the court is a rank fabrication and the forgery committed by the petitioner. Unless a full-fledged investigation is undertaken, the truth will not be revealed. Therefore, he prays for dismissing the petition, permitting the investigating officer to investigate into the matter. Next paragraph. When the counsel further submitted that section 111 of Karnataka Cooperative Societies Act refers to the prosecution instituted under the Act without previous sanction. The offense referred in section 111(2) of the Cooperative Societies Act refer to the offenses under the Act which are described in chapter 14, 109, chapter Peda, under section 109 of the Act. When there is specific allegations of forgery, concoction of document, impersonation, and misuse of power, no sanction is necessary to prosecute the petitioner. Therefore, he prays for dismissing the petition as devoid of merits. There is the materials point for consideration. I answer to the point in the negative for the following reasons. Respondent number 2 as a complainant filed the first information making specific allegation invoking section 408, 420, 468, 471 of IPC. The specific contention of the complainant that few acres of land belonging to his father-in-law comprised in survey number 6/4/B and 6/B of Kodihalli village was acquired by the society for formation of layout. A decision was taken in the society to give ex gratia amount of rupees 10 lakhs per acre. This amount was never paid by the society to the wife of the earlier owner, that is Srimati Venkatalakshmamma. Next part, it is also the contention of the complainant that the petitioner promising to allot a site in favor of the wife of the complainant had taken rupees 9 lakh in cash. He issued 2 checks for rupees 4,50,000 in his capacity as a secretary of the society and concocted 2 vouchers to show that the said amount was paid towards compensation. Thereby, he has not only misappropriated the public money, but also committed criminal acts of forgery, cheating, criminal breach of trust. The document styled as check vouchers dated 20th April 2015 are produced by the learned counsel for respondent number 2, according to which it is signed by the wife of the complainant and the petitioner being the secretary. It is the specific contention of the complainant that the signatures of his wife found on these vouchers are forged one. This allegation is to be investigated into by the investigating officer by referring the disputed document for handwriting expert. The petitioner is responsible to explain under what circumstances he issued 2 checks for rupees 4,50,000 in favor of the wife of the complainant, and to substantiate its defense that the said amount is towards payment of the ex gratia amount payable for the land that was acquired by the society. Admittedly, no investigation was undertaken by the investigating officer, as the petitioner had approached this court and obtained an order of stay for the investigation. When such serious allegations are made against the petitioner, who was admittedly working as an accountant, public in charge secretary and secretary of the society, and was handling the public money, proper investigation by the investigating officer will unearth the truth in the matter. Next point. It is the contention of the learned counsel for the petitioner that an inquiry under section 64 of the Karnataka Cooperative Societies Act was undertaken by the Deputy Registrar of Cooperative Societies. The petitioner is exonerated from his charges, from the charges leveled against him. The inquiry under section 64 refers to the matter specified in the order touching the constitution, working and financial condition of the cooperative society. But admittedly, the wife of the informant, in favor of whom the petitioner had issued 2 checks for rupees 4,50,000, was not a member of the society. Under such circumstances, the inquiry under section 64 will not cover the will not cover the allegations made by the complainant against the petitioner. Moreover, exoneration of the petitioner in the inquiry under section 64 will automatically not give clean chit to the petitioner. When the petitioner is having a defense in his, when it is the contention of the petitioner that he is having valid defense, it is for him to appear before the investigating officer and produce appropriate documents in support of such a defense. Since prima facie materials are placed, since specific and serious allegations are made against the petitioner for having committed the offences as stated above, I am of the opinion that the investigation cannot be throttled at the initial stage. Therefore, I am of the opinion that this is not a case for rushing the criminal proceedings. Accordingly, I answer the above point will be negative and proceed to pass the following. Petition dismissed.
Serial number 18, H.V. Ramchandra Rao.
Petitioner counsel, my lord.
stay for a week's time, my lord, in this matter. He's not keeping.
Order sheet, order sheet. Two thousand nineteen matter.
Different.
Hmm.
Time.
Yes, what is the stage? The investigation. Is what is the stage?
I'm sorry.
There is no interim order.
There's no interim order.
Then, yes. 2019 matter, what is the stage?
Lower court stay.
Huh?
Verify minutes.
Passover.
Please.
You have to get instructions and make submissions.
Yes.
Next, you also seek instructions.
Serial number 19, Bharat Gowda.
Petitioners are accused number 2 and 1 minutes.
I praise time in this matter.
Hmm?
I praise time.
Why? 2019 matter.
A week time may be granted. Kindly have it on next week.
Petition
Then
filed by the
HCGP prays for
co-accused,
time.
my lords.
Huh?
Petition filed by the co-accused is already allowed, my lords. And
Then what
this
is there?
This is the successive FIR. Initial FIR, B report is filed. Second time, the same FIR.
FIR is against how many accused?
Lords, 6 accused, my lords.
These petitioners are accused number 1 and 2.
Yes, my lords. As against accused number 3, 4, and 6, the petition is filed in criminal petition number 6224 of 2019, it's allowed.
Then,
Complainant,
Next week.
then at HCGP prays for time. The petition is of the year 2019. Then counsel for the petitioner submits that the criminal proceedings against the co-accused is already quashed. It's good.
criminal petition number 6224 of 2000.
You produce it. Hence, list finally as the last chance. Yes.
Grateful minutes.
Next date of hearing, please get ready.
Please, ma'am.
Pray for extension of interim.
Interim order granted earlier. Next,
Short date, ma'am.
yes, date will be given. Take the date.
Serial number 20, R. Ramaswamy.
This is also kindly have it on next week, my lords.
Who's the further petitioner?
Petitioner, the council from DC is Friday, but he could not get it.
Hmm?
The council,
Hmm. Where is he? He is not connected.
I think he is not able to get connected. Next day, we will see him.
No, if you had tried it, we could make out.
He has registered everything,
Then where is he?
but I think he could not. But still there.
Then pass over. Ask him to come or ask him to log in.
Oh,
Serial number 21, Kamaluddin.
My lordship, kindly allow me to file memo for withdrawal, my lordship.
Filing a memo for withdrawal of the petition. Counsel for the petitioner filed a memo seeking permission to withdraw the petition. They need the note holder. Petition dismissed as so and so. Withdrawn. Yes.
Much obliged.
Yes.
List number 3, serial number 1, Vikram Raj.
The petitioner.
HCP to take notice for respondent. Private irrigation. Yes.
A date may be fixed, your lordship.
Date, you can take the date later.
Yes, your
Next,
Much obliged.
Serial number 2, Latif B.
same. Issue notice. Yes.
Serial number 3, Latif B.
Eastern Alliance. Offense under section 448, 326 and 307 of IPC. Petitioner is the sole.
Offense under
Section 448, 326, and 307 of IPC.
Petitioner is accused number?
Sole accused. Petitioner had approached this court earlier in the.
When he was
FIR
arrested?
8/4/2024.
How many injured are there?
That's it. Single CW2 is the injured.
Huh?
CW2 is the injured.
CW
One.
two. Who is the complainant?
Complainant is the brother of the injured.
Do you have the wound certificate?
I have. There are two injuries.
No, first informant is the injured himself.
No,
Anna, yes, brother of the injured. Okay.
brother of the injured.
Yes.
That's
Yes.
what I said.
How many injuries?
Two injuries.
What is the nature?
This one.
What is the nature of injury?
Previous injury.
Huh?
Previous injury.
ಎಲ್ಲಿದೆಪ್ಪ? ಕೊಡಿ.
Pass.
When he was discharged?
He was discharged on 18/4/24. In the same wound certificate as it has been mentioned. Was admitted for 10 days, 11 days.
That is on the vital part of the body.
To the left side of the abdomen. madam.
Hmm.
And one
Then-
one injury is in the left side of the abdomen and another injury is to the left hand. madam. The petitioner had already approached this honorable court during the FIR stage and then withdrawn. There was a financial transaction between the petitioner and the CW2. And some civil.
What is the
disputes.
weapon used?
The allegation is that had used a churi knife. Recovery is also done.
Knife
Please,
recovered.
Recovery,
please, recovery is done.
recovery is there. Bloodstain cloths are recovered.
Only cloths are there.
Yes.
There was a financial transaction between.
Transactions ಇದ್ರೆ ಚಾಕು ಹಾಕ್ಬಿಡುದನು? How can you justify that?
No intention to kill. From 18.
Charge sheet is filed,
Statute is filed.
criminal antecedents.
There are two cases where he has on bail mandate.
Which are those? For what offense?
One is for 326 of IPC,
390,
326.
326.
Another one is 307.
Similar offense. He is
Some-
in the habit of committing the offense.
He's on bail mandate.
That is
As
the
maybe
mistake
he's-
we commit. That is
If
why you
the-
are committing the offense.
No minutes.
No.
There was a
Now,
personal.
what is the stage?
Milots, kindly peruse the page number 15 and 16, Milots. In lower court order, Milots, clearly stated that he is involved in he is an habitual offender, Milots. He is involved in many crimes, Milots.
How many cases?
Milots,
There are not two, many cases.
Milots,
103.
in crime number 103 of
Crime number 95.
Bantwal Police Station for the offences 504, 324, 307, 506. Let's in crime number 15 of which was registered in SC number 15 of 20 minutes and the same is pending minutes and in crime number 95 minutes for the offences minutes 341, 504, 506, 326 minutes. And further minutes in crime number 1
Two.
Two.
Two of them.
There are two antecedents against this petition, my lords.
The-
And there are eyewitness to the
cases.
incident, my lords, and further, my lords, there was in a recovery, my lords.
Judicial
The
custody.
enlarged and bill.
Date of offense?
7/4/24, my lord.
You have committed the offense in 2020, 2022, again in 2024. How many eyewitnesses are there?
Complainant itself is I. There's no.
Injured eyewitness.
Injured eyewitness.
Let him be examined.
Complainant is that,
There are no other eyewitnesses.
there are no other I.
Where is the charge sheet?
That's at page number 22, my lord.
Material witness, examiner. No, not
Ready
entitled.
to abide by any condition may be.
No conditions. He
He
is
had
having the
already
criminal
approached in
antecedent.
the FIR stage and it was withdrawn with the liberty to file
No,
after charge.
nothing. Covered. The petitioner being the sole accused is seeking
Not-
grant of bail.
I withdraw.
Huh?
Permit me to withdraw.
Counsel for the petitioner, after addressing the argument for some time, seeks permission to withdraw the petition. Submission is placed on record, petition is dismissed as withdrawn. Yes, dismissed.
Those two cases is on the.
Ade mistake, 2020, 2022, 2024. Every 2 years he is committing the offense.
307 is there.
307, idu 307, earlier 307.
Financial transaction.
ಅದೇ ಅವ್ರು ಹೇಳಿದ್ರು ಫೈನಾನ್ಷಿಯಲ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಚೂರಿ ಹಾಕ್ಬಿಡು ಈಸಿ ರಿಕವರಿ
ಇಲ್ಲೂ ಟ್ರಯಲ್ ಆಗಿದೆ. ಇನ್ನೆರಡು ಕೇಸಲ್ಲೂ
ಆಗ್ಲಿ ನೆಕ್ಸ್ಟ್
liberty after examination of the injured.
with liberty to approach the trial courts with similar prayer after examination of the material witnesses. Yes.
Injured witness.
ಅದು ಯಾರು ಅಂತ ನೋಡೋಣ.
The injured only the complainant.
ಅವ್ರು ಇದ್ರೆ ಅವ್ರೊಬ್ರೆ ಮೆಟೀರಿಯಲ್ ವಿಟ್ನೆಸ್ ಅಷ್ಟೇ. ಪಂಚರೆಲ್ಲ ಮೆಟೀರಿಯಲ್ ವಿಟ್ನೆಸ್ ಅಂತ ಮಾಡಲ್ಲ. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Serial number 4, P. Sheshgiri Rao.
Sir.
Kindly have it passed over.
Hmm?
Kindly have it passed over, my lord.
So
Number 1.
Hmm?
11. For withdrawal.
which one?
This number 1. Serial number 11. Memo for.
ಏನಕ್ಕೆ?
It has been settled.
ಆಗೋಯ್ತು ಅದು ಡಿಸ್ಮಿಸ್ ಆಗಿತ್ತು. ನೆಕ್ಸ್ಟ್.
Passover matters, list 1, serial number 8, Lankeshel.
The one 20. Next, 1 minute. In which list?
List number 2.
Wait. Yes, serial number 10. Wait, ಆಯ್ತು ಪಾಸ್ ಓವರ್ ಆಯ್ತು ಮತ್ತೆ.
Serial number 10. Serial number 12, Subhash Reddy.
Next.
Serial number 13, Sudarshan AM. Serial number 14, Surendra Kumar.
Next.
Serial number 15, M. Srinivas Murthy.
Next.
Serial number 17, Ajay Jain.
My lords, appear for the petitioner, my lords. Needful has been done, my lords. I have taken the process. Steps has been taken.
17.
Please, my lords. I am for the petitioner.
I submit that. Needful.
Kindly interim order may be extended, my lords.
PF is already paid. Office to verify. If needful is done, interim order is extended, issue notice.
Much
Yes.
obliged.
List 2, serial number 1.
He has to report.
230, I'll file it.
Next.
Serial number 2, Sunil petitioner.
Notice ಹೋಗಿದೆ. ಅದಾಯ್ತಪ್ಪ, ಕೋರ್ಟ್ ನೋಟಿಸ್ ಹೋಗಿದೆ. ಏಕೆ? ಕೋರ್ಟ್ ನೋಟಿಸ್ ಅಂತ ಯಾಕೆ ಬರೆದ್ರು ಮತ್ತೆ? Issue court notice to the petitioner since the counsel representing the petitioner is elevated as a judge of this court, issue court notice to the petitioner. Yes, next.
Serial number 5, Harshit P.
Seek time may be granted, my lords.
Time for what?
Let's say, non-compliance raised by on IA1 filed by the learned HGP anta ide idralli. Just I'll inquire regarding this and have it on next week, my lord.
What is this IA?
ಅದು ಆಫೀಸಲ್ಲಿ ನಾನು ಅದು ಅದಕ್ಕೆ ಪಾಸ್ವರ್ಡ್ ಅವಾಗಲೇ ಕೊಟ್ಟಿದ್ದು ಅದು ಆಫೀಸಲ್ಲಿ
ಪಾಸ್ವರ್ಡ್ ಆಯ್ತು ಮತ್ತೇನು? ಯಾಕೆ ಫೈಲ್ಸ್ ಯಾವುದು ಇರೋದಿಲ್ವಾ?
ಅದು ಅಸ್ಮಾ ಮೇಡಮ್ ನೋಡ್ತಾ ಇದ್ರು ಮೆಲಾಟ್ಸ್. ಅವ್ರ ಹತ್ರ ಕೆಲವೊಂದು ಫೈಲ್ಸ್ ಎಲ್ಲ ಅವ್ರ ಹತ್ರ ಇದ್ಬಿಟ್ಟಿದೆ. ಅವ್ರಿಗೇನೋ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಆಗಿರೋದ್ರಿಂದ ಇವತ್ತು ನಾನು ಬಂದಿದ್ದೀನಿ ಸರ್. 482
ಇದು ಅದೇ ರೀತಿ ಆಯ್ತು. ಅವ್ರು ಕೇಳಿದ್ರೆ ನಿಮ್ಮ ಹತ್ರ ಫೈಲ್ ಇದೆ ಅಂತಾರೆ, ನೀವು ಕೇಳಿದ್ರೆ ಅವ್ರ ಹತ್ರ ಇದೆ ಅಂತೀರಿ.
ನಾನು 482
ಎಂಡ್ ರಿಸಲ್ಟ್ ಅಂದ್ರೆ ಇಷ್ಟೇ ಆಗೋಯ್ತು. Learned HCVP so and so has no idea about the application IA1 of 2023 and the objections raised on the same. Learned SPP is directed to look into the matter and direct the learned HCGP in this regard. This time. Next.
Serial number 6.
ಅದ್ರಲ್ಲಿ ಏನು interim order ಇದೆಯಾ?
Smart was dismissed for.
1 minute, sir. Earlier. ಕೊಡಿ. ಮತ್ತೆ ಅದಕ್ಕೆ ಈಗ ಅದೇನು ಬೇಡ. Counsel for the petitioner is the serial number ಮೊದಲಿಂದು. Counsel for the petitioner is absent no representation. Then HCP has no idea, so and so has no idea about IA1 of 2023. Of his objection raised on the application during 2023 is not yet complied with. Moreover, the interim order granted and extended till 22/4/2023 is not extended further. Else IA1 of 2023 is dismissed. As the same is rendered infructuous. Petition is of the year 2020. List finally has a last chance. Yes, 6.
Serial
My
number
lord.
6.
I beg to appear for. Just recalling application is filed, my lord, to.
Order sheet. How many recalling applications? How many orders
my
are to
lord.
be?
And my apologies, my lord, as, my lord, only objection is that, my lord, age is not mentioned.
Maybe.
That too, my lord, after. my
Even
lord,
that objection you are not complying with.
My lord,
Simple objection, one objection,
only one
not in a
objection, my lord.
position to comply with that. What is to be done? For years together, call on, list on.
Lordships may have it, my lord, this matter tomorrow itself, my lord, today itself, my lord, I will comply with this objections. my lord.
Comply with that.
I will
ಅದೇನು ಅದು ಇಲ್ಲ, ಎರಡು ಆರ್ಡರ್ ಇದೆಯಲ್ಲ.
I am permitted to comply, my lord, then the lordships may kindly hear me, my lord, on this application.
Another 1 or 2 years.
No, my lord, tomorrow, day after tomorrow, your lordship may have it.
Even after passing the preemptory order, there is no compliance.
I'll comply it now.
That shows the negligence.
ಅಲ್ಲಿ ನನಗೆ ರಿಪ್ರೆಸೆಂಟ್ ಮಾಡಿರೋದು ಎಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ಬಿಟ್ರು, ಅದಕ್ಕೆ I was,
ಎಲ್ಲ ಹೇಳ್ತಾರೆ.
I depend on my lords.
ಏನಿಲ್ಲ.
I personally do it, my lord. What to do?
Even after filing the
Everything is,
application for recalling, there was no representation.
My lord, I was held up in that the tax matter, my lord. Some
Cannot have
indulgence.
such lame excuses, sir.
Tomorrow, your lordships may have it, my lord, I'll get it rectified.
They are your colleagues.
My colleague,
Then what he was doing? I understand you are held up in some
no, my
court.
lord, in fact, my lord, he was interested, my lord, he could.
What the gentleman was doing? Roaming around the corridor. I can understand. Seniors
Lord,
cannot go and.
My lord, my position is that, my lord, I rely on, thing, my lord, they said that everything is compliant.
That is the mistake you are
I-
committing.
I personally comply with, my lord, let it be heard on merits, my lord.
There can- See, once it's okay,
Yes, my
something
lord.
else, and finally posted,
But
even
I'm-
then no compliance.
Your lordship,
And
my lord,
dismissed.
my lord, yes.
And even after recalling
is-
application,
recalling is-
absent. How many times?
Yeah.
Thrice.
There's a blunder. That's one indulgence, my lord, I personally seek one indulgence.
Counsel for the petitioner. Submits that he will apologize for the inconvenience caused to the court. The order sheet discloses that initially the office has raised objections. The same were not complied with. The preemptory order came to be passed on 12/6/2024. Even thereafter, the objections were not complied with. And therefore, as per order dated 6/8/2024, petition came to be dismissed. The petitioner filed IA 1 of 2024 for recalling the order dated 6/8/2022. When the matter was listed to hear the application on 10/9/2024, there was no representation. Therefore, the application came to be dismissed. Now IA 2 of 2024 is filed to recall the order dated 10/9/2024. This shows the gross negligence on the part of the petitioner in prosecuting the petition. Admil Hakil and counsel for the petitioner apologizes for the inconvenience caused. But I do not find any justification for the petitioner for not complying with the office objections in spite of passing the preemptory order and not there being any representation when the application for recalling the order dismissing the petition was filed. However, to afford final opportunity, the petitioner is permitted to comply with the office objections within 7 days from today, pending consideration of IA 2 of 2024 and 1 of 2024. List on, 7 ದಿನ ನಂತರ ಹಾಕಿ. You are permitted to comply with the office objections pending consideration of the application.
Please, I'll comply. Immediately I'll comply.
Serial number,
Much.
serial number 12, Satish K.
Senior is on his leg since he has to kindly have it. Kindly have it at 2:30 minutes.
2:30, I'm having other matters. How many times it is to be passed over?
Alert
From
senior is-
10:30 till 1 o'clock, he is on his legs. Huh? Who is the advocate? Satish, where is he? Continuously, from 10:30 to 1. In which court he is held up? I will inquire.
Senior is in CH2, my lords.
Huh?
Senior counsel MS Bhagat is in court all 2, my lords.
Maybe senior counsel may be arguing. Bhagwat had came here in between.
He is in court all 2 minutes.
I'll straight away dismiss the petition.
Fine, sir.
Pass over again. Next.
Serial number 15, Harish Kumar MS.
My lord, the petitioners.
Sorry.
The petitioner number 1 is the father,
What do you think?
2 is the mother, and 3 is the daughter.
They are
Lord,
read as accused number.
Please, ma'am.
Accused numbers.
Accused number, my lord, 7, 8, and 9.
7.
8 and 9.
In all, how many accused?
My lord, there are totally 9 accused.
What about other accused?
My lord, we are not concerned, they are the different persons.
They have not approached this
They
court.
have not approached.
Yes.
My lord,
What are the offense alleged?
the offense is under section the 3 and 4 of the Dowry Prohibition Act, 354A, subsection 1, clause 3, 494, 506, 354A, again it is admitted, 498A, 504, 149. My lord, the complainant is one Srimati Shabari Rao.
Hmm.
My lord, the gist of the complaint is that Shabari Rao has married one Manjunatha A.
He is accused number 1.
Yes.
Hmm.
My lord,
Number 2.
her marriage was taken place on 30/11/2015. My lord, in the complaint, there are series of allegations against the husband.
Let me understand the
Please.
relationship. Who is accused number 2?
Accused number 2 is the wife of one Manjunatha A. My lord, incidentally, my lord, with,
No, accused number 2.
yes, accused number 2, I will tell my lord. She is the wife of one Manjunatha A, with whom the petitioner number 3 has married subsequently. So there is no relation. The both petitioner number 3 and complainant, that is the accused number 2. My lord, your lordship has asked the complainant or accused number?
Accused number 2.
My lord, she is the mother of the relatives of the Manjunatha A.
Mother,
Mother,
not the wife.
not the.
A3.
My lord, father of the Manjunatha A. That is the accused number 1.
Then A4.
A4 is mother.
Mother of whom?
Accused number 1. 2 is brother.
Sir, what is
Sorry,
this?
my
Sir?
lord, I confused with this one. Accused number one.
Not
is the-
only you confused, you are
No, no,
confusing the
it's a
court
fine.
also.
My lord, I was.
Once you said he is the wife,
No, no.
once you said she is the mother.
I-
Now you are saying he is the brother.
Sorry, my lord, only with that I was confused. I was telling about the respondent number two over here. My lord, accused number one is the husband of complainant, two is the brother, three is the father, four is the mother. And five and six, my lord, they are the agents of accused number one.
Agents.
Means they are the one is his assistant. And at his instance, he did something to the accused number, the complainant. So they are the persons who are related to accused number one.
Yes, A7.
A7 is the petition number one here.
Whether he is related to accused number one.
No, ma'am.
Then why he is there?
Allah, he is related to accused number one as a father-in-law, second father-in-law. My lord, that's the reason I wanted to tell the facts. One fact first, then my lord.
First, you are not in a position to say the relationship.
No,
What
no.
facts you will say?
No, that's the reason, my lord. Then only it will be easy to tell that, my lord, the complainant is the wife of one Manjunatha, first wife of Manjunatha. Petitioner number three is the second wife. Then, my lord, the petitioner number one becomes the father-in-law of the accused number one. And mother-in-law, petitioner number two is the mother-in-law of the accused number one.
When he married accused number 9?
My lord, the marriage of the petition number 3, accused number 9, took place on 29/12/2017. My lord, the allegation in the complaint is that, my lord, the entire allegation is against the accused number 1 to 6. My lord, from the date of marriage, what are the pathetic situations she has undergone, she has stated in the complaint. My lord, in the whole this one, it was the case of the complainant is that the Manjunatha A, who supposed to be a doctor, he ill-treated her, demanded dowry, and also assaulted. And my lord, while stating that in page number 70, she has stated that, my lord, her husband and brother-in-law, my lord, by sending her out of the matrimonial home, got arranged the marriage with the petitioner number 3. That is the 2 line, page number 17. Para 2. ಈಗ ರಂಗನಾಥನೇ ಮುಂದೆ ನಿಂತು ಸಾಗರದ ಸಿಪ್ಪೆ ಮಂಜುನಾಥ ಎಂಬುವರ ಮಗಳ ಜೊತೆ ಮಂಜುನಾಥನ ಮದುವೆ ಮಾಡಿಸಿದ್ದಾನೆ. ನಮ್ಮ ನಡುವೆ ಡೈವೋರ್ಸ್ ಆಗಿಲ್ಲ. ಇಂಥದ್ದರಲ್ಲಿ ಮಂಜುನಾಥ 2ನೇ ಮದುವೆ ಮಾಡಿಕೊಂಡಿದ್ದಾನೆ. ಈ ಮದುವೆಗೆ ಕಾರಣಕರ್ತರಾದ ತಂದೆ ಅನಂತ ಶೇಟ್,
Who is Ranganatha?
ಬ್ರದರ್ ಆಫ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1. ಅನಂತ ಶೇಟ್, ತಾಯಿ ರೇಣುಕಮ್ಮ, ತಮ್ಮಂದಿರಾದ ರಂಗನಾಥ, ಶ್ರೀನಿವಾಸ, ಹೆಣ್ಣು ಕೊಟ್ಟಿರುವ ಸಿಪ್ಪೆ ಮಂಜುನಾಥ, ಅವರ ಪತ್ನಿ ಜಯಮ್ಮ, ಮಗಳು ದಿವ್ಯಾ, ಇವರೆಲ್ಲರೊಂದಿಗೆ ಪ್ರಮುಖ ಆರೋಪಿ ಮಂಜುನಾಥನನ್ನು ತಕ್ಷಣ ಬಂಧಿಸಿ ಉಗ್ರ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕು. My lord, the allegation is that the accused number 1 has married the accused number 9.
Yes.
That is the only allegations. My lord, as far as the petitioners are concerned, my lord, they were not aware of this marriage. This Manjunatha, who claims to be a doctor, my lord, he played a fraud upon the petitioners also.
That is to be unearthed during investigation.
My lord, as far as the allegations made in the complaint is concerned, except stating that the said accused number 1
Constitute an offense.
My lord, it will not. That is what my humble sir. Section 494. My lord, here the petitioner, petition number 3 also filed the complaint against the husband, divorce petition, everything, my lord. Even he has cheated the petition number 3 also. My lord, may I read, my lord? Whoever having a husband or wife leaving marries in any case in which such marriage is void by reason of its taking place during the life of such husband or wife shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. Then, my lord, the exception has been given. And my lord, the essential ingredients also stated. A person has a spouse living, he marries again. And my lord, the second or subsequent marriage is void by reason of its taking place during the life of such spouse. The case does not fall within the exception. My lord, my humble submission is that here, my lord, the complainant can maintain the complaint only against the husband, not against the others. The allegations, my lord, there is no scope under section 494 to prosecute, my lord, the petition number 3.
Yes.
Therefore, my lord, except this allegation, my lord, none of the allegations made in the complaint applies to the
Are you
petition.
supported by any
Yes.
decision?
Short judgment, my lord. Here also the similar circumstances.
No, where is the principle of law laid down?
My lord, the principle, in para 5, it has been stated.
Yes.
The Honorable Supreme Court in the case of Lingari Obulama
You
versus.
give that decision.
Please, my lord.
You give that decision.
That decisions, my lord, I'll place it, my lord. My lord, next, my lord, the para 6. In the instant case, there is no averments made in the complaint that the marriage of the accused number 1 with accused number 2 was valid and strictly according to law governing the parties. Even otherwise, the allegation of contracting of second marriage is against the accused number 1. There is no averment that these accused instigated the accused number 1 to contract the second marriage with the accused number 2. Hence, in the absence of essential ingredients,
Supreme Court decision.
that I'll place it.
Citation you can read 2000. Yes.
I'll place it.
What because there are the Supreme Court decision ಅಲ್ಲಿ relay ಆಗಿದ್ದಾರೆ, you are not citing that.
I was on the point that, my lord, there was laid upon para 6 of that, my lord. That's it. I'll place it.
No principle of law is laid down there.
No,
There is a reference to the decision of the Honorable Apex Court.
Correct.
You have to rely on that.
That is regarding.
Not on the coordinate bench decision,
Yes, I'll,
where no law is laid down.
please. I'll place it. May I request it, my lord, to have it tomorrow, my lord. Today I have some.
ತಗೊಂಬನ್ನಿ ಮಧ್ಯಾಹ್ನ ಬಾ.
Today I have some inconvenience, my lord. Tomorrow.
Otherwise, I'll hear her and proceed. Next.
Serial number 16, Basavaraju. Basavaraju ki.
Sorry, my morning I was held up in quota number 10, my lord, sorry. The offense, my lord, the section 498A IPC and section 3 and 4 of Dowry Prohibition Act. The present petitioners are the accused numbers 1 to 3. There are no other accused.
Yes. What is their relationship?
The first petitioner is husband. Second petitioner is father-in-law. Third petitioner is mother-in-law.
Date of marriage?
The date of marriage 11/4/1996.
Date of complaint?
24/1/2018. Ma'am.
What is the allegation?
My lord, the allegations, my lord, lord, kindly come to the my lord, gist of the charge sheet, page number 28. May read column number 7. ಸಾಕ್ಷಿ ಒಂದರವರು ಕಲಂ ನಂಬರ್ 2ರಲ್ಲಿ ನಮೂದಿಸಿರುವ A1 ಆರೋಪಿಯನ್ನು 11/4/96 ಹಿಂದೂ ಸಂಪ್ರದಾಯದಂತೆ ಗುರು ಹಿರಿಯರ ಸಮಕ್ಷಮ ಆಂಧ್ರ ಪ್ರದೇಶದ ವಿಜಯವಾಡ ದನೇಕುಲ ವೆಂಕಟ ಸುಬ್ಬಯ್ಯ ಕಲ್ಯಾಣ ಮಂಟಪದಲ್ಲಿ ಮದುವೆಯಾಗಿದ್ದು, ಮದುವೆಯ ಸಮಯದಲ್ಲಿ A1 ಆರೋಪಿಗೆ ಸಾಕ್ಷಿ ಒಂದರವರ ತಂದೆಯವರಾದ ಲೇಟ್ ಹನುಮಂತರಾವ್ ರವರು ವರದಕ್ಷಿಣೆಯಾಗಿ 15 ಲಕ್ಷ ನಗದು ಹಣ, ಒಂದು ಕತ್ತಿಗೆ ಚಿನ್ನದ ಚೈನ್, ಒಂದು ಡೈಮಂಡ್ ಉಂಗುರ, ಒಂದು ಚಿನ್ನದ ಬ್ರಾಸ್ಲೈಟ್ ನೀಡಿರುತ್ತಾರೆ. ಸಾಕ್ಷಿ ಒಂದರವರಿಗೆ 4 ಜೊತೆ ಚಿನ್ನದ ಬಳೆಗಳು, 3 ಜೊತೆ ನೆಕ್ಲೆಸ್, 4 ಉಂಗುರ, 8 ಜೊತೆ ಕಿವಿಯ ಓಲೆಗಳು, ಡಾಬು ಚಿನ್ನದ ಮಾಟಿಗಳು, ಚಿನ್ನದ ಬೈತಾಳಿಯ ಮಣಿ, ಚಿನ್ನದ ಕಾಲು ಚೈನು, ಚಿನ್ನದ ಬ್ರಾಸ್ಲೈಟ್, ಸುಮಾರು 10 ಲಕ್ಷ ಬೆಲೆ ಬಾಳುವ ಒಡವೆಗಳನ್ನು ನೀಡಿದ್ದು. ನೆಕ್ಸ್ಟ್ ಲೈನ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್. ಮದುವೆಯಾದ ನಂತರ ಸಾಕ್ಷಿ ಒಂದರವರು A1, A2, A3 ಆರೋಪಿಗಳು ದಾವಣಗೆರೆ, ವಿದ್ಯಾನಗರ ಮತ್ತು ಪಾವನಹಳ್ಳಿಯಲ್ಲಿ ವಾಸ ಮಾಡಿಕೊಂಡಿದ್ದ ಸಮಯದಲ್ಲಿ ಸಾಕ್ಷಿ ಒಂದರವರಿಗೆ A1, A2, A3 ಆರೋಪಿಗಳು ಸಮಾನ ಉದ್ದೇಶದಿಂದ ನಿನ್ನ ತವರು ಮನೆಯಿಂದ ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆ ಹಣ ತರುವಂತೆ ಒತ್ತಾಯ ಮಾಡುತ್ತಿದ್ದು. 2008ನೇ ಸಾಲಿನಲ್ಲಿ ಉಳಿಮಾವು ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿನಲ್ಲಿ ನಂಬರ್ A-401 ಪೂರ್ವ ಪನೋರಮಾ ಅಪಾರ್ಟ್ಮೆಂಟ್ B ರಸ್ತೆ ಕಾಳಿನಾಗ್ರಹಾರ, ಬೆಂಗಳೂರು ನಗರದಲ್ಲಿ A1 ಮತ್ತು ಸಾಕ್ಷಿ ಒಂದರವರು ತನ್ನ 2 ಮಕ್ಕಳ ಜೊತೆ ವಾಸ ಮಾಡಿಕೊಂಡಿದ್ದು. A1 ಆರೋಪಿಯು ಕೆಲಸಕ್ಕೆ ಹೋಗದೆ ಪ್ರತಿ ದಿವಸ ಮದ್ಯಪಾನ ಮಾಡಿಕೊಂಡು ಬಂದು ಮಕ್ಕಳ ವಿದ್ಯಾಭ್ಯಾಸಕ್ಕೆ ಶುಲ್ಕವನ್ನು ಕಟ್ಟದೆ ಸಾಕ್ಷಿ ಒಂದರವರಿಗೆ ನಿನ್ನ ತವರು ಮನೆಯಿಂದ ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆ ತರುವಂತೆ ಒತ್ತಾಯ ಮಾಡುತ್ತಿದ್ದು. A2 ಮತ್ತು A3 ಆರೋಪಿಗಳು ಆಗಾಗ್ಗೆ ಬಂದು A1 ಆರೋಪಿಗೆ ಹೇಳಿಕೊಟ್ಟು ಸಾಕ್ಷಿ ಒಂದರವರಿಗೆ ನಿನ್ನ ತವರು ಮನೆಯಿಂದ ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆ ತರುವಂತೆ ಒತ್ತಾಯ ಮಾಡುತ್ತಿದ್ದು. 2015ನೇ ಸಾಲಿನಲ್ಲಿ A1, A2, A3 ಆರೋಪಿಗಳು ಸೇರಿಕೊಂಡು ಸಾಕ್ಷಿ ಒಂದರವರನ್ನು ನಿನ್ನ ತವರು ಮನೆಯಿಂದ ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆ ಹಣವನ್ನು ತರುವಂತೆ ಮಾನಸಿಕವಾಗಿ ಮತ್ತು ದೈಹಿಕವಾಗಿ ಹಿಂಸೆಯನ್ನು ನೀಡಿ ಸಾಕ್ಷಿ ಒಂದರವರ ಮಕ್ಕಳಾದ ಸಾಕ್ಷಿ 2 ಮತ್ತು ಸಾಕ್ಷಿ 3ರವರನ್ನು ಮನೆಯಿಂದ ಹೊರ ಹಾಕಿರುವುದು ತನಿಖೆಯನ್ನು ದೃಢಪಟ್ಟಿದೆ. My lord, on 28/9/2015,
Yes.
28/9/2015, the respondent number 2 had filed the petition under section 12 of the Protection of Women from Domestic Violence Act and sought for
What is the
severity.
date? What is the date?
28/9/2015.
Hmm.
But page number 51 is the petition. Well, but I may be permitted to read 4 lines, my lord. It was filed on 28/9/2015. But kindly come to page number 55, para number 11. Para number 11, page 55.
Yes.
It is submitted that in the year 2008, as per the instructions of the respondent number 2 and 3, the petitioners number 2 and 3 hearing. The petitioner and the respondent number 1 have leave the matrimonial house and live in a rented house in Bangalore and paying rent a sum of rupees 20,000. It is submitted that as per the promise, the respondent numbers 2 and 3 have failed to send a sum of rupees 5 lakhs to the petitioner, but they send only 40,000 per month. Now, my lord, from the year 2008, petitioners number 2 and 3 are residing, my lord, permanently at Davangere. They have never resided along with the respondent number 2. Then, my lord, kindly come to page number 58, para number 15. When the cause of action was aroused to file the petition, page 58. Para 15. The cause of action arose in the month of June 2012, and many more previous and subsequently continuously physical and mental torture by the respondent, hence which is within the jurisdiction of this honorable court. 2012 cause of action was aroused to make such allegations. 2018 the complaint was filed after lapse of 6 years. Now, my lord, the further truth has been revealed by the respondent number 2 in her own further statement. My lord, kindly come to page number 34. Page number 34 is the further statement of the respondent number 2 herein. My lord, the relevant, my lord, kindly turn to the next page, my lord. My lord, page number 35 ಅಲ್ಲಿ from the top, my lord, 4th line. ಸಹ ನೀಡುತ್ತಿರಲಿಲ್ಲ ಫುಲ್ ಸ್ಟಾಪ್ ಆದ್ಮೇಲೆ ಮದುವೆಯಾದ 10 ವರ್ಷಗಳ ನಂತರ ನಾನು ನನ್ನ ಗಂಡ ಮತ್ತು ಇಬ್ಬರು ಮಕ್ಕಳು ದಾವಣಗೆರೆಯಿಂದ ಬೆಂಗಳೂರಿಗೆ ಬಂದು ಬನ್ನೇರುಘಟ್ಟ ರಸ್ತೆ ಕಾಳೇನಗಾಗ್ರಹಾರದ ಪೂರ್ವನರೋಮ ಅಪಾರ್ಟ್ಮೆಂಟ್ ನ ಫ್ಲಾಟ್ ನಂಬರ್
para number 1 or 2?
ಎರಡು ಪೇಜ್ ನಂಬರ್ 35 ಅಲ್ಲಿ ಟಾಪ್ ಇಂದ 4th ಲೈನ್ ಮದುವೆಯಾದ ಅಂತ ಬರುತ್ತೆ. ಮದುವೆಯಾದ 10 ವರ್ಷಗಳ ನಂತರ ನಾನು ನನ್ನ ಗಂಡ ಮತ್ತು ಇಬ್ಬರು ಮಕ್ಕಳು ದಾವಣಗೆರೆಯಿಂದ ಬೆಂಗಳೂರಿಗೆ ಬಂದು ಬನ್ನೇರುಘಟ್ಟ ರಸ್ತೆ ಕಾಳೇನಗಾರದ ಪೂರ್ವ ಪುನೋರಮ ಅಪಾರ್ಟ್ಮೆಂಟ್ ನ ಫ್ಲಾಟ್ ನಂಬರ್ A401 ಮನೆಯಲ್ಲಿ ಸುಮಾರು 2008ರಿಂದ 2015ವರೆಗೆ ವಾಸ ಮಾಡಿಕೊಂಡಿದ್ದೆವು. ಇಲ್ಲಿ ಪಿಟಿಷನರ್ಸ್ ನಂಬರ್ 2 and 3 ರೋಲ್ ಇಲ್ಲ. ನನ್ನ ಗಂಡ ಶ್ರೀಕಾಂತ್ ಎಲ್ಲಿಯೂ ಕೆಲಸಕ್ಕೆ ಹೋಗದೆ ಪ್ರತಿದಿನ ಮದ್ಯಪಾನ ಮಾಡಿಕೊಂಡು ಬಂದು ನಿನ್ನ ತವರು ಮನೆಯಿಂದ ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆ ಹಣವನ್ನು ತೆಗೆದುಕೊಂಡು ಬಾ ಎಂದು ಹಿಂಸೆ ಕೊಡುತ್ತಿದ್ದರು. ನಾನು JP ನಗರ 7ನೇ ಹಂತದಲ್ಲಿ ಕರಿಪಾಟ್ಸ್ ಎಂಬ ಹೆಸರಿನ ಮೆಸ್ ಅನ್ನು ಇಟ್ಟುಕೊಂಡು ಜೀವನಕ್ಕೆ ಬೇಕಾದ ಸಂಪಾದನೆಯನ್ನು ಮಾಡಿ ಮಕ್ಕಳನ್ನು ಓದಿಸುತ್ತಿದ್ದೆನು. ಬೆಂಗಳೂರಿನ ನಮ್ಮ ಮನೆಗೆ ಆಗಾಗ್ಗೆ ನಮ್ಮ ಮಾವ ಪೂರ್ಣಚಂದ್ರರಾವ್, ಅತ್ತೆ ಎನ್ ರಮಣಿಯವರು ಬಂದಾಗ ಅವರುಗಳು ನನ್ನೊಂದಿಗೆ ಸರಿಯಾಗಿ ಮಾತನಾಡದೆ ನನ್ನ ಗಂಡನಿಗೆ ಹೇಳಿಕೊಟ್ಟು ವರದಕ್ಷಿಣೆಯ ಹಣವನ್ನು ಪಡೆದುಕೊಂಡು ಬರುವಂತೆ ನಿನ್ನ ಹೆಂಡತಿಗೆ ಹೇಳು ಎಂದು ಎಲ್ಲರೂ ಸೇರಿಕೊಂಡು ನನಗೆ ಮಾನಸಿಕವಾಗಿ ಹಿಂಸೆ ನೀಡುತ್ತಿದ್ದರು. ನಾನು ದಾವಣಗೆರೆಗೆ ಹೋದಾಗ ನನಗೆ ವರದಕ್ಷಿಣೆ ಹಣ ತರುವಂತೆ ನನ್ನ ಗಂಡ, ಅತ್ತೆ, ಮಾವನವರು ಹಿಂಸೆ ನೀಡುತ್ತಿದ್ದರು. ನಾನು ನನ್ನ ಮಕ್ಕಳ ಭವಿಷ್ಯಕ್ಕೆ ಯಾವುದೇ ತೊಂದರೆ ಆಗಬಾರದು ಎಂದು ಸುಮ್ಮನೆ ಇದ್ದೇನು. ನೆಕ್ಸ್ಟ್ ಲೈನ್ ಇಸ್ ದಿ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಈಗ್ಗೆ 3.5 ವರ್ಷಗಳ ಹಿಂದೆ ನನ್ನ ಗಂಡನಾದ ಶ್ರೀಕಾಂತ್, ಅತ್ತೆಯಾದ ರಮಣಿ, ಮಾವನಾದ ಪೂರ್ಣಚಂದ್ರರಾವ್ ರವರುಗಳು ಸೇರಿಕೊಂಡು ನಿನ್ನ ತವರ ಮನೆಯಿಂದ ವರದಕ್ಷಿಣೆ ಹಣವನ್ನು ತೆಗೆದುಕೊಂಡು ಬಾ ಎಂದು ನನ್ನನ್ನು ಮತ್ತು ನನ್ನ ಮಕ್ಕಳನ್ನು ಮನೆಯಿಂದ ಹೊರಗೆ ಹಾಕಿದರು. ನಂತರ ನಾನು ಜ್ಞಾನಪ್ಪನಲ್ಲಿರುವ ಮಾನ್ಯ ಅರೇನಾ ಅಪಾರ್ಟ್ಮೆಂಟ್ ನಂಬರ್ 205ರಲ್ಲಿ ವಾಸ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. The alleged incident was taken place 3 years much prior to the filing the complaint. Then, my lord, further relevant, my lord, page number 32 is the spot measure. Page number 32, my lord. From bottom 10th line, my lord. Page number 32. From bottom 10th line. ನಾನು ವರದಕ್ಷಿಣೆ ನಾನು ವರದಕ್ಷಿಣೆ ಹಣವನ್ನು ತರದೇ ಇದ್ದಾಗ ನನ್ನ ಗಂಡ, ಮಾವ ಮತ್ತು ಅತ್ತೆರವರು ನನಗೆ ಈಗ್ಗೆ 3 ವರ್ಷಗಳ ಹಿಂದೆ ನನಗೆ ಇದೇ ಮನೆಯಲ್ಲಿ ವಾಸ ಮಾಡುತ್ತಿದ್ದ ಸಮಯದಲ್ಲಿ ನನಗೆ ಮಾನಸಿಕವಾಗಿ ಮತ್ತು ದೈಹಿಕ ಹಿಂಸೆ ನೀಡಿ ವರದಕ್ಷಿಣೆಯನ್ನು ತರುವಂತೆ ಹಿಂಸೆ ನೀಡಿರುತ್ತಾರೆಂದು ನುಡಿದು ಸ್ಥಳವನ್ನು ತೋರಿಸಿದರು.
Yes.
Now, my lord, under the DV Act proceedings, my lord, there was an order to refer the mediation. My lord, it's available at page number 78. My lord, this order has been passed by the Lord Magistrate on 16/7/2016, page number 78. my lord.
Yes.
Both parties present, both advocates present, joint memo filed seeking refer the matter to the mediation center. Heard, perused the papers. This court find the existence of elements of settlement between the parties. This court satisfied to refer the matter to mediation center. Accordingly, I pass the following. The matter is hereby referred to mediation center. Both parties are directed to appear before the Bangalore Mediation Center.
What happened to me?
Now, my lord, she has also filed a suit for partition. She also filed the petition for proceedings under section 125 of CRP. But my respectful submission, my lord, on the grounds is, but the 3 years after the alleged incident, the complaint is time barred, not maintainable. The Honorable Supreme Court may pass it. Para number 12, my lord.
Para number
12. After considering the decisions of this court rendered in Vanka Radha Manohare versus Vanka Venkata Reddy, 1993, 3 SEC 4, and Arun Vyas versus Vanit Vyas, 1994, volume 4 SEC 690, and decision of the High Court of Delhi in Asha Ahuja versus Ravesh Ahuja, reporting so and so. The High Court held as under. As noted above, the allegations of the complaint are of harassment by the petitioners 1 and 2, i.e. the husband and mother-in-law. Admittedly, respondent number 2 and petitioner number 1 are living separately since June 10, 2009. And there is no material to show that due to reconciliatory measures or for what reason the respondent number 2 failed to file the complaint on which the aforementioned FIR was registered till 28 January 2013. Beyond the period of limitation of 3 years. Thus, there being no justification for the delay in filing the complaint beyond the period of limitation, and there being no allegation that the physical and mental harassment continued against respondent number 2 beyond June 10, 2009, petitioners 1 and 2 are not liable to be prosecuted under section 498 of IPC. However, as noted above, section 406 is a continuing offense, and every day of non-return of Sridhana articles would give fresh cause of action. Admittedly, after the registration of FIR, petitioner number 1 sought to return certain Sridhana articles, thereby forfeiting the claim of the breach of trust. However, one of the necessary ingredients for offense punishable under section 406 of IPC.
406 ಇದೆಯಾ ಇದರಲ್ಲಿ?
My lord?
Whether 406 is invoked in
No,
this case?
we are not.
Why are you reading that?
Then, my lord, pair number 13, my lord, by as regards the finding recorded by the High Court in respect of complaints / FIR filed under section 498 IPC, we are of the firm opinion that the same does not call for interference. In the facts of this case, it is clear that the FIR filed in this regard in the year 2015 was time barred. Having been filed much more than 3 years after the separation of Manish Karla husband and Silpa Karla wife and the filing the divorce petition by the husband both in 2009. In the facts of the case, for the reasons given by the High Court for quashing the proceedings under section 498 IPC are justified and do not call for interference by this.
In this case, no petition for divorce?
No.
Maintenance petition.
Maintenance proceedings
Maintenance
are
petition
pending.
is pending.
Yes.
Oh, my lord, along with the memo, my lord, I have given 2 judgments. My lord, coordinate bench of this honorable court. But it was filed on 17/1/2022. My lord, similar facts and circumstances. My lord, here admittedly, my lord, the allegations have been.
What about accused number 1?
But the accused number 1 is concerned also, my lord, 3.5 years he has been elapsed. The allegations, my lord, appreciated, my lord, the complaint, further statement, and the spot murder. 3.5 years has been.
Allegation against the husband, not against the in-laws.
But my lord, 3.5 years, my lord, he is living separately. My lord, the admittedly DV proceedings are pending before the husband and wife. Well, 3 years, my lord, as per the judgment of the Honorable Supreme Court, even against the husband also, my lord, the affair has been quashed. It is an admitted fact, my lord, the husband also living separately 3.5 years, much prior to filing the complaint. But the further, my lord, page number, my lord, the 32 is the spot measure I have read, my lord. Page number 30. Page number 32 only. From the bottom 10th line.
Yes, that is there, of course, 3.5 years. Even later, thereafter, you stayed with the respondent number 2.
My lord, as per the domestic DV proceedings, my lord, 2012, my lord, cause of action was aroused. My lord, they are living separately. Well, that is the reason I have read over the cause of action.
Where she has stated we are residing separately.
Well, the further statement of the complainant is suffice, my lord. Kindly, my lord, my lord, page number 35 ಅಲ್ಲಿ 2008 ಇಂದ 2015 ವರೆಗೆ ವಾಸ ಮಾಡಿಕೊಂಡಿದ್ದೇವೆ ಅಂತ ಅವರೇನೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ. May I read, my lord, once again? Page number 30.
That is there. Then
please.
What happened thereafter?
My lord, the domestic violence proceedings are is going on. Both husband and wife are fighting. 125.
She has stated that I am residing separately.
My lord, see herself, page number 37 ಅಲ್ಲಿ ವಾಸ ಮಾಡಿಕೊಂಡಿದ್ದೆವು ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಸರ್.
ಇಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 35 ಅಲ್ಲಿ ಸುಮ್ಮನೆ ಪೇಜ್ ನಂಬರ್ 35 ಅಲ್ಲಿ ಮೇಲೋಡ 4th ಲೈನ್. ಮದುವೆಯಾದ 10 ವರ್ಷಗಳ ನಂತರ ನಾನು ನನ್ನ ಗಂಡ ಇಬ್ಬರು ಮಕ್ಕಳು ದಾವಣಗೆರೆಯಿಂದ ಬೆಂಗಳೂರಿಗೆ ಬಂದು ಬನ್ನೇರುಘಟ್ಟ ರಸ್ತೆ ಕಾಳೆನಗರದ ಪೂರ್ವ ಪುನೋರಮ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಫ್ಲಾಟ್ ನಂಬರ್ A 401 ಮನೆಯಲ್ಲಿ ಸುಮಾರು 2008 ರಿಂದ 15ರವರೆಗೆ ವಾಸ ಮಾಡಿಕೊಂಡಿದ್ದೆವು. So therefore, my lord, my respectful submission, but the complaint is time barred. Let's liability be quashed. But the FIR has been filed, my lord, after lapse of nearly 22 years from the date of the marriage, having 2 kids. The only, my lord, for the purpose of the property and other aspect, but
Yes, continue at 2:30.
please.
Yeah, date one submission to law.
Submission.
In number 12, I am ready, but one more petition by the same petitioner is pending. Petition number 3732 of 19.
12. Serial number 12.
12.
Ah.
There one more petition was pending before this court. Criminal petition number 3732 of 2019.
She could have stated in the morning itself.
He did not know, my lord.
Why Passover, senior is coming, senior is
No,
coming.
I was ready in the morning. I came, my lord. I thought of coming, my lord. I was held up in court too.
That's
Came
all
running.
right. But why this,
Yes,
this is not mentioned?
It's a just entrance, my lord. But hardly about 4 months back.
3732.
Yes, 2009.
Then the counsel for the petitioner submits that writ petition number 3732 of 2019 is connected with the present petition. This is directed to list both the cases together. Next. Yes.
Which date, ma'am?
Yes, it will be listed together.
Interim order may be considered.
Interim order is extended. Yes.
Item number 20, second is, the petitioner house is not able to connect due to some technical problem. So we currently
Hold on, ಅದೇನು finally ಆಗಿರ್ಬೇಕು.
we have not done, this is the first time he is connecting with the VC, so the registration problem. he could
ಅದೇನು
not
finally
attend.
ಆಗಿದೆ.
Kindly attend the matter. Praise for it.
Counsel for the petitioner prays for time. Petition is of the year 2020 list finally as a last. Yes. Right. Next.
Serial number 20. ಭಾಗವತ್ ಸರ್ ಬಂದು ಭಾಗವತ್ ಸರ್ 12 ಸರ್ ಆಗಿದೆ ನಾವು ರಿಪೋರ್ಟ್ ಹಾಕ್ತಿದ್ದಾರೆ ಲಿಸ್ಟ್ 12 ನಮ್ಮ ಅರ್ಜೆಂಟ್ ಇದ್ದಾರೆ ನಾವು ರಿಪೋರ್ಟ್ ಹಾಕ್ತಿದ್ದಲ್ಲ ಡೇಟ್ ಬೇಕಾ ಕಸ್ಟಡಿ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ನೀವು ಅದು ತಗೊಂಡಿರೋದಕ್ಕೆ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ರಾ ಮತ್ತೆ
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಡೇಟ್ ಕೊಟ್ರಾ ಲಿಸ್ಟು 12 13
serial number 20 yes 1410 ಭಾಗವತ್ ಸರ್
ಸೀರಿಯಲ್ ನಂಬರ್ 12
1
ಅದೇ ನಮ್ದೇ
ಯಾವುದು
ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 12
serial number 12 ಭಾಗವತ್ ಸರ್ ನಿಮಿಷ ಇದು
23rd ಹಾಕೋದು 23rd
23rd
ಮೇಡಮ್ ಯಾವ ಡೇಟ್ಗಾದ್ರೂ ಅದೇ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಅಂತಾನೆ ಹೇಳು ಅಂತ ಹೇಳಿದಾರ 21 ಹಾಕೊಳ್ಳಿ ಹಂಗಾರೆ 21 ಹಾಕೊಳ್ಳಿ 21 ಹಾಕೊಳ್ಳಿ ಅಲ್ಲ 23 ಇಲ್ಲ 21 ಅಲ್ಲ 30 ಆಗಲ್ಲ 23 ಹಾಕಿ ಇಲ್ಲ 21 ಹಾಕಿ 24 ಹಾಕಿ
24 ಮಾಡ್ಬೋದಾ ಸರ್
ಬೇಡ 24 ಮಾಡಿ ಇಲ್ಲ ಆಗಲ್ಲ ನಾನು ಇಲ್ಲ ಬೇಕಾದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ 2:30 ಅಲ್ಲ
ಮೇಡಮ್ have I not made submission to date ಕೊಡಿ ಅಂತ ಹೇಳಿ
ಹೇಳಿದಿರ ಸರ್
ಅಲ್ಲ 30th ಗಲ್ಲ ಡೇಟ್ ತಾವು
ಅಲ್ಲ ಕೋಆರ್ಡಿನೇಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್ ಯಾವ್ದಾದ್ರು
ಇಲ್ಲ
24th ಕೊಡ್ಲಾ
ಕೊಡಿ
24th ಸರ್
ಆಗಲ್ಲ ಮೇಡಮ್ 24th ಬೇರೆ ಹೆಂಗಿದೆ 30th
ಹಂಗಾರೆ ಈಗ 21st ಹಾಕೊಳ್ಳಿ ಅಥವಾ 20th ಹಾಕೊಳ್ಳಿ ಇಲ್ಲ ನಾನು ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ
ಮೇಡಮ್ ಅವ್ರು ಮೆನ್ಷನ್ ಮಾಡಿ
21st
ಹಾಕೊಳ್ಳಿ
ಬೇಡ ಮೇಡಮ್ ಅವ್ರು ಮೆನ್ಷನ್ ಮಾಡಿ
ಮೆನ್ಷನ್
ಮಾಡಿ
ಮೆನ್ಷನ್ ಮಾಡಿ ಡೇಟ್ ತಗೊಳ್ಳಿ ಸರ್ ಅಷ್ಟೇ ಇಬ್ರಿಗೂ ಕನ್ಫ್ಯೂಷನ್ ಇದ್ರೆ ಮೆನ್ಷನ್
ಕನ್ಫ್ಯೂಷನ್ ಅಲ್ಲ ಈಗ ಶಾರ್ಟ್ ಡೇಟ್ ತಾನೇ ಕೊಡ್ಬೇಕು
ಬೇಡ ಅವ್ರು ಡೇಟ್ ನಾನು ಕೇಳಿದ ಡೇಟ್ ಅಲ್ಲ ನೀವು ಕೇಳಿ
ಆಯ್ತಾ
ಆಯ್ತು ಫ್ಯಾಮಿಲಿ ಆಗ್ತೀವಿ ಮತ್ತೆ
ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಅಂತ ಒಂದು ಡೇಟ್ ಕೊಡ್ತಾರೆ ಫೈನಲಿ ಅಂದಾಗ ಡೇಟ್ ಕೊಡ್ತಾರೆ ಮೇಡಮ್ ಅದಕ್ಕೆ ಅಲ್ಲಪ್ಪ ಇಬ್ರು ಮಾತಾಡಿ ಹೇಳಿ
ಸೀನಿಯರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೇಳಿದಾರಲ್ಲ ಡೇಟ್ ಕೊಡಿ 23rd ಗೆ ಸೀನಿಯರ್ ಕೇಳಿದ್ರಲ್ಲ
ಮೆನ್ಷನ್ ಮಾಡಿ ಸರ್ ನಾನು ಕೇಳಿದೆ ನಾನು ಕೇಳಿದೆ ಡೇಟ್ ಕೊಡಿ ಅಂತ ಕೇಳಿದೆ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೇಳಿದಾರಂತಲ್ಲ
ನಾನು
ಡೇಟ್ ಅಂದ್ರು ಸರ್ ಅಷ್ಟೇ ಡೇಟ್ ಅಂದ್ರು ಸರ್
ಆಯ್ತು 2:30 ಬರ್ತೀನಿ ಅಲ್ಲಿ ತನಕ ಡೇಟ್ ಕೊಡ್ಬೇಡಿ
ಇಬ್ರಿಗೆ ಹೇಳೇ ಬರೋದು ಡೇಟ್ ಹೇಳಿದ್ದಾರೆ ಒಂದು ಡೇಟ್ ಅವ್ರಿಗೆ ಕೇಳಬಾರ್ದು ಕೊಟ್ಕೊಳ್ಬೇಕು
ಈ ಡೇಟ್
ಮೇಡಮ್ ಹತ್ರ ಮಾತಾಡ್ಬಿಟ್ಟು ಕೇಳಿದಾರೆ ಅಂದ್ಬಿಟ್ಟು ಮೇಡಮ್ 21st ಇಲ್ಲ 24 ಅಲ್ಲಿ ಕೊಡೋಣ ಮೇಡಮ್ ಇದಿರ್ಬೇಕು ಮೇಡಮ್ ಅದ್ರಲ್ಲೇನೋ ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡ್ರಿ ಏನು ಕೇಳಲಿಲ್ಲ, ಮಾರ್ಕ್ ಮಾಡ್ತಾರೆ ಪರವಾಗಿಲ್ಲಲ್ಲ. ಹೇಳ್ತೀನಿ.
ನಂಬರ್ 1 ಅಲ್ಲಿ ಎಲ್ಲ ಪಾಸ್ ಆಗುವಾಗ ಯಾವ್ದು BH ಆಗಲಿಲ್ಲ. BH ಗೆ ಲಾಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 17 ಮಾತ್ರ ಆಗಿತ್ತು ಬಿಡಿ.
ಓಕೆ.
ನಂಬರ್ 2 ಅಲ್ಲಿ ನಿಮಿಷ ಹಾಗೆ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ಕೋರ್ಟ್ ನೋಟಿಸ್
ಕೋರ್ಟ್ ನೋಟಿಸ್ 1510. ಓಕೆ.
ನಂಬರ್ 5 ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಆಯ್ತಾ BH ಗೆ?
ಸೀರಿಯಲ್ ನಂಬರ್ 5 BH ಗೆ ಆಯ್ತು, ಫೈನಲಿ ಅಂತ ಆಯ್ತು. 30 ಆಮೇಲೆ ಇಯರ್ ಡಿಸ್ಮಿಸ್ಡ್ ಅಂತೇನೋ ಹೇಳಿದ್ರು.
ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಗೆ ಏನ್ ಹೇಳಿದ್ರು?
6 ಗೆ ಫೈನಲಿ ಅದೇನೋ 7 days ಒಳಗೆ ಏನೋ ಮಾಡ್ಬೇಕು ಅನ್ನೋಂಗೆ 24/9 ಮೇಡಮ್.
24/9 ಅಪ್ಡೇಟ್ ಮಾಡಲ್ಲ ಬಿಡಿ.
12 ಕನ್ಫ್ಯೂಷನ್. 15 ಪಾಸ್ ಓವರ್. 16 ನಡೆಯುತ್ತೆ ಇವಾಗ, ಮಧ್ಯಾಹ್ನ ಬರ್ತೀನಿ ಅಂದ್ರಲ್ಲ ಅದು. 18 ಪಾಸ್ ಓವರ್ ಇನ್ನೂ ಆಗಿಲ್ಲ. 20th ಮಧ್ಯದಲ್ಲಿ ಕೇಳಿದ್ರು, ಅದು 1410. ಓಕೆ.
21 ವಿಡ್ರಾ.
ಇದರಲ್ಲಿ ಲಿಸ್ಟ್ 3 ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ನ ಕೊಡಕ್ ಹೋಗಿಲ್ಲ. ಆದಷ್ಟು ಎಲ್ಲೆಲ್ಲಿ ಸಾಧ್ಯವೋ ಅದು ಬಿಟ್ಬಿಡ್ತಾರೆ, ಡೇಟ್ ಬೇಡ ಅಂತ ಹೇಳಿದಕ್ಕೆ. ಇರ್ಲಿ ಬಿಡಿ, ನಾನು ನೋಡ್ಕೊತೀನಿ. ಅಲ್ಲೇನ ತರ್ಕೊತೀನಿ ಹಾಗೇನಂಗೆ. ಡೇಟ್ಸು ನಮಗ್ ಬಿಟ್ಬಿಡ್ತಾರೆ, ಕಷ್ಟ ಆಗತ್ತೆ.
ಒಂದು ಡೇಟ್ ಡಿಕ್ಲೇರ್ ಮಾಡಬೇಕು.
ಅವರು ಆಗ್ಲೇ ಹೇಳಕ್ ಬಿಡಲ್ಲ ಮೇಡಮ್. ಆಮೇಲೆ ಕೊಡಿ ಅಂತ ಹೇಳೋಂಗ್ ಹೇಳ್ತಾರೆ, ನೆಕ್ಸ್ಟ್ ಹೋಗ್ಲಿ ಅನ್ನೋ ಮಾಡ್ತಾರೆ ಅವರು. ಎಸ್ ಮೇಡಮ್. ಕೊಡ್ಬೇಕು ಮೇಡಮ್. ಇಲ್ಲ ಮಾಡೋದು ಮೇಡಮ್. ಓಕೆ ಬನ್ನಿ ಮೇಡಮ್. ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಆ ಲೇಡಿ ರಜಾ ಅಂತಂದ್ರು, ಇನ್ನೊಬ್ರು ಇದಾರೆ, ಹೆಸರು ಏನಾದ್ರು ಗೊತ್ತಾ ನಿಮ್ಗೆ? ಯಾರಿಗಂತ? ಇಲ್ಲಲ್ಲ? ಏನ್ ಮಾಡ್ತೀನಿ? ತಿಳ್ಕೊತೀನಿ ಬಿಡಿ, ಕೇಳ್ತೀನಿ ಬಿಡಿ, ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಅಲ್ಲ? ಮೇಡಮ್, ಇನ್ನೊಂದು ಮೇಡಮ್ ಕುತ್ಕೊಳ್ಳೋದಿಲ್ಲ. ಕನ್ಸರ್ನ್ ಕೇಸ್ ಬರ್ತಿದ್ದಾರೆ ಮೇಡಮ್. ಲಂಚ್ ಹೋಗಿದ್ದಾರೆ. ಓಕೆ, ಅದು ಬಂದ್ರೆ ಆಮೇಲೆ ಉಮಾ ಮೇಡಮ್ ಕೊಟ್ಟಿರೋದು. ಫೋನ್ ಮಾಡಿ. Hello? 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 ಕೇಳಿಸ್ತಿದ್ಯಾ? Hello? Hello? ಹಾ, ಹೇಳಿ ಹೇಳಿ, ಕೇಳಿಸ್ತಿದೆ. ಹಾ. ಹ್ಮ್ 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 ಹ್ಮ್. ಬರೀ dismiss ಅಂತ ಮಾಡ್ಕೊಡೋಣ ನಿಮ್ದು? Okay, ma'am. ಬರೀ dismiss ಅಂತ. Dismiss ಅಂತ. Okay, ma'am. Dismiss ಅಂತ ಬರ್ಕೋಣ ಮೇಡಮ್. ಹಾ. ಹ್ಮ್ 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 ಹ್ಮ್. Dismiss ಅಂತ ಬರ್ಕೋಣ. ಓಕೆ ಮೇಡಮ್, ಸೀರಿಯಲ್ ನಂಬರ್ ಗೊತ್ತಾ ಮೇಡಮ್? ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 4315 ಇನ್ ಪರ್ಚೇಸ್ ಮಾಡಿಸ್ಕೊಡ್ಲ? ಓಕೆ ಮೇಡಮ್, 4315 ಇನ್ ಪರ್ಚೇಸ್ ಅಂತ ಮಾಡಿ. ಓಕೆ ಮೇಡಮ್, ಓಕೆ ಮೇಡಮ್. ಫೈಲ್ ಅಲ್ಲ ಅಲ್ಲಿ ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಮೇಡಮ್ ಅದು? ಸರ್ ಇದು ನೀವು ಆಗ್ಲೇ ಕೇಳಿದ್ರಲ್ಲ ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ 66214 ಅಂತ ಹೇಳಿ ಅದು ಫೈಲ್ ಇಲ್ಲೇ ಇದೆ, ರಿಪೀಟ್ ತಗೊಂಡ್ಬಿಡಿ ಸರ್ ಅದು. ರಿಪೀಟ್ ಹಾಕೊಂಡ್ಬಿಡಿ ಸರ್ ನಾಳೆ ಡೇಟ್ಗೆ. ಮತ್ತೆ ಇಲ್ಲಿ ತನಕ ಯಾವ್ದು ಆಗಿಲ್ಲ ಸರ್, ಇಲ್ಲಿ ತನಕ ಏನಿಲ್ಲ ಇದ್ರೆ ಹೇಳ್ತೀನಿ ನಮ್ಗೆ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 20 27. ಓಕೆ ಸರಿ. ಲಿಸ್ಟ್ 6 ಒಳಗಿದೆಯಾ ಅಷ್ಟೇನಾ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ? ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ 27. ಇನ್ನೊಂದು ಚೂರು ಏನಾದ್ರು ಹಾಕಿ ಸಾಯಂಕಾಲ ಅಷ್ಟೊತ್ತಿಗೆ ಅದ್ರ ರಿಪೀಟ್ ಬರುತ್ತೆ ನೋಡ್ಕೊಂಡು, ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಇನ್ನೊಂದು ಸ್ವಲ್ಪ ಹಾಕಿ ಇದೆ. ಫೈನಲ್ ಇಯರಿಂಗ್ ಎಷ್ಟಿದೆ ಸರ್ ಅದರಲ್ಲಿ, ಏನಾರು ಇದೆಯಾ? ಫೈನಲ್ ಇಯರಿಂಗ್ 4 ಇದೆ, ಹಂಗಂದ್ರೆ ಅದು ಟಚ್ ಮಾಡೋಗ್ತದೆ, ಹಂಗೆ ಇರ್ಲಿಕ್ಕೆ ಅಷ್ಟೇ. ಈ ಅಡ್ಮಿಷನ್ಸ್ ಬಿ ಗ್ರೂಪ್ ಅದರಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲಾರು ಇರುತ್ತಾ ಚೆಕ್ ಮಾಡಿ ಸರಿ. ಅಡ್ಮಿಷನ್ ಅಲ್ಲಿ ಇರುತ್ತಾ ಅಥವಾ ಹಿಯರಿಂಗ್ ಇಯರ್ದಲ್ಲಿ ಏನಾರು ಇರುತ್ತಾ ಸರ್? ನಿಮ್ಗೆ ಏನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಏನೋ ಹೇಳಿರ್ಲಿಲ್ವಾ ಮೇಡಮ್ ಇವರು ನಮ್ಮ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಏನು ಹೇಳಿಲ್ಲ? ಸರ್ ನಾನು ವಿಚಾರಿಸ್ಬಿಟ್ಟು ಹೇಳ್ತೇನೆ ಸರ್ ನಿಮಗೆ. ಹೇಳ್ತೀನಿ ನಾವು ಜಾಬ್ ಮಾಡ್ತೀವಿ. ನಿಮ್ಮ ಹೆಸರು ಸರ್? ಓಕೆ. Hello, matter pertaining to Kalburgi bench. Advocate sir idira sir.
ಎಷ್ಟಿದೆ ಕಲಬುರ್ಗಿ?
ಮೂರಿದೆ ಸರ್.
ಆಮೇಲೆ 230 ಲಿಸ್ಟ್
ಕೇಳ್ತೀನಿ ಸರ್. ಪಾಸ್ ಓವರ್ಸು ಇದೆ. ಅದೆಲ್ಲ ಕೇಳ್ತೀನಿ ಯಾವ್ದು ಹೇಳ್ತಾರಲ್ಲ. ರಿಪೀಟ್ ಇಲ್ಲಿ ತನಕ ಯಾವ್ದಿಲ್ಲ. ಪಾಸ್ ಓವರ್ಸ್ ಎಷ್ಟಿದೆ ಮೇಡಮ್? ಅದೆಷ್ಟು ಪಾಸ್ ಓವರ್ ಕಲಬುರ್ಗಿ ಬೆಂಚ್.
Lord's kind permission. My Lord's kind permission. Serial number 12 in list number 2. I request my Lord to grant the shortest possible date. The DA case trial is held up for 5 years. Fourth adjournment before my Lord. Once matter did not reach. 4 adjournments before my Lord's Lord in this case. Over the last 1 hour.
Serial number?
Serial number 12 in list number 2.
ಆಗಿದಲ್ಲ ಅದು.
The date ಇನ್ನು ಕೊಟ್ಟಿಲ್ಲ.
ಹ್ಮ್.
I request the shortest possible date, not
ಆಯ್ತು ಅದು.
20th or 21st or
First ಎಲ್ಲ ಆಗ್ಲಿಕ್ಕಿಲ್ಲ.
23rd, my Lord.
Overburden ಆಗಿದೆ. Next month first week. First week.
The 23rd or
Holiday ಬಂತು.
23rd or 24th, my Lord. I'll take a chance, my Lord. My Lord, 5 years, my Lord, the DA case trial is held up on one or the other reason, my Lord. That's all that I'm requesting. I'll take 23rd or 24th.
Is it a connected matter?
Lord, submission is made. Even there, my Lord, it is the 4th round of filing petition before this honorable court. One after the other discharge application.
For respondent number 1, opposing the adjournment, submitted that the disproportionate case pending before the trial court is being adjourned indefinitely in view of the pendency of this petition.
And interim order, I'm sorry.
Pendency of this petition with the interim order staying the further proceedings. Considering the submission, list the matter finally as a last chance. Yes. ಅದು ಡೇಟ್ ಕೊಡ್ತಾರೆ ನೋಡ್ಕೊಂಡು ಕೊಡಿ ಯಾವಾಗ ಸ್ವಲ್ಪ free ಆಗಿ.
23rd or 24th.
23rd.
I'll take a chance, my Lord. All that
ಅಂದ್ರೆ
I will.
ಅಲ್ಲ
all that-
ಫೈನಲ್ ಅಂತ ಹಾಕಿದ್ಮೇಲೆ I have to take up the matter.
ಅದೇ ಅಲ್ಲ just in case, if only if it reaches.
ನೋಡೋಣ, we'll decide. ನೋಡ್ಕೊಂಡು ಟೈಮ್ ಕೊಡಿ. Next. Yes.
Matter pertaining to Kalburgi bench, serial number 1.
First petitioner is charging that they are accused of the thing of the crime or charging wherein the A1 your lordship has granted bail, but at page 156.
No, this is under 482 ಅಲ್ಲ. 482.
A1 ತಾವು at page 156.
No, 482 petition, not bail petition. Yes, who is representing the petitioner? Serial number 1, Kalburgi matter.
Yes, ma'am. My lord, I am for the petitioner.
Why
2
you
weeks
are
time.
not compliant with the office objections? The office objection.
My lord, 2 weeks time, my lord, to file the objection, my lord, kindly.
How many objections are there? You don't know?
No. No, my lord.
Second time it is listed, still you do not know how many objections are there. Casually, you are seeking 2 weeks time. Counsel for the petitioner, pray for time.
My lord,
Petition was filed in
kindly.
as many as 9 objections.
This time.
None of the office objections were complied with. I do not find any reason to adjourn the matter, however. Next.
Serial number 2, Ashok Mulagi.
My lordship, I appear for petitioner, and this is a regular bail under 439 of TRPC. And the offence are under section 341, 395, 397 of the IPC. And my lordship, petitioner was arrested on 30/10/2019, my lordship.
30/10/2000.
19. And still he is in custody. And my lordship, there are total 36 charge sheet witnesses. So far, only 3 charge sheet witnesses are examined.
Petitioner
And
is-
also, pardon, my lordship.
Petitioner is accused number?
My lordship, petitioner is accused number 2, my lordship. 2. And A1 is already on bail. And the punishment for the said offencer is maximum 10 years, my lordship. And almost,
Your petition was dismissed on merits earlier.
yes, my lordship. My lordship, now the change circumstance, my lordship, is there are total 36 charge sheet witnesses, and so far only 3.
Even before,
My lordship.
even before they were there, 36 charge sheet witnesses.
My lordship, yes, my lordship. Now, so far only 3 charge sheet witnesses are examined, and they also turned hostile, my lordship. I have filed the document, section document, the depositions of the charge sheet number witness 1 and the punishment is maximum 10 years, madam, my lordship. And also, it almost he is in custody for 5 years now, completing 5 years. And A1 is also on bail. The only that on that ground, my lordship, I am seeking for a bail.
Twice your petition were dismissed on merits. You are the author of the crime, not accused number 1. You cannot have parity with accused number 1.
Yes. The only that since there are 36 charge sheet witnesses, I know soon the trial.
Already commenced.
My
Trial
lordship.
has already commenced.
Yes, it's already commenced, my lordship. And already the charge sheet witnesses which I produced, they have turned the hostile.
There are other material witnesses as well. Even there are eyewitnesses to the incident. Letter ಇದು ಆರ್ಡರ್ ಇದೆ 21/11/2023. ನೀವು ಲೆಟರ್ ಏನು ಓದೋದಿಲ್ವಾ? ಅದರಲ್ಲಿ ಇರಲ್ಲಮ್ಮ. ಲೆಟರ್ ಎಲ್ಲ ಓದೋದಿಲ್ವಾ? ಏನೂ ಇಲ್ಲ, ಸುಮ್ಮನೆ ನಿಂತು ಬಿಡೋದಪ್ಪ. Whether any direction was issued to the trial court to expedite the matter?
No, my lordship.
ಇದ್ರದ್ದು ಎಲ್ಲಿದೆ ನೋಡಿ, ಡೈರೆಕ್ಷನ್ ಎಲ್ಲಿದೆ? Who filed this criminal petition number 200485 of 2023? ನೋಡಿ, ವೆರಿಫೈ ಮಾಡಿ. ಯಾಕೆ ಬಂತು ನೋಡಿ. ಪಾಸ್ ಓವರ್.
Serial number 3, Shivaputra.
Counsel for the petitioner is absent, no representation this time. Next. $230 matter. ಏನಾಗಿದೆ ಅದು? ಒಂದು ನಿಮಿಷ. ಎಲ್ಲಿ CGP ಇಲ್ಲ. ಅವರು SPP ಬರ್ಲಿಕ್ಕೆ ಹೇಳ್ಬೇಕು, ನಾನು ಮೀಟ್ ಆಗ್ಲಿಕ್ಕೆ ಹೇಳ್ಬೇಕು. 230 ಮ್ಯಾಟರ್ ಕರಿ.
Further hearing 230 matter serial number 22, Maya Holla.
Taking your lordships through the judgments, my lord. Lay.
Produce the judgments.
Yes, ma'am. I
Compilation.
already given last time. Correct.
Yes.
Judgment, my lord, is.
First
When it was produced
Not
Other-
earlier itself. but this one.
separately.
Your lordship recollects, my lord, here is a case where,
You are representing accused number 3. But he is not named in the FIR.
no, ma'am.
Ah.
But then, my lord, in the preliminary report, my lord, they name him. Therefore, I am before your lordships.
You are the managing director.
Yes, my lord. The land was, my lord, sold by the state government.
Yes. Yes, I know
Absolute
the
sale
facts.
deed.
Yes.
After, my lord, 10 long years, my lord, the complaint has been lodged. On the ground of delay and laches, my lord, the complaint is liable to be quashed.
Yes.
I submitted, my lord, on the last occasion, my lord, 1989, 1 SCC 321, the first of the judgments, which I already, my lord, read to your lordships, my lord, at paragraph 21.
Hmm.
6 years delay, my lord, the Honorable Supreme Court held. In lodging the complaint, my lord, the complaint is liable to be quashed.
Yes.
Page, my lord, 14.
Para number 21.
Yes. ma'am. In the middle, my lords get that. The first information report, my lord, 1, 2, 3,
Yes.
4, 7 lines, 6
Yes.
lines from the top. First information report in this case was lodged on 27th of August 1985. That's about 6 years from the accrual of the cause of action or taking place of the events which took place in 1979, or about 3 years even from October 31, 1980, when the respondent retired from service. Now, in 1988, it would be pursuing a stale matter. In this view of the matter, we are of the opinion. Order the High Court quashing the first information report to just be maintained.
Yes.
Second judgment is, my lord, page 15, where the Honorable Supreme Court, my lord, in relation to that ISKCON, my lord, president, where he sold a bus belonging to Calcutta, my lord, ISKCON branch, para 11 and 21, my lord.
Yes.
Para 11 is at page 19. Last 6 lines, my lord, in para 11.
Yes.
Respondent to complaint also did not take any concrete action in getting the said complaint registered with regard to the alleged theft of the bus. My lord, allegation was theft of bus for a long period of 8 years, till the complaint in the court was filed in 2009. In the opinion of the court, such an inordinate delay of 8 years in filing the complaint in the court itself would be sufficient ground to quash the proceedings. Third judgment, my lord, is paragraph 21 of this judgment, my lord, their lordships, my lord, reiterate this. They quash, my lord,
Yes.
paragraph 21 at page 23. They quash the complaint. Then, my lord, the next judgment is paragraph page 25.
Yes.
Paragraph 21 to 25, my lord. At, my lord, running page 32. Paragraph 21.
Yes.
Prompt and early reporting of the occurrence of by the informant with all its vivid details gives an assurance regarding the truth of its version. In case there is some delay in filing the FIR, complainant must give explanation for the same. Undoubtedly, delay in lodging the FIR does not make the complaint's case improbable when the such delay is properly explained. However, deliberate delay in lodging the complaint is always fatal.
Yes.
My lord, the next judgment is at page 34. My lord, that was a matrimonial dispute between husband and wife. Husband married for the second time, my lord. Please come to page 34 at, my lord, page 35, paragraph 3. 2018, 12 SCC 625.
Yes.
My lord's para 3, my lord. Considering the matter, having considered the matter, we are of the opinion that there is inherent improbability in the version of the complainant, complainant, insofar as offense of 376 is concerned. This is because, according to the complainant, she came to know about the fact of the early marriage or the appellant accused in the year 2014, though the parties were married in the year 2009. That apart, in the complaint dated 19/12/2014, it is stated the same has been lodged after 1 year of the knowledge of the previous marriage the appellant accused. In view of the inherent improbability and, my lord, delay, my lord, their lordships, my lord, quash the complaint. Then, my lord, managing director, my lord, is not vicariously liable. My lord, he can't be held responsible if the company, my lord, the firm or the company sells. My lord, please come to page 36.
Yes.
Literally, paragraph 5, my lord, this is 2011, 1 SCC 176, paragraph 50. At running page 52, my lord. Starts at 37, 36, at 52.
Paragraph number?
50, my lord, 50.
Yes. Yes.
As mentioned here above, High Court heard in giving its own interpretation of the decision of the case in court in SMS Pharmaceuticals Limited case, which was reiterated subsequently in several judgments, some of which have been indicated here above, and relying instead on the decision of Gangacharya, the facts of which were entirely different from the facts. It is now well established that in a complaint against the company and its directors, complainant has to indicate in the complaint itself as to whether the directors concerned were either in charge of or responsible to the company for its day-to-day management, or whether they were responsible to the company for the conduct of business. Beyond false statement that the person was the director of the company against which certain allegations had been made, he is not sufficient to make such director liable in the absence of any specific allegations regarding his role.
Yes.
In the sorry.
Yes.
In the instant case, my lord, I submitted to your lordship. There was, my lord, the complaint. Whatever. There was, my lord, encroachment into the land. Police complaint, my lord, all that, my lord, I had indicated. In the light of that, my lord, we couldn't keep the land vacant. So, my lord, we appointed a consultant. Consultant said, my lord, this is the methodology by which you can go about. We followed, my lord, what is known as the Karnataka transparency, my lord.
No, his submission is that since you wanted a land for construction of your office.
Correct, corporate office.
A concessional rate, the land was given.
My lord, no. It is not their case, my lord, that is given at a concession rate. Nobody, even the state has not said that it is given at a concession rate. It is, my lord, given to us, my lord, at some rate. Whether it is concession or not, nobody has stated about it. This is one aspect. Second is, my lord, even if it is, my lord, please look at the sale deed. I'll tell your lordships why. Since your lordships asked me this question, can I persuade your lordships? Just look at, my lord, two judgments. Please come to, my lord, page 170, capital A, my lord, of this compilation itself. Judgment compilation. 170, capital A, my lord.
Yes.
2020, 11 SCC, 19, my lord, paragraph 221, paragraph 19.
Yes.
At page 170, capital H, my lord. Section, sorry. Page 170, capital H.
Yes.
Para 10, 19, my lord. Section 10. My lord, section 10 is, my lord, at the top. Can I read, my lord, section 10 of the TP Act? Section 10 of the Transfer Property Act, which is to the following effect. Where the property is transferred subject to condition or limitation, absolutely, restraining the transfer or any person claiming under him from parting with the disposing of his interest in the property, condition or limitation is void, except in the case of a lease, where the condition is for the benefit of the lessor or those claiming under him. Therefore, my lord, section 10, my lord, para 19, provided the property may be transferred to or for the benefit of a woman, Hindu, my lord, this does not arise, proviso. Please look at para 19. Section 10 expressly provides that where the property is transferred subject to condition or limitation, absolutely restraining the transferee or any person claiming under him from parting with or disposing of his interest in the property, condition or limitation is void. According to section 10, any condition restraining the transferee, the right of alienation is void. A plain reading of section 10 of the Transferred Property Act makes it clear that the condition in the gift deed dated so and so, that the defendant shall not alienate the property is void. Idralli a condition no illa. My lord, if your lordship look, take my lord, the sale deed itself.
Line of submission, line of argument on the other side.
Yes, my lord.
The land in question was granted on a concessional rate for the purpose of building the constructing the office for administration.
Correct. Where is, my lord, the allegation?
But
my lord?
you constructed the office elsewhere.
Correct.
And there was no need for that.
Reason is,
Under that circumstances, you could have surrendered back the
no, my lord.
land.
No, please take, my lord, the sale deed itself.
And within 10 days from the date of sale deed, there was this, you opted for leasing it out to third parties.
My lord, the grant was.
The builders.
Correct. My lord, please look at, my lord. Ultimately, my lord, when was the grant made? Grant was made in there 1984. 84, my lord, to 1988. 98, my lord, 1984 to 19, sorry. 1
Grant
minute.
in the year 1984.
Handed over, my lord, in 1998. My list of dates is there. My lord, 4/5/1998, land was handed over to us. There were no preconditions.
Yes,
It was, my lord, granted to me because, my lord, I wanted to build up a corporate office.
yes,
Thereafter, my lord, we entrusted, sorry,
yes. Dates and events related.
list of dates, page 2, para 5, my lord. Serial number 5.
Events related. Yes, yes.
Serial number 5,
Hmm.
4/5/1998.
Yes,
Public Works Department, Government of Karnataka handed over the scheduled property to KMF. My lord, earlier, my lord, please come to my lord, para 4, my lord, at the bottom.
no,
In
when the sale deed was executed.
Sale deed, my lord, was in the year 2008 because I'll tell your lordships why. If my lords recollects, we entrusted the, my lord, the building of this, my lord, to National Dairy Development Corporation. National Dairy Development Board, they did not, my lord, they were not able to complete it, my lord, within 3 years. Till 2001.
Yes,
Therefore, my lord, we, my lord, in the meanwhile, my lord, because there was an urgent need for us to have the corporate office, my lord, we constructed the corporate office. Subsequent thereto, BDA, my lord, we, my lord, sought opinion of the lawyers. I had also indicated this, my lord, on the earlier occasion.
they have given a
Correct.
opinion.
They
saying
said,
that-
you can lease it out, but take a sale deed. So, my lord, the sale deed was obtained by us in the year, my lord, 2008.
24/2008.
Yes. Therefore, my lord, before that, what happened was, we, my lord, invited tenders. Please come to, my lord, serial number 6. Sorry, serial number, my lord, 9. KMF had already, my lord, by 2001, we had already constructed our own building for housing its corporate office behind the Bangalore Dairy under the Dairy Development Fund, project funds. Location of the said building was logistically convenient for KMF to carry on its activities. Since the scheduled property was vacant, there were several attempts at encroachment upon the scheduled property by encroachers, land grabbers, and erstwhile landowners, as a result of which several police complaints were lodged. One such complaint, my lord, we have placed it. My lord, there are a number of them, if necessary, my lord, because we already, my lord, it was such a thick bundle. Then, my lord, please come to, my lord, serial number 10. Board of KMF at its 189th meeting, after considering the entire matter, felt that the construction of corporate office as a scheduled property would involve unnecessary burden of rupees 8 to 10 crores to KMF without any return, and that leasing the scheduled property would earn additional revenue and also protect the land from encroachers. And at the same time, ensuring that the scheduled property continues to be the property of KMF, and resolved to give the scheduled property on a long-term lease, authorizing the managing director to take necessary steps in this regard, after obtaining legal opinion. In furtherance of the resolution, managing director initiated action for appointing a consultant to guide the KMF for grant of lease of scheduled property on a long-term basis for commercial purpose. In this regard, Messrs. Wilbur Smith Private Limited was appointed as a consultant. Then, my lord, serial number 12. As per the advice tendered by the said consultant, tenders were invited by KMF in accordance with the provisions of the Karnataka Transparency in Public Procurements Act. Advertisements were released in the daily newspaper. My lord, we have placed that also before your lordships. Procedure contemplated in the Karnataka Transparency in Public Procurement Act, my lord, was followed. Can I persuade your lords? Just look at, my lord, that Karnataka Transparency in Public Procurements Act. It, my lord, specifically mandates that we should, my lord, invite tenders. So we invited tenders, and, my lord, all of them were placed before the board. And, my lord, the person who offered the highest amount was chosen.
Yes.
Then, my lord, it was placed before the board. Now, please come to serial number 15, my lord. Serial number 15, on 17/3/2008, decision of the board to lease the scheduled property in favor of PM Infrastructures referred to Kesvi and Company Advocates, Bangalore, panel of advocates who handle legal disputes of KMF land to ascertain as to whether there is any legal bar for leasing the scheduled property. Kesvi and Company Advocates, by their legal opinion, opined that there is no bar to lease the scheduled property in favor of Messrs. PVK Infrastructure and advised to get a deed of conveyance from the government. So, my lord, on 22/4/2008, but the process was started, as I pointed out, way back, my lord, in 2001 itself. State government, my lord, executed a registered conveyance deed on 19/5. Clause 7 of the said deed empowers KMF to enjoy the property without any interruption, with absolute power to deal with the property. Thereafter, my lord, a agreement was entered into between the PM Infrastructure and, my lord,
Yes.
the KMF. That was also placed before the board, my lord. It was accepted. Legal advice, my lord, went into it.
Yes.
After, my lord, on serial number 21, 9 long years thereafter, my lord, the complaint has been lodged. My submission to your lordships is that delay itself, my lord, is fatal. One. Secondly, please look at the complaint, my lord. Complaint is as bald as my forehead. (167) already. 116. So, 165, my lord. Registrar the 10 ದಿವಸಗಳಲ್ಲಿ ಪರಭಾರೆ ಮಾಡಿದ್ದಾರೆ, my lord. I have not ಪರಭಾರೆ ಮಾಡಲಿಲ್ಲ. I have, my lord, given it on lease in terms of, my lord, the procedure contemplated in the Karnataka Transparency Act. In fact, I must also bring this, your lords. On the last occasion, I did bring this, your lords. Board comprises of, my lord, secretary, government. Please come to, my lord, running page.
Senior officials are the
Yes,
members.
my lord. Or the government itself.
Yes.
Not, my lord, KMF farmers or somebody.
Yes.
The secretary, my lord, of the Department of Animal Husbandry, director, my lord, Cooperative Society, my lord, registrar, National Dairy Development, my lord, boards, which is a central government organization, my lord, their representative. They took, my lord, a decision. And all that has been stated, my lord, in the complaint is, my lord, we have not alienated it. In fact, it is to the advantage. In fact, if you, I did bring this, your lord's notice. The report of the, my lord, we filed, my lord, memo.
Fetching more rent.
That's all, my lord. Then, my lord, can, my lord, new documents be looked into under 482? Can I persuade your lords look at the judgment list, my lord, again? Documents of unimpeachable character, my lord, can be looked into under 482. My lord, I have given that judgment. Serial number 11 of the judgment compilation, 2015, 11 SCC 730. There are a number of them. One the judgment ನಾನು ಇಟ್ಟಿದ್ದೀನಿ.
2018.
15, my lord. Serial number 11, my lord. Serial number 11, 2015, 11 SCC 730, paragraph 7.
Yes.
What, my lord, when can, my lord, it be looked into? Is the material relied upon by the accuser of sterling quality? Answer is, my lord, all public documents. Whether the material rule out level charges and persuade a reasonable person to dismiss the complaint, answer is yes. Whether the material is such that it cannot be refuted, answer is they have not refuted anything. Whether the proceedings would result in abuse of process of court, my lord, my answer is yes. In fact, my lord, there are a number of judgments. I didn't want to, my lord, unnecessarily burden the lordships with authorities and authorities. Number of judgments are there where their lordships of the Supreme Court have held that, my lord, documents can be, my lord, unimpeachable character can be looked into under section. Then, my lord, the 2000, my lord, our own High Court, my lord, please come to the division bench judgment of our High Court, my lord, at page 171. Noora Yappatondu. This is, my lord, WP 7039 of 2020, a division bench judgment. Please come to, my lord, para 13 at running page 183, my lord. Respondent 4 was put in possession of scheduled property, my lord, para page 183. And lease cum sale deed was executed in favor of the very same year. Immediately thereafter, in 73, he had established a granite factory, graphite plant, and in the scheduled property. And the said industry was functioning till the year 2019. In the meanwhile, in 1987, an absolute sale deed was executed by the board in favor of respondent number 4 in respect to scheduled property. Undisputably, said sale deed has been executed in favor of the respondent number 4 without any restriction. Material record would show that in the year 2012, several complaints were made by the residents of the locality with regard to pollution caused by the functioning of the respondent number 4 industry. My lord, what happened was, this my lord was in Whitefield. Whitefield industry run marta idru. Lease cum sale alli. Neighbors, my lord, started complaining. Adu suit barlik shuru aitu. Graphite, my lord, emanates suit. So, my lord, we had to, my lord, close down the industry. We took a sale deed. In fact, I had appeared, my lord, for the petitioner, the respondent. Ultimately, my lord, please come to, my lord, in page 14, last 1, 2, 3, 4, 5, 6, 8 lines from the bottom, my lord. Undisputably, no conditions or restrictions were attached in the sale deed dated 24/4/1987, executed by the board in respect of respondent number 4, in respect of scheduled property. Therefore, contention of the learned senior counsel of the petitioner that after the closure of the industry, scheduled property has to revert back to the government, or the land should be brought to sale by the state government by public auction cannot be accepted, the same is liable to be rejected. It is not the case of the petitioner, para 14, my lord, that the scheduled property was not utilized by respondent number 4 for the purpose for which it was allotted. Undisputably, respondent number 4, my lord, that was at the time of lease cum sale, had established an industry. Absolute sale deed is in its favor is without any restriction. Para 14 alli, my lords may come to, my lord, 6 lines from the top. Absolute sale deed executed in its favor is without any restriction or utilization of the land. And even if there is any restriction, same would be void under section 11 of the TP Act.
Yes.
Under the circumstances, we are of the view that several prayers made by the petitioner for issuing a writ of mandamus, including writ of mandamus directing respondent number 3 to acquire the scheduled property or allot it to some entrepreneur or use the scheduled property as lung space cannot be granted.
Yes.
Lord, can I request you, Lord, to look at page 69, my lord, of this compilation? There, the Lord, Supreme Court has held investigation cannot be to find out whether, my lord, a person has committed the offense or not. That's precisely, my lord, what this complaint, my lord, sought to, my lord, do. Please come to page 69.
Yes.
2002, 5 SCC 521. Paragraph 6 of this judgment, my lord. Para 6, my lord, at page 73.
Yes.
It is seen from the above decision of this court that the right to life under Article 21 includes the right of a person to live without being hounded by police or CBI to find out whether he has committed an offense or is living as a law-abiding citizen. Therefore, it is clear that a decision to direct any inquiry by CBI against a person can only be done if the High Court, after considering the material on record, comes to the conclusion that such material does disclose prima facie calling for investigation by the CBI or any other similar agency. Same cannot be done as a matter of routine or merely because a party makes some allegations. In the instant case, we see that the High Court, without coming to a definite conclusion that there is a prima facie case established to direct an inquiry, has proceeded on the ifs and buts and so on. So on. My submission is, therefore, my lord, we will have to look at the complaint. Complaint is, 10 ದಿವಸದಲ್ಲಿ ಮಾರಿದ್ದಾರೆ, therefore, my lord, second judgment also, my lord, to a similar effect. That, my lord, Article 21. My submission to your lordships is that, my lord, the tendering process, if your lordships take, my lord, I have produced, my lord, along with the memo, my lord, on the last occasion, my lord, on the first day itself, my lord, I argued, produced all the documents, my lord, public documents, paper publication, all that, my lord, Transparency Act, my lord, if India, Transparency Act, India. Please come to, my lord, page 18, serial number 2, section 2, subsection 18. Here, exactly.
Section 2,
18, my lord, sorry,
ABCD ಇದೆ.
section 2, H ಬಂದ್ರೆ ತಾವು tender ಅಂತ ಹೇಳಿದ್ರೆ H, my lord.
Yes.
Tender means the formal offer made for supply of goods or services or construction works, or includes tender gone through the electronic reverse auction in response to an invitation to tender published by the Karnataka Public Procurement Portal. Tender accepting authority means, my lord, committee, my lord, appointed to accept the tenders, etc. Now, my lord, please come to section 5. On and after the commencement of this act, no procurement entity shall procure goods or services except by inviting tenders for supply. My submission to your lordships is, the tendering process, my lord, as provided under this act, my lord, has been followed. Therefore, my lord, no offense is made out. Therefore, my lord, my submission is that, my lord, the petition is liable to be allowed. And then, my lord, if your lordships look at, my lord, the sale deed itself, it specifically states, clause 1 of the sale deed at page 100 of the petition. In fact, can I persuade your lords, look at, my lord, that sale deed for a minute, my lord. 93 nalli barutte, page 93.
93
of, my lord, the petition, my lord, petition.
Yes.
Deed of absolute conveyance, my lord.
Yes.
ಇದರಲ್ಲಿ ಯಾವ್ದು ತೋರಿಸ್ತಾ ಇದೆ ಪೇಜ್ 100 ಬಂದ್ರೆ ತಾವು ಗವರ್ಮೆಂಟ್ ಸಾರಿ 100 ಟಾಪ್ ಅಲ್ಲಿ my lord.
Yes.
7 ಅಂತ Roman 7. Government confirms having delivered vacant possession of the scheduled property to KMF on 4/5/1998 itself.
Yes.
Government hereby covenants with KMF as follows. KMF shall be entitled to hold, possess, build upon, enjoy the scheduled property hereby sold to it. And the rents, my lord, please mark this. Rents and profits received therefrom without any disturbance or interference by the government or any other person or authority claiming through or under it.
Yes.
Ultimately, my lord, KMF, my lord, is a public authority. It is, my lord, all the government, my lord, it's virtually, my lord, a wing of the government which supplies, my lord, milk all across. If, my lord, the KMF, my lord, benefits by this sale, my submission is the government benefits, farmers benefit. Therefore, my lord, my submission to your lordships is, when, my lord, there's an absolute sale deed issued without any even if there is a restriction, this honorable court and Supreme Court have held, that would be, my lord, contrary to section 10 and 11 of the TP Act. Therefore, my lord, my submission is, petition, my lord, deserves to be allowed. That's all. Grateful, my lord, for the abundant patience and the indulgence that your lordships have shown.
Yeah, Haridhar. We have already addressed the argument. Hmm. Hmm.
But can I
Yes.
seek your lord's indulgence?
Petition number, 56253. Writ petition number 56253.
Page number?
111. Annexure G. My lord, the document starts at 111. My lords, may I just pray my lords to kindly have page number 113. My lord, this was the stand of the government when we, my lord, approached the anticipatory bail court. On instructions, my lord, the learned PP, my lord, places it on record this way. Arjidaru, my lord, page number 113, my lord, top paragraph. Arjidaru, ಪ್ರಶ್ನಿತ PVK ಕೋರಮಂಗಲ ಡೆವಲಪ್ಮೆಂಟ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಕಂಪನಿಯ ನಿರ್ದೇಶಕರಾಗಿದ್ದು ಈ ಭ್ರಷ್ಟಾಚಾರ ವ್ಯವಹಾರದಲ್ಲಿ ಪ್ರಮುಖವಾದ ಪಾತ್ರವನ್ನು ವಹಿಸಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬರುತ್ತದೆ. And then, my lord, paragraph number 7 in the same page. ಈ ಪ್ರಕರಣದ ಅರ್ಜಿದಾರರು PVK ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಪ್ರಾಜೆಕ್ಟ್ ಇಂಡಿಯಾ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್, ಹ್ಯಾಸ್ಕೋ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಪ್ರಾಜೆಕ್ಟ್ ಕಂಪನಿ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಮತ್ತು ವಿಜಯ್ ಕುಮಾರ್, my lord, the petitioner, ರವರಿಂದ ಹಿಂದೂಸ್ತಾನ್ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಪ್ರಾಜೆಕ್ಟ್ ಇಂಜಿನಿಯರ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಕಂಪನಿ ಪ್ರಶ್ನಿತ ಜಮೀನಿನಲ್ಲಿ 33,333 ಅಡಿ ಜಾಗವನ್ನು ಉಪಗುತ್ತಿಗೆ ಪಡೆದಿದ್ದು.
But that is not the contention now.
That's not the contention. Only one last, my lord, submission. My lord, on the report, my lord, if your lordships could kindly have, my lord, the investigation officer's report. With this, my lord, I will not trouble your lordships, my lord, the investigation officer's report, which is on page number 96 in this very petition. Only one portion, my lord, if your lordships could kindly have, my lord, page number 101. Page number 101, my lord. In the page number 101, there is some English portion, my lord, is extracted. In that English portion, my lord, the third paragraph, which is under quote. My lord, this is an extract from the sale deed. Government hereby accept, acknowledge, acquit KMF therefrom. The government as absolute owner hereby grants, transfers and conveys unto KMF by way of an absolute conveyance all the 4 acres and 14 guntas of land, so and so, that the KMF shall be entitled to hold, possess, build upon, enjoy the scheduled property hereby sold and it and rents and profits received therefrom without any disturbances or interferences by the government or any other person or authority claiming through under it. Now, my lords, may kindly have, this was the, my lord, government's statement in the sale deed. Now, my lords, may kindly have the affidavit, my lord, which is placed by the respondent, my lord, affidavit of one Dr. Selva Kumar, Principal Secretary of the government. My lord, I am only on paragraph number 3. If your lordships would kindly see, my lord, paragraph number 2, my lord, the affidavit of Selva Kumar.
Page number.
My lord, this is on page number, my lord, the first page of the affidavit itself, my lord, second paragraph. Hope my lords are with that, my lord, affidavit. It is separately filed by the government. This honorable court, my lord, directed the government to take a stand. What is your stand in this? If the government has been a party to all these grant, etc., then there is nothing that can be done. Then there is no offense. And my lord, the government was asked to, my lord, take a stand. My lord, this was filed on 13th of August, 2024, my lord, 13th of August, 2024.
It is filed in which case?
In this very case, my lord, this honorable court, my lord, insisted the government to take a stand. That what exactly you want to say in this matter? The honorable court, one nimsham, brother. Honorable court also expressed that if the government is a party to this, there is this entire case, my lord, has to fall. And the government, my lord, was asked particularly to take a stand. What is your stand?
Who is the deponent secretary?
My lord, one Dr. S. Selvakumar, my lord, he is a principal secretary to the government PWD. My lord, he places this affidavit.
In WP 46675, the affidavit is filed in.
The affidavit is placed, my lord, in one of those cases. My lord, it is applicable to all the cases. Kindly, my lord, see.
466. Yeah. Yes, what he says?
He says, my lord, I think my learned friend has a copy of it. Can we just, my lord, pass it on? Madam, kindly, my lord, see the paragraph number 2, my lord, on this. Consciously, my lord, he knows, my lord, why this affidavit is being submitted. Paragraph number 2 onwards, I'll read. I respectfully submit that by an order dated 11/10/23 passed in writ petition number so and so, this honorable court has directed the state government to inform whether the government had permitted the Karnataka KMF was entitled to encumber the property conveyed to KMF to a private entity for commercial exploitation, and also directed the state government to inform the honorable court whether it had permitted the KMF to alienate or transfer the property on lease in favor of the private entity. It shall also indicate whether it has any serious objection against the manner in which the KMF has transferred the land to private entity for commercial exploitation. Now, my lord, this is his answer. I respectfully submit that the Public Works Department has issued proceedings of the government video order dated so and so 30/3/1998 by stating that 4.14 acres of land in Kormangala, Bangalore has been allocated for consideration of rupees 50,000 per acre to Cooperative Milk Producers Federation by referring the letter dated 4/2/1998 of Director, Karnataka Cooperative Milk Producers Federation Limited, and the letter dated 11/3/1998 of Superintending Engineer, Building Circle, Bangalore, submitted to the government. Further, I respectfully submit that the said proceeding, the Public Works Department has not mentioned about the alienation of the transfer of property. My lord, he goes to the proceedings forgetting that it is the government that has executed a sale deed by absolutely transferring the property. Now, my lord, can that sale deed which was executed, my lord?
No, there is no reference to the sale deed in this.
No, my lord, sale deed is subsequent. When the government is asked, should the, my lord, government not account the sale deed which is executed by the government? Now, my lord, can the government, having executed a sale deed which is absolute sale deed in nature,
Yes.
can they take a U-turn and say, no, the sale deed could be wrong. Previously, what happened prior to the sale deed, there is some problem. My lord, this is a changing stand taken by the government. Once a sale deed was executed, my lord, in favor of the KMA, it becomes an absolute property. My lord, now finding faults with what somebody does with their absolute property, my lord, will pierce into the constitutional rights. And my lord, in that, my lord, finding fault with everybody, my lord, who then, my lord, this is all my humble submission. Therefore, once there is an absolute sale deed, nothing, my lord, by the government could have been found fault with, because the government is a party to the sale deed. And my lord, my closing submission is
Who executed the sale deed?
government, my lord.
Represented by?
Represented by, my lord, the government only. If your lordships could kindly have, my lord, my lord, they were referring to the sale deed itself. I think sale deed is produced. Governor of Karnataka. My lord, sale deed, if your lordships could.
Secretary. Represented by Under Secretary?
Yes, represented by Executive Governor of Karnataka, represented by Executive Engineer, Public Works Department, Government of Karnataka. This is all, my lord, under delegation. Now, my lord, the government doesn't want to find fault with this sale deed. No, my lord, the property rights, my lord, once conveyed, either it is a government conveyance or a private conveyance, my lord, it becomes absolute. Now, my lord, they can't take a U-turn and say that everything is wrong.
Yes, anything?
My lord, lordship may accommodate 5-10 minutes tomorrow at 2:30, my lord. Senior is held up in court hall 3.
Last time, I think.
Our senior has made a submission. If there anything left, we'll make 5-10 minutes, we'll finish.
For everything, every time this happens,
My apology, Malay on hand.
not end with 5 or 10 minutes. It will take another half an hour minimum. ಆಗಿದೆ ಅದಷ್ಟೇ, ಮತ್ತಿನ್ನೇನು? You are for respondent number?
Respondent Loka Ekta, my lord.
Third,
What becomes, my lord, a moot question would be,
6675, 2017 and 56253, 17. Learned senior advocates. Yes,
can the Lokayukta, my lord, pierce holes and find faults with the indulgences of the governor? My lord, if that cannot be done, my lord, the government cannot, Lokayukta cannot have a say on this matter.
admittedly, sale deed is not questioned, sale deed is not set aside.
Sale deed is not questioned, my lord. Now, they can't, my lord, now say, a wing of the government, Lokayukta cannot, my lord, today come and say, everything what we did was wrong. Just because, my lord, a private complainant, my lord, files a complaint.
Then counsel for respondent, look like the place for time. For further arguments. Yes. Yeah, when?
Tomorrow, day after tomorrow, anytime.
Tomorrow? Tomorrow, yes. Tomorrow at 2:30.
Please.
So great, so
Mobilize.
great. Interim order may kindly wait.
Okay.
But I hope that affidavit of, my lord, the government was found on the file. Otherwise, my lord, we'll also place a copy. I have a copy, my lord, which we'll supply if it is not found on the file, because, my lord, it may be a bit important document.
Get a copy.
We'll also place a copy. So great.
So.
Passover matter, list number 1, serial number 8, Lankeshwar.
Counsel for the petitioner is absent, no representation, even when the matter is passed over trials and called at 3:30 PM. The petition is listed for the 4th time for compliance of office positions. Order sheet dated 13/8/2024 reads as under. In spite of that, there is no progress made in the matter. It appears the petitioner is not interested in prosecuting the petition. Petition dismissed. Next.
Serial number 10. Please, Kumar.
And for applied minor, prevent date minor. Senior after station is the same.
ಇಲ್ಲ ಇದು dismiss ಆಗುತ್ತೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ ಒಂದು short date ಕೊಡ್ಬೇಕು.
Yes, what is the charge is framed?
Charges is framed and it has posted for evidence and compared to year millets on 29/2018 millets.
Now it is for evidence.
Now is hearing millets.
Hearing of?
Hearing of final hearing millets. It is showing that hearing dated 29/2018 millets.
ಇಲ್ಲಿ hearing ಅಂತ ಬರಲ್ಲ, final ಅಂದ್ರೆ final arguments.
But ಇದರಲ್ಲಿ
Evidence is over.
ಎವಿಡೆನ್ಸ್ ಅಂತ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಹಿಯರಿಂಗ್ ಅಂತ ಹೋಗ್ತಿತ್ತು.
You should consult your counterpart there. You cannot depend upon
ಎವಿಡೆನ್ಸ್ ಡೇಟ್ ಆಫ್ ಎವಿಡೆನ್ಸ್ ಪೋಸ್ಟ್ ಆಗಿದೆ 21/3/2018 ಪೋಸ್ಟ್ ಆಗಿದೆ.
So why it is passed over then? I asked you to verify what is the stage.
No,
they will not do anything.
ಸೀನಿಯರ್ ಬರ್ತಾರೆ ಅಂತ ಬೆಳಗ್ಗೆ ನಾನ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
You are not supposed to verify, is it?
ಅಲ್ಲ ನಾನು ಬೆಳಗ್ಗೆ submission ಮಾಡಿದೆ ಇದು
That is why I have put a
Task-
question mark here. What is the stage? Whether evidence is over or whether it is fixed for evidence.
ಇಲ್ಲ ಸ್ವಾಮಿ ಎವಿಡೆನ್ಸ್ ಹೋಗಿಲ್ಲ.
ಎವಿಡೆನ್ಸ್ ಗೆ ಅವರು ಎವಿಡೆನ್ಸ್ ಗೆ ಹೋಗಿಲ್ಲ ಮಲಾಡ್ಸ್.
Then
ಎವಿಡೆನ್ಸ್
what is the stage?
ಸ್ಟೇಜ್ ಹಿಯರಿಂಗ್ ಅಂತಾನೆ ಇದೆ ಅಲ್ಲಿ.
Hearing ಅಂದ್ರೆ ಏನು? From day one till judgment, it will be hearing dates. You should know the stage of the sessions court.
Please, my lords. ಎವಿಡೆನ್ಸ್ ಆಗಿಲ್ಲ ಇದ್ರಲ್ಲಿ, ಬಟ್ ಅದು ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ನೋಡಿದ್ರೆ
Hearing ಅಂದ್ರೆ ಏನ್ stage? Tell me.
ಅದು ರಿಪೋರ್ಟ್ ಹಾಕ್ತೀನಿ ನಾನು ಅದ್ರಲ್ಲಿ. ಅದು ಲೋಯರ್ ಕೋರ್ಟ್ದು ರಿಪೋರ್ಟ್ ಏನ್ ಬರ್ತಿದೆ ಅದು ನಾನು ರಿಪೋರ್ಟ್ ಹಾಕ್ತೀನಿ.
ಅದಕ್ಕೆ ಇನ್ನೊಂದು adjournment. Where is SSP, SPP?
SPP.
It won't work like this. ಏನು ಗೊತ್ತಿಲ್ಲ ಹಿಯರಿಂಗ್ ಅಂತಂದ್ರೆ what does it mean?
ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
What is the offense?
420. 420.
420. Compromise ಆಗುತ್ತೆ.
ಅದೇ ಮಾತಾಡೋದಕ್ಕೆ ಅಂತ 29 ಡೇಟ್ ಇದೆ ಸ್ವಾಮಿ.
Counsel for the petitioner prays for time. Learned SCGP do not know the stage of the case before the trial court. Petition is of the year 2018. I do not find any reason to adjourn the matter, however, for final opportunity list on.
Serial number 12, Subhash Reddy.
Petitioner ended 2 days time and ended.
No.
ಅದ್ರಲ್ಲಿ ಏನು ಫೈಲ್
After taking emergent notice, you have not paid the PF.
2 days ಇವತ್ತು
It was in the month of May. Till date, you have not paid the PF.
ರೆಕಾರ್ಡ್ ಕೌನ್ಸಿಲ್ ಫೈಲ್
Counsel for the petitioner.
kindly have
prays
it
for
and
time.
tomorrow.
It is noticed that as per order dated 25/5/2023.
Kindly have it and tomorrow
Counsel for a petitioner to
needful.
emergent notice against respondent number 2. In spite of that, PF is not paid. List after service of notice. Next.
Serial number 13, Sudarshan A.
Put it. Counsel for the petitioner is absent, no representation, even when the matter is passed over twice and again called at 4:30 PM. In spite of issuing order to issue notice to respondent number 2. As per order dated 22/7/2021, CF for issuance of notice is not paid. It appears petitioner is not interested in prosecuting the petition, however, to afford final opportunity. Even the office objections are not complied with. Next.
Serial number 14, Surendra Kumar.
Counsel absent in spite of the 3:35. Order sheet dated 19/8/2024 reads as under. Order sheet dated 13/8/2024 reads as under. Order sheet dated 19/8/2024 reads as under. In spite of that, the PF is not paid. Nothing is produced before the court to show that the hand summons is issued, served on the respondent. Hence petition dismissed.
Serial number 15, M. Srinivas Murthy.
Absent, no representation, even though the matter is passed over twice. Notice to respondent number 2 is ordered as per order dated 7/10/2021. Till date notice could not be served as PF is not paid. The case petitioner is not interested in prosecuting the petition. However, to afford final opportunity. Next.
List 2, serial number 1, SPP.
It's filing with
Number of the respondent, my lords.
Yes. What is that?
that's they have surrendered. Right.
What is that you are filing?
There was a non-bailable warrant issued against the Ravi Kumar accused, my lords, was surrendered before the court, my lords.
Non-bailable warrant?
Warrant issued against Shri Ravi Kumar, my lords,
Who is he?
accused, my lords,
Here, what is his status?
petitioner. Appellant.
Respondent.
God alone save us. You do not know who is the petitioner, who is the respondent, who is the accused,
My lords,
nothing.
no, my lords, today's files.
Please do not appear before this court for. Ask the SPP to come and meet me. When there is absolutely no assistance, what is the fun in having the HCGP before this court?
My lords, sorry for
Simply to say in the order sheet that so and so represented.
No,
Is
sorry,
it?
sorry for inconvenience.
I don't want your assistance at all.
My lords, today's files is supposed to appear by my colleagues. My
Yes,
lords.
what happened to the NBW? You are for?
I am for the respondent, my lords.
Who is for the petitioner?
They are the state, the appellants, my lord.
NBW is executed.
Yes, my lords.
He is in custody.
He is in custody on Saturday, my lord.
Custody.
We'll file IA for
Learned
recall. my lord.
Counsel for respondent submits that NBW is executed and the respondent is in judicial custody. Yes, when will you argue the matter?
We'll file IA for recall, my lord. A short date may be given.
What is to be recalled?
The order, my lord, that you sent him to judicial custody. We'll file
Why?
IA for
You
recall.
address the argument and get the judgment, final judgment.
Lords, but he'll be in jail for some time, my lord. He'll be in jail for some time. That's it.
I am ready to hear you now. Please address the argument on merits. I'll dispose it out. Why should I hear the bail application or any other application for that matter?
Lordship, okay, we will have, lords, any date next week, we'll be fully prepared to finish the matter.
You cannot have that luxury, sir, because the respondent is in judicial custody.
Yes, my lord.
You should know that seriousness.
Yes, ma'am, that's any date on Monday to 23rd, 24th, we'll be.
Learned Counsel for learned HCGP and learned Counsel for respondent prays for time to address his arguments on merits. List on. Yes, next.
Any date may be fixed, my lord, 23rd, 20.
Next.
Serial number 15.
Yes. Date ಕೊಡ್ತಾರೆ sir, ಆಮೇಲೆ ತಗೊಳ್ಳಿ.
Sure.
Yes.
Serial number 15, Harish Kumar and
Advocate ಇದ್ದಾಗ ಫೈಲ್ ಕೊಡ್ಬೇಕಮ್ಮ. Yes, second marriage.
My lord, I was quoting the judgments. My lord, on 2 points, my lord, I am relying upon. One is, my lord, the complaint against the person with whom the wife or the husband married is not maintainable. And another is, my lord, it comes under, there is a bar under section 198, where, my lord, only private complaint is maintainable. My lord, as far as that part is concerned, my lord, I relied upon the judgment of this honorable
Is
court.
198.
190. One 198, my lord. Prosecution for offences against marriage. No court shall take cognizable of an offence punishable under chapter 20 of the Indian Penal Code 1860, except upon a complaint made by some person aggrieved by the offense.
That is the complaint only under 494 or 495. Here, other offences are also alleged.
But my lord, as far as petitioner are concerned, there cannot be any other allegation because we are not party.
It's your defense, but you cannot say that it is not maintainable anta barlik barala.
Allala.
No merits anta
Alla.
that could be.
By reading the complaint, my lord, the allegation against the.
You have already
Yes,
argued
yes.
the matter.
Then, my lord, the another point is concerned, I have relied upon the judgment of this honorable court, which I have already placed it. That is Bhimanna and others. There, my lord, there is a reference. My lord, that is not in that compilation. Earlier, I have given it. It is there.
I
Bhimanna,
asked which is the judgment of the Supreme Court.
Supreme Court, my lord, first one, Lingari Obulamma. In that, my lord, it may not be of much helpful for the reason that here it has been discussed, what are the ingredients to file the complaint? My lord, as far as that is concerned, the para, my lord, the last page of the judgment, second para, Lingari Obulamma judgment. My lord, in Lingari Obulamma judgment, in the last page, second para, my lord, the last sentence, it is well settled that before a conviction can be recorded under section 494, the following ingredients must be proved: that the complainant had been married to the accused, that the accused contracted a second marriage while the first marriage
That
was
is not
still.
in dispute, sir.
Please, my lord.
Regarding these ingredients that are requirements, there is no dispute.
There is no dispute. My lord, what I have relied upon in the judgment of this honorable court is the para 7, my lord, in Bhimanna and others, where it has stated, even otherwise, the allegation of contracting of second marriage is against the accused number 1. There is no averment that these accused instigated the accused number 1 to contract the second marriage with the accused number 2. Hence, in the absence of essential ingredients, so as to constitute the commission of aforesaid offense.
Where is that ingredient as stated by the Supreme Court? There should be an instigation.
My lord, in that judgment, it is not,
Then
I could not.
from where the
No,
coordinate
here,
got it?
here it is only for the ingredients to file the complaint was discussed.
Yes.
Then the para 7, my lord.
Simple question.
Yes.
What is that ingredient that the accused should instigate the other accused?
Yes, my lord.
Then only the complaint is maintainable. Where
No,
is that?
like that in that judgment, it has not.
Is why
That I will.
morning I asked you,
Yes,
where is the principle of law laid down?
On
Either
that,
by the apex court or by this court.
my lord, I have gone through certain judgments. My lord, I'll quote the other judgments which I am relying upon. It has got, no, for the on the point of filing the complaint against the other than the husband is concerned or wife is concerned. My lord, the next judgment is the Basuraj and others. I have given it, my lord. In that, my lord, it is the petition filed by the relatives and others, my lord. In that, the honorable court has stated, as per charge sheet material, accused number 1 performed his second marriage with accused number 9 during the lifetime of first wife accused number 1. Thus, the complainant lodged FIR for various sections, including section 498(4) of IPC. The investigating officer of 494 of IPC. The investigate, like this, my lord, along with other 498A and other things.
Yes.
The investigating officer, after conducting investigation, filed charge sheet including the offense punishable under section 494 of IPC. Admittedly, there is a bar under section 198, subsection 1, subclass C of CRPC, section 198(1), subsection 1, subclass C of CRPC reads as under. I'll skip that.
There cannot be a bar, sir, when the offense under 494 is coupled with other offenses.
In this case also.
420, likewise.
Yes, my lord.
There cannot be a bar.
In this case also, the same thing has happened. My lord, further the court has held. In view of the aforesaid proposition, the magistrate shall not take.
That cannot be accepted, sir. That cannot be accepted. That is very settled position of law.
My lord.
If the offense is only under 494, you are right. There is a bar.
My lord, kindly see, otherwise, my lord, it will be misused for any other. That is the reason, my lord, that it is a recent decision of this honorable court where it has been specifically dealt with.
Is the division bench decision?
No, my lord,
Then
in division, it is the
leave-
coordinate.
Leave it.
My lord, I'll just read it and I will, for my
Cannot accept
my
that.
this one.
Yes,
In view of the aforesaid,
you can read it yourself, but not to the court. Then, is there any other decision?
my lord, then the another judgment is regarding, my lord, the filing of the complaint against the other person is concerned. A judgment is, my lord, Timmappa versus Srimati Bharati. My lord, in this, para 8 is the relevant, the 9. What is important for this court to consider is that in terms of section 494 of IPC, it is only the person who marries during the subsistence and the lifetime of the earlier spouse, and the earlier marriage could be prosecuted and punished for the offences punishable under section 498(4) of IPC. The said provision does not even contemplate the person to whom the husband or wife has married to be prosecuted under section 494 of IPC, let alone the father, mother, and sister who had participated in or attended the wedding. The only allegation made in the complaint at paragraph 7 is that accused number 3 to 6 have knowledge of the marriage of the accused number 1 and 2 is illegal, and despite which they have participated. There is no averment made therein that they were aware of the subsisting marriage between the complainant and accused number 1, or further, there is no allegation made as regards the intention on part of the accused number 3 to 6 having involved themselves in an offense punishable under section 494 of IPC, or felicitate or abated the said offense. In that view of the matter, I am of the considered opinion that in terms of section 494 of IPC, as is clear from the mere reading of the said provision, it is only the husband and wife who marries for the second time during the subsistence of an earlier marriage and the lifetime of the earlier spouse who can be prosecuted, and not the petitioners here.
Yes.
Then, my lord, the another judgment of this honorable court it is, my lord, on 198 of what I have read earlier, that also. So these are the judgments. My lord, my humble submission is that since the judgment of the coordinate bench is binding, and if at all this honorable court differs from that, it has to be, it's binding on the this court.
Show the
I have
proposition
the, I will place it. My lord, otherwise, my lord, it can be referred.
For the proposition of law,
Well,
then proceed with the argument.
Yes, my lord, I may be given a day time, my lord, I will place, I'll,
Tomorrow.
please. Much.
Fraudulent counsel for the petitioner, please tomorrow further.
Serial number 16, Basaraju P.
Morning, I completed my lord argument. The complainant herself, but in her statement categorical admitted that 3.5
Separately residing.
Please, ma'am.
Hmm.
3.5 years prior to filing the complaint, she is residing separate. Page number 35 ಅಲ್ಲಿ, I may be permitted to read. Further statement of the complainant.
ಆಯ್ತಲ್ಲ ಅದೆಲ್ಲ ಮಾಡಿದಿರಲ್ಲ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ ಒಂದು ನಿಮಿಷ ಪೇಜ್ ನಂಬರ್ 34 is the further statement.
Yes.
35 ಅಲ್ಲಿ next page ಅಲ್ಲಿ from bottom 15th line, my lord, because she went to the Mahilavani and filed the complaint. 15th line ಅಲ್ಲಿ from the bottom. ಹೀಗೆ 3.5 ವರ್ಷಗಳ ಹಿಂದೆ ನನ್ನ ಗಂಡನಾದ ಶ್ರೀಕಾಂತ್, ಅತ್ತೆಯಾದ ರಮಣಿ, ಮಾವನಾದ ಪೂರ್ಣಚಂದ್ರ ಅವರು ಸೇರಿಕೊಂಡು ನಿನ್ನ ತವರ ಮನೆಯಿಂದ ವರದಕ್ಷಿಣೆ ಹಣವನ್ನು ತೆಗೆದುಕೊಂಡು ಬಾ ಎಂದು ನನ್ನನ್ನು ನನ್ನ ಮಕ್ಕಳನ್ನು ಮನೆಯಿಂದ ಹೊರಗೆ ಹಾಕಿದರು. ನಂತರ ನಾನು ಜ್ಞಾನಪ್ಪನಹಳ್ಳಿಯಲ್ಲಿರುವ ಮಾನ್ಯ ಅರೇನಾ ಅಪಾರ್ಟ್ಮೆಂಟ್ ನಂಬರ್ 205ರಲ್ಲಿ ವಾಸ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. ನಮ್ಮ ತಾಯಿ ಮತ್ತು ಸಂಬಂಧಿಕರಲ್ಲಿ ಶ್ರೀಕಾಂತ್ ರವರ ಮನೆಗೆ ಹೋಗಿ ಸಂಸಾರವನ್ನು ನಡೆಸಿಕೊಂಡು ಹೋಗುವಂತೆ ಕೋರಿದರು ಕೂಡ ನಮ್ಮ ತಾಯಿ
That's as per the charge sheet allegation, my lord, she was subject to harassment, my lords. She was subject to mentally and physically harassment, my lords. To get the
Madam, you
additional
have to
dowry.
answer his, what he has argued, you have to answer.
Yes, sir.
You cannot go on saying that there is allegation, so FIR was registered, the investigation is undertaken. No. It is his specific contention, even according to the informant, about 3.5 years earlier to filing of the first information, she was residing separately. There is inordinate delay in lodging the first information, which was a ground for quashing the criminal proceedings by various courts, including the Honorable Apex Court. What is your answer?
My lords,
You should answer that query.
prior to that, my lords, there are many petitions she was filed before the honorable court by seeking the maintenance and the OS petition, my lords. Then also there was a subject to harassment, my lords. And she was to reply, my lords.
Petition. Respondent appear ಆಗಿದಾರ ಇಲ್ಲಲ್ಲ? Yes. That's all.
Please, my lords.
ತಗೊಳ್ಳಿ. Petitioners being accused number 1 to 3. In crime number 0022 of 2018. Which police station?
My lord, the Ulimau police.
Limau Police Station. Now pending in CC number 7837 of 2018 on the file of the learned 5th Additional Chief Metropolitan Magistrate, Bengaluru, for the offense under sections 498A of IPC and under section 3 and 4 of DP Act, are seeking to quash the criminal proceedings initiated against them. Brief facts of the case are that parties are referred to. The respondent number 2 filed the first information against accused numbers 1 to 3, alleging commission of the aforesaid offences. They stated that she had married accused number 1 on 11/4/1996 and started residing with accused number 1 to 3 in the matrimonial house. At the time of marriage, there was demand by the accused for payment of rupees 25 lakhs, out of which rupees 15 lakhs was paid as dowry. The accused were insisting for bringing additional dowry and used to harass her. Expert, it is alleged that accused number 1 was not doing any job nor earning anything, and he was addicted to bad vices. He was being instigated by accused number 2 and 3, being his parents, to ill-treat respondent number 2 and to demand additional dowry. Accordingly, accused number 1 used to abuse her in filthy language and used to ill-treat her. It is stated that the accused have forcibly thrown her out along with the children. and she was forced to shift to Bengaluru and residing separately in an apartment at Ulimau. It is stated that even after she started residing separately, the accused were torturing her for dowry. They have threatened her to cause her death on 16/1/2018. If in case she goes back to Davangere, where they are residing. Therefore, she requested the police to register the case and to initiate legal action. Accordingly, the police have registered the case, took up investigation. Charge sheet is not yet filed.
Page number 28, my lord, charge sheet was.
28.
Please.
After investigation, charge sheet came to be filed.
Page 28, my lord. Annexure D.
For the offences punishable under section 498A of IPC and 3 and 4 of DP Act. The petitioners being accused number 1 to 3 are before this court seeking to quash the criminal proceedings initiated against them. Or so and so. For consideration, my answer to the above point is in the affirmative for the following reasons. It is the specific contention of respondent number 2 that she married accused number 1 on 11/4/1996, and at the time of marriage, the accused have demanded for dowry and received rupees 15 lakh along with gold ornaments. It is pertinent to note that even according to respondent number 2, the accused have given 4 pairs of gold bangles, 3 sets of necklace, 4 finger rings, 8 pairs of gold ear stud, waist belt, and other gold ornaments valued about 10 lakhs at the time of marriage. The very fact that the petitioners have given such valuable gold ornaments valued at rupees 10 lakhs to the respondent number 2 at the time of marriage, for contention that they were demanding additional dowry, cannot be accepted. Moreover, admittedly, the marriage of respondent number 2 with accused number 1 was held on 11/4/1996. Even according to respondent number 2, respondent number 2 and petition number 2 and 3 were residing separately since 2008. At that time, respondent number 2 was residing with her husband, accused number 1, and her children. But the allegation is that accused number 2 and 3 used to visit her house very frequently, and they used to demand for additional dowry. This contention of the petition, respondent number 2, is also not substantiated by any material. Then a counsel for the petitioner has drawn my attention to Copy of the petition filed by respondent number 2 on 28/9/2015 in criminal miscellaneous number 175 of 2015, filed under the provisions of Domestic Violence Act. According to the said petition, the cause of action had arisen during June 2012. And it is specifically stated that respondent number 2 is residing separately with accused number 1 since 2008. My attention was also drawn to the further statement of the informant recorded by the investigating officer, where respondent number 2 specifically stated that she is residing separately with her children since about 10 years. She further makes it clear that about 3.5 years back, the accused have demanded additional dowry and ousted her from matrimonial house. Since then, she is residing separately with her children in an apartment. Therefore, even accepting the contention of respondent number 2, what she has stated in the first information as well as in the first further statement, accused number 2 and 3 were not residing with her at least since 2008. Accused number 1 was not residing with her at least since 3.5 years earlier to filing of the first information. But strangely, the first information came to be filed on 24/1/2018. That is about 3.5 years after the so-called demand for additional dowry and ousting her from the matrimonial house, upon which she started residing separately. Next paragraph. Counsel for the petitioner placed reliance on the decision of the apex court in Kamalesh Kalra versus so-and-so. Reportable on the other to contend that inordinate delay in lodging the complaint is fatal to the case of respondent number 2. The Honorable Apex Court, referring to the decision of the High Court, in S.K. Balla versus State of NCT of Delhi, noticed that the complaint came to be filed beyond the period of 3 years and held that there was no justification for the delay in filing the complaint beyond the period of limitation. It was also noticed by the High Court of Delhi that there was no allegation that physical and mental harassment continued against respondent number 2 during that period of 3 years, where she was residing separately. And therefore, the criminal complaint came to be quashed. Considering the facts and circumstances of the said case, the Honorable Apex Court held that there is no reason to interfere with the said order. And upheld the verdict of the High Court that the FIR filed by the complainant was time-barred, as it was beyond 3 years after the separation from the husband. In the present case, the undisputed facts, even according to respondent number 3, is that the demand for dowry, for additional dowry was about 3.5 years earlier to filing of the complaint. Admittedly, accused number 2 and 3 were residing separately at least since 2008. Under such circumstances, the allegations made against the petitioners that there was demand for a dowry during 1996 at the time of marriage. And even after separation, accused number 2 and 3 were instigating accused number 1 to bring additional dowry. And even after she was ousted by the matrimonial house about 3.5 years earlier to filing of the complaint, there was demand for dowry. Same cannot be accepted. So I am of the opinion that the criminal proceedings initiated against the petitioners is liable to be crushed. Accordingly, the answer is allowed subject to allowed.
Serial number 18, H.V. Ramchandra Rao.
Let's kindly have it tomorrow, my lords.
Happier for the petitioner counsel, my lord. I had sought for the time.
Counsel for petitioner prays for time. No stay order is in operation. The XCGP is not aware of the stage of the case before the trial court. Let's start. Next.
List 3, serial number 4.
Offense is for 420. The petitioner is accused number 10.
Accused number? Accused number?
10.
In all, how many accused?
That's 10. 10.
What about other accused?
That's A1, A5 are on anticipatory bail.
They were granted anticipatory bail.
They have been granted anticipatory.
Then?
They remained, to my knowledge, what I've just inquired, all the remainders are not free. The remaining accused are not in custody.
They are absconding.
No, one or two are absconding. One or two are absconding. That is what is available from the PPS report.
Yes.
The case is that
This anticipatory bail granted to accused number 1 and 5 by trial court or by this court?
the trial court.
Trial court.
Trial
Have you
court. After
produced the
dismissing
order?
the application once.
Have you produced the order?
Please, minutes.
Page number?
Minutes. The order dated 61, page 61.
Really?
It's at 63 minutes. And notice will find the order at 76. 76, running page 76. There is an order sheet. Within the order sheet, the operative portion is found. 76 minutes. The main order is found.
You are the goldsmith. Accused
Yes,
number
but I am the goldsmith and I used to be a jewel appraiser in a bank. And it's on my complaint, not the FIR. The bank officials were alerted. And not they lodged an FIR. And they have added only one sentence not in the complaint saying that even our bank appraiser was not able to, jewel appraiser was not able to find out this. This is exactly the, not an allegation, but I alert my bank officials saying that there is something fishy which is going on.
Who is the complainant? Who
But
is
the complainant is the bank manager, bank manager. He's a bank employee, that's not exactly a manager, he's a bank employee.
Whether manager has stated that you have alerted him?
Yeah, minutes, yes, the complaint is there. Complaint is. 24 minutes. Third line minutes. And jewel appraiser, Mr. Bharat Acharya, by using his regular testing method, jewel appraiser found low purity of gold. Further upon inquiry with the customer regarding so and so, so and so.
Huh?
Minutes. On 30/1/2024, existing customer by name Mrs. Sunita DM visited the branch with some gold ornaments to avail fresh gold loan against these gold ornaments. Upon verification by branch official and jewel appraiser, Mr. Bharat Acharya, working as panel jewel appraiser since 2018, by using his regular testing method, jewel appraiser found low purity of gold. Further, upon inquiry with the customer regarding source of this, she failed to provide any proper justification and left the
No, that was not the isolated incident. There was 27 gold loans.
correct minutes. So these people minutes, have come and minutes they used to pledge ornaments. Minutes the testing method what we were given minutes is we had to
You
take.
have certified all the other earlier gold ornaments.
No, not minutes. Not in all cases. Not in all cases. Minutes it is minutes a case where so many people. So there are more than 4 or 5 appraisers here. Minutes I have alerted the bank saying that.
No, in this case, you are the only goldsmith. Others are the pledgers. They are the
Others are
borrowers.
minutes. Others.
There are no other goldsmiths here.
From what I'm able to minutes, gather here, minutes, it is a case where 2018 I have been a panel evaluator. Minutes. I have been a panel evaluator. So,
No, if in
Please,
fact you have alerted the bank.
yes, minutes. In this
regarding
case, I
the-
have minutes.
Why you will be included as in one of the accused?
Kindly minutes. This is what the banker says. 24 minutes in the same, last but 4 line minutes.
Which is the paragraph we are referring to?
Minutes. This is in the same complaint, last but 4 lines. Keಳಗಡೆ end in the Swami. Alone seal ಇದೆ, city civil court. Even our jewel appraiser failed to identify purity of gold in these cases. Please take legal actions against them. This is the only
That means
allegation.
to say, you have not, you have certified it as gold ornaments.
Please, minutes. My job minutes was to verify whether these are gold or not.
Certified.
And minutes, I only minutes.
Price it.
I only appraise minutes. I cannot certify. I can only appraise. Minutes.
Price.
Now minutes in the standard course of testing which we are given minutes.
An artificial ornament is
It is not artificial. Minutes. It is not artificial.
Will happen.
Minutes. It is artificial agila. What has happened means I'll just let know. Minutes. In these are cases where minutes. The first 5-6 layers minutes in the jewel minutes is 24 karat gold. As we go deeper into it, minutes, we find that there are impurities in the gold. This is what minutes I have said. This is appearing to be a bigger issue. And minutes, because minutes, we are asked to file. We use a filer minutes. I'll just point out how the method works.
Maybe, sir, you
Yes.
will understand when you check the purity, you will know what is the purity of the gold.
Minutes.
Whether it is 24, whether it is 22, whether it is 18,
Minutes,
whether
if
it
it
is
is,
16.
I'll just point out. I'll just tell why minutes. I'll just tell. Your lordship is absolutely fine. Right. Minutes, there are 2 ways of testing gold. One minutes we keep it under a instrument of.
In whatever manner you know.
Yes. In the
The
traditional
goldsmith will
method,
be
minutes,
able to find
in the
out.
traditional method minutes where I'm just asked to file 2 layers and put a hydrochloric acid test or the nitric acid on that fire, I'll be able to give the result on the extent whether the files which we have taken out, the scraps which we have taken out, that is 24 karat or not. That, yes, minutes, your lordships are right. Only to that extent I can certify. Minutes, if I am asked to certify whether the entire ring is 24 karat or not, it will have to be kept under a sonic meter. Minutes. Sonic meter. This minutes ultimately, in all these cases, minutes, my role minutes is very limited. Very limited. Kindly see minutes.
Brought by the investigating officer.
Minutes.
Allegations are very serious.
Minutes. For me, minutes, kindly see.
90
The seriousness minutes is against the accused number 1 to 9. They are the ones minutes who have bought these ornaments. And I am the one who have alerted the bank.
No, alerted ellu illa, sir.
Minutes, I have
Say-
told my bank officials this is a case where Minutes, it is on my intimation, minutes, that this has come up.
Sir, there were 27 gold loans.
27 gold loans, minutes. In all these cases,
97.68 lakhs of rupees were obtained as loan.
correct, minutes, by accused number 1 to 9.
When the bank officials suspected,
Not bank officials.
then
Please, minutes, it is me, minutes. Jewel appraiser found low quality of gold. It is in the 4th line in the first paragraph. It is me, minutes, who found out that. Bharat Acharya, minutes. That is accused number 10.
for fresh loan.
Please, minutes. She went for
Already
fresh, upon
she has
verification.
already taken the loans.
She is an existing, pre-existing
Yes.
customer. Upon verification by bank official and jewel appraiser, that is me, Bharat Acharya, working as panel jeweler appraiser since 2018, December. By using his regular testing, jewel appraiser found low purity gold. I found that, minutes. Immediately, minutes, I have told. Yes, minutes.
Branch officials and jewel appraiser,
Please, minutes. That is me, Bharat Acharya, accused number 10.
they found low purity gold.
Yes, minutes.
Yes.
I am the only appraiser.
So this is the 28th instance.
This is the instance where we are able to find out there is a low
Earlier,
purity.
27 loans were already passed.
Correct, minutes. Minutes, and we don't
97.680.
even know what is the state of those affairs. Minutes, I found out in this that there is a impurity in this case. 27 minutes, I don't know what is the fate of them. What is, minutes, who are they? How do they come? What is the loan sanction? Minutes, my role, minutes, I sit in a bank cabin and give my opinion, minutes.
No, sir.
I give my bank, minutes, I am a professional, I just give my opinion there.
That is sufficient, sir,
Minutes,
to cheat the bank.
minutes, if there is, minutes, I am not, minutes, kindly at this point of time, minutes, I have been before the police, I have tendered statements also. It is not that I am trying to escape, minutes. I have been before the police, I have tendered my statements also.
Go before the investigating officer, not a
I've
case
been
for
there,
both
minutes,
the-
I've been there. If your lordships could just take that information, minutes, if your lordships could just take that information, whether I've been near the investigation officer or not.
Cannot get any information from the other side. That is the problem.
Minutes, may I just, then minutes, can your lordships hold it for day after tomorrow so that they can pass, minutes, is my statement recorded or not? Your lordships may ask that. I have tendered my statement. Minutes, I'm making that statement before your lordships. Minutes, after verifying that, minutes, the accused number 10 has, minutes, subjected to investigation before the IO.
Yes, what do you say?
These minutes, I have.
Well, let's, as per is tested, my lords, the bank has issued a loan against those who are pledged.
Facts I could understand.
Please, my
Now,
lords.
what is your stand?
My lords, due to his certification, my lords, the bank has given the loan, my lords. He has certified and he has made it as a gold, pure gold, and on the basis of his statement, my lords, the bank has.
Minutes, your lordships may ask them whether have I subjected myself to.
Why should I ask, sir?
Minutes, I have subjected
Why
myself.
should I ask?
Minutes, ultimately, your lordships may see this. Minutes, for one moment, have I subjected myself to investigate? Minutes, if, minutes, one moment, minutes, may I just convince for one moment. Your lordships may see what is my role here, minutes, for one moment. Now, minutes, kindly see, minutes, the order which is passed by the very same, minutes, the judge, minutes, the district judge who says, now, minutes, accused number 1 to 9, kindly see, minutes, they are on anticipatory bail. They are on anticipatory bail, minutes.
Maybe parity, no parity with you.
Minutes, they are on
No
anticipatory bail. Minutes, me, minutes, I am here before your lordship saying that, minutes, I am not even involved in the, minutes, I am just a person who, minutes, who is discharging his duties. If they find that, minutes, all 27 instances were by me, minutes, they can prosecute me. It is not even that case. It is not their case, minutes, that 27 instances were there by me. It is still at the case of investigation. I have subjected myself to investigation. Minutes, if I'm at risk of absconding, minutes, I would understand.
You rely on the order passed granting anticipatory bail to accused number 1. The court says, therefore, bank suspected about accused number 10,
Minutes,
who is officially appointed as goldsmith.
minutes,
The entire burden on you.
minutes, kindly see, minutes. Your lordships would be right in saying that there is a role of mine if prima facie it is looked into it.
You are appointed as a goldsmith.
No,
as
minutes,
the
I'm
appraiser. by the
appraiser,
bank.
minutes. I'm just an appraiser.
Yes.
I'm just an
And
appraiser.
you are a goldsmith. That is why you are the appraiser.
Correct, minutes. I am just a goldsmith and there are methods, minutes, in which I am allowed to test the jewels. I cannot exceed that. There are kits which are provided by the bank. It is their own kits.
Yes.
All I need to, minutes, scrape the gold and test it. Now, my lords, in the test, my lords, if it is right, my lords, it's a very simple test.
It's for the investigating officer. I will
Yes,
not
my lords, she has
investigate.
completed.
I will not
My lords,
investigate it.
your lordships may just call for this, but only one thing. My lords, if your lordships may just see to what extent the investigation is complete insofar as I am concerned. That is all, my lords. If they say they will really require custodial interrogation, then my lords, it's a different.
Do not require you for custodial interrogation. They will not get you.
My lords,
It is
but
not, it is not their pleasure to get you for custodial
absolutely, my lords,
interrogation.
absolutely. My only,
They will run a risk if they require you for custodial interrogation.
if they, my lords,
No.
because I have subjected myself, that is what I wanted my lordships to.
So just appear before the investigating officer. That's
All right, your lordship may put it like this, my lords. All right. My lords, this petition be kept pending. Your lordship, I'll appear before the IO, come back before your lordships.
Petitioner being accused number 10 is seeking grant of anticipatory bail.
May I request this, my lords, before the orders are passed for one moment. May I just say that I'll.
Sir, sorry. On the apprehension of being arrested. The manager of the chief manager of Canara Bank, Devnalli branch, lodged the first information against accused number 1 to 10, alleging commission of offence as stated above. It is the specific contention of the informant that the petitioner being the goldsmith was appointed as an appraiser for the bank. Accused number 1 to 9 have obtained as many as 27 gold loans by depositing the ornaments, which was appraised by the present petitioner as pure gold. However, when accused number 1 again approached for fresh gold loan, the branch official and the present petitioner found that the purity was low, purity of the gold was low. Therefore, it is suspected that all the accused in collusion with one another have cheated the bank by obtaining loan of rupees 97.68 lakhs by depositing which are of low purity. And such serious allegations are made against the petitioner and other accused. The contention of the learned counsel for the petitioner that the petitioner is the person who had assisted the bank official in unearthing the cheating committed by accused number 1 to 9 cannot be accepted. Looking to the nature and seriousness of the offense, I am of the opinion that the petitioner is not entitled for grant of anticipatory bail. Yes, dismissed.
Not may I only request to renew this request after, because not it's a case, I may be allowed to renew the
Sir,
request.
These type of cases, no mercies. Please appear before the investigating officer.
But I have appeared, Minutes. That is what I'm trying to say.
That is there ends the matter. Why you are having an apprehension?
Minutes, it's always an apprehension. Your lordship knows, Minutes, having such a criminal case, Minutes, I can be taken in at any point of time for some reason or the other. Though I have appeared, that is why.
Matter, serial number 2.
All right, I'm great.
Yeah, good. Direction CDR. You can note same model. ಇದರಲ್ಲಿ ತಗೊಳ್ಳಿ. Letter dated 27/7/2024 is received from the child court, that is a learned additional. Fourth additional district and sessions judge Kalburgi sitting at Sedang, seeking extension of time to dispose of the matter. It is noticed that accused number 2, the petitioner herein filed criminal petition number 200485 of 2023, seeking grant of bail The said petition was came to be dismissed with a order dated 21st November 2023. While dismissing the petition, a direction was issued to the trial court to dispose of the matter within 8 months from the date of order, with the cooperation of the prosecution as well as the accused. Was held that if the trial court fails to comply with the directions, the petitioner is at liberty to move similar petition before the trial court. Next, the trial court says that even though such an order was passed on 21/11/2023, the same was received by the court only on 10/1/2023. Therefore, seeking extension of time to dispose of the matter. Unfortunately, the letter does not explain as to the stage at which the matter is pending before the court. And it also does not state as to what is the time that is required. However, extension of period by 6 months is sought for. For the reasons stated in the application, 6 months' time is granted to dispose of the matter from the date of receipt of the same by the trial court. Petition. Petitioner accused number 2 is before this court seeking grant of bail. The materials on record discloses that this is the third successive petition filed by the petitioner seeking grant of bail. Third or fourth either. Petition Kodipa. ಅದು 2000260 of 2022. Dismissed on 22nd June 2022. Number 201446 of 2022. Disposed of on 15th December 2022. The criminal petition number 200485 of 2023. Disposed of on 21st November 2023. The ordinal haki. Third or fourth or the tenth. This is the fourth petition. All the 3 earlier petitions came to be dismissed on merits, recording the finding that the serious allegations were made against the petitioner for having committed the offense, which is punishable either with the death or imprisonment for life. Even according to the learned counsel for the petitioner, the trial in the matter has already begun. As per the request made by the trial court, the time fixed for disposal of the case is extended by another 6 months from the date of receipt of the order with the cooperation of so and so, so and so. Under such circumstances, I do not find any reason to entertain the petition once again, when admittedly the material witness, some of the material witnesses are not yet been examined. Dismissed.
Crime intention. ಮತ್ತೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ. ಇಲ್ಲಿ ಬರೀ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾತ್ರ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೋದು ಏನಂತ ಡಿಸ್ಮಿಸ್ ಅಂತ ಅಲ್ಲ ಮೇಡಮ್, ಬರೀ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾತ್ರ ಇರೋದು.
ಯಾಕೆಂದ್ರೆ ನಮ್ಗೆ ಆಪ್ಷನ್ ಇಲ್ಲ ಇಲ್ಲಿ.
ಅಯ್ಯನೂ ಇಲ್ಲ.
ಡೇಟ್ ಆಗಿಲ್ಲ ನೋಡೋಣ.
ಓಕೆ ಮ್ಯಾಮ್, ಸರಿ ಮೇಡಮ್.
ಇದೊಂದು ಅಪ್ಡೇಟ್ ಮಾಡಿರಲ್ಲ. ನನಗೆ ಡೌಟ್ ಇದೆ. ಈಗ ನನ್ನ ರೀಕಾಲ್ ಮಾಡಿ ಇನ್ಫೆಕ್ಷನ್ಸ್ ಇರೋದನ್ನ ಮಾಡಿಫಿಕೇಶನ್ ಮಾಡ್ತೀನಿ. ಅದೆಲ್ಲ ಎರಡು ನನ್ ಡೌಟ್ ಇದೆ. ಇದು ಪೆಂಡಿಂಗ್, ಅದೇನ್ ಹೇಳ್ತಾರೋ ಕೇಳ್ಬೇಕು.
ಅದನ್ನ ನಾನು ಪೆಂಡಿಂಗ್ ಇರ್ತೀನಿ. ಇರುವಂತ ಫೈಲ್ ಅದ್ ನಂಬರ್.
ಅಲ್ಲಿ ಯಾರು ಬಂದಿದ್ರು ಇನ್ಫೆಕ್ಷನ್ಸ್ ಅಂತ ಹೇಳಕ್ಕೆ?
ಅದೇನೋ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ಅದೇನೋ ಇದಾಗಿದೆಯಾ ಅಂತ ಇವ್ರು ಸ್ಟೇಟ್ ಅವ್ರು ಇದ್ರಲ್ಲ, ಅವ್ರೇನೋ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಅದಕ್ಕೆ ಅವ್ರು
ಅದು ಇದು
ನೈನ್ ಅಲ್ಲಿ ಹೇಳುದು.
ಅಲ್ಲ, ಈಗ ಎರಡರಲ್ಲಿ ಹೇಳಿದ್ದು ಇನ್ಫೆಕ್ಷನ್ಸ್ ಅಂತ
ಇದರಲ್ಲಿ ಇನ್ಫೆಕ್ಷನ್ಸ್ ಹೇಳಿಲ್ಲ, ಬರೀ ಡಿಸ್ಮಿಸ್ ಡೇಟ್ ಬಿಟ್ಬಿಟ್ರು. ಬಟ್ ಅಲ್ಲಿ ಏನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ಅದೇನೋ ಬರುತ್ತಲ್ಲ, ಅದೇನೋ ಡಿಸ್ಕಷನ್ ಆಗಿದೆ ಅಂತ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ ಅದೇನೋ ಇದಾಗಿದೆ ನಮ್ಗೆ. ಅದಕ್ಕೆ ಅದು ಡಿಸ್ಮಿಸ್ ಅಂತ ಹಾಕ್ಬಿಟ್ಟು ನಾನು ಇನ್ಫೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು. ಇನ್ಫೆಕ್ಷನ್ಸ್ ತರ ಹಾಕ್ತಾ ಇದೀನಿ ಅಂತ ಅಂದ್ರು ಅವರು ಡಿಕ್ಟೇಷನ್. ಯಾವ್ದು ಮೇಡಮ್? ಹೌದು ಮೇಡಮ್, 24/9 ಮಾಡಿಫಿಕೇಶನ್ ಲಾಸ್ಟ್
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 serial
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ಒನ್ ಮಾಡಿಫೈಡ್ ಬಿಸ್ನೆಸ್ ಇದರಲ್ಲಿ ಡಿಸ್ಪೋಸ್.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 serial number 20 ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು. 20
1410 ಸರ್.
ಮಚ್
ಪಿಟಿಷನ್ 4315. ಅದೇ ಅಷ್ಟೇ, ಏನು ಡಿಸ್ಮಿಸ್ ನಂಬರ್ ಸ್ಟಾರ್ಟಿಂಗ್ ಬರೀ ಡಿಸ್ಮಿಸ್ ಅಷ್ಟೇ.
ಇಲ್ಲಿ ಯಾರು ಮುಂದೆ ಬೇಡ
ಏನು ಕೂಡ ಏನು ಇದು ಅಲ್ಲಿ ಈ ಕಡೆ ಎಷ್ಟೊಂದು ಬೇಕಾದ್ರೆ ಮಕ್ಕಳು ಓದದೇ ಇಲ್ವಾ ನೀವು?
ಲಿಸ್ಟ್ ನಂಬರ್ 1 serial number 12
ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್ ಅಲ್ವಾ ಅದು ಹೇಳಿದ್ದು? ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ಸರ್ವಿಸ್ ಅಷ್ಟೇ.
ಅಲ್ಲಿ ಏನೋ ಸಣ್ಣ ಡೇಟ್ ಹೇಳ್ಕೊಂಡ್ರೆ ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ.
ಅದಕ್ಕೆ ನಾನು ನಿಮಗೆ ಚೀಟಿ ಬರ್ಕೊಟ್ಬಿಟ್ಟೆ.
ಸರ್ವಿಸ್ ಆಫ್ ನೋಟಿಸ್
ಅಷ್ಟೇ ಅರ್ಜನ್ ಆಗ್ತದೆ
ನನಗೆ. ಒಂದೊಂದು ಅಲ್ಲಿ ಕೋರ್ಟಲ್ಲಿ ಹಾಗಲ್ವಾ ಡೇಟ್ ಆಮೇಲೆ ಕೊಡೋದು, ಅದಕ್ಕೆ ನಮ್ಗೆ
ನಮ್ ಡೇಟ್ ಕೊಡಕ್ಕೂ ಏನ್ ಕೊಟ್ರಿ ಏನಂತ
serial number 19 ಲಿಸ್ಟ್ ನಂಬರ್ 2 19
ಬಂದು 30 30
ನಾ 18 ಬಂದು 30
ಅದು 30 ಗೆ
14 ಮಾಡಿದ್ದೀನಿ. ಅದೊಂದು ರಿಪೋರ್ಟೆಡ್ ಜಡ್ಜ್ಮೆಂಟ್ ಬಂದಿದೆ ನೋಡಿ, ಬರ್ತದ ಇವತ್ತು ಡಿಸ್ಪೋಸಲ್
ಮಾಡ್ತೀನಿ. ನೋಡಿಲ್ಲ ಲೈವ್ ಅಲ್ಲಿ ನಾವು ಇಷ್ಟು ಮಾತಾಡ್ತಾ ನಿಮಿಷ